Good morning, everyone. Great turnout. Thank you so much for being here. My name is Paul Rose. I'm the Dean of Case Western Reserve University School of Law. It is our pleasure to welcome you to the 8th District Court of Appeals Advanced Appellate Advocacy Seminar. We are delighted to host this seminar again. This is our third year in a row in collaboration with the 8th District Court of Appeals. This annual event is offered at no charge for both in-person and virtual attendees, and it reflects our shared commitment to advancing the art of appellate advocacy. This seminar is a perfect complement to work that we do here in our curriculum at the School of Law. At Case Western, students are immersed in appellate litigation through courses like LEAP 3, which is our sort of third in our research and writing courses, where those students found advocacy skills in preparation for the Dean Dunmore Moot Court competition that we hold each spring. Our students, of course, also represent Case Western on the national stage, competing in prestigious moot court tournaments across the country. I was a transactional attorney in practice, but I was asked to be a moot court coach once upon a time. So this is definitely one of those things where those who can't do teach, because I never really was very good at it, but I did have success as a coach, and I really grew to appreciate how much work goes into doing it well. So I'm really grateful that our students are doing so well representing us on national stages. The Appellate Litigation Clinic really serves as the capstone of the training that we provide here. It gives students hands-on experience as advocates. In the clinic, our students argue cases in appellate courts throughout Ohio and the 6th Circuit, including right here in the 8th District Court of Appeals. This semester alone, our clinic has participated in 4 appellate arguments, is managing 12 active appeals, and is awaiting decisions from the Supreme Court of Ohio on whether to accept 3 cases for review. Today's seminar agenda offers a wealth of opportunities to deepen your understanding of appellate advocacy and appellate practice. It begins with insights into effective appellate brief writing and oral advocacy led by experienced practitioners and judges. A panel discussion will follow on navigating key procedural rules and ethics in appellate practice, essential for both new and seasoned advocates. The seminar concludes with a thought-provoking session on emerging issues in appellate law with perspectives from members of the 8th District Bench and Bar. None of this would be possible, of course, without the cooperation and generosity of the 8th District Court of Appeals, the many judges, attorneys, and alumni who support our programs, and of course all of you in this room. Your willingness to volunteer as moot court judges, coaches, mentors has been invaluable in preparing our students to excel as future appellate advocates. And of course, if you'd like to join our community of supporters, you can scan the QR code that's just outside by the coffee or at the registration table to be added to our judges list. So thank you again for joining us today and for your continued partnership. We look forward to a day of engaging discussions and valuable learning. It's now my pleasure to introduce Administrative Judge Kathleen Ann Keogh of the 8th District Court of Appeals.
Good morning, everyone. Thanks for coming. I want to just, on behalf of our court, thank all of you for your participation. It's nice to see some faces that we never get to see, because sometimes in the Court of Appeals, you're kind of cloistered and you don't get to see people. And I want to thank our staff for their hard work and preparation, in particular the Education Committee and all the presenters, and Case Western Reserve for making this possible. We really appreciate it. It's a great seminar. I don't know if it's your first time. It's really fantastic and great participation. And with that, I'd just like to introduce Judge Mary Jane Boyle, who is the chair of this seminar. Thank you.
Thank you, Judge. Welcome back. Third year, and it's growing. I'm excited about this year's program, and I'm just so thankful for the members of my court and the members of Case and the lawyers that have stepped up to participate and present advanced appellate seminar. I think last year I was mentioning to you, I really like to grow the appellate lawyers, community. We seem to me, to be overlooked a lot. We provide this program because a few years ago, well, maybe a decade now, I don't know, they came up, the Ohio State Bar Association in the state of Ohio offers appellate specialization certificates, and you need advanced appellate CLEs. Also, to be on appellate assignment lists, to do criminal appellate assignments, you also need a lot of appellate CLEs. And when we heard from the lawyers that there wasn't enough advanced appellate CLEs being given opportunities for you all, our judicial attorneys came to us and said, we need to do this for the community. And so that's why we bring this program to you today. Our first group I'd like to introduce is the program is entitled Missed Persuasive Opportunities. And you're going to hear from Tony Farkas, Dave Parcham, who are staff attorneys at the 8th District Court of Appeals. And then you're going to hear from Melissa Greist, an adjunct professor at case law, who used to also work at the 8th District Court of Appeals. So they regularly review the transcripts, the evidence, the records, participate with helping the judges put on their decision making, their opinions, and so they wanted to bring to you what they see from behind the scenes on some of the persuasive opportunities as appellate practitioners that you may be missing. Instead of going through all their bios, you may come on up, you guys. Instead of going through all their bios, you can read it in the electronic format the materials are included in. And we're going to move rapidly from group to group. So I hope you enjoy this program and you learn lots. With that, Tony, Dave, and Melissa. There's some in the back and the front. Thank you.
Good morning. I'm Tony Farkas, and as Judge Boyle said, I'm here with Melissa Greist and Dave Parcham, and we're hoping to provide some suggestions on ways to make the most of your persuasive opportunities in appellate briefs, oral argument, and throughout the appellate process in the Court of Appeals. In preparing for the presentation here today, I sort of canvassed our court a little bit and asked for views on what can detract from the effectiveness of an appellate brief or oral argument, or that can just make the appellate process a little more difficult. And so I'm going to try and incorporate some of that feedback here today. In my part of the presentation, I'm going to try and focus on how persuasiveness can be impacted by practical considerations in the way the court operates and the requirements of the appellate and local rules. Melissa, a professor in appellate practice, will provide tips regarding legal writing techniques to maximize the persuasiveness of your written arguments. And then Dave, who's been with the court for almost 34 years. 34 years. And who's probably seen it all, will probably do a little bit of both. First, we're going to start with appellate briefs. As I'm sure you all know, under the Ohio appellate rules, briefs filed in the Court of Appeals must have 8 components: the table of contents, the table of the cases, a statement of the assignments of error, a statement of the issue presented for review, a statement of the case, a statement of facts, and an argument containing an argument and then a conclusion. I'm not going to go through all of that in detail, but one thing I learned fairly quickly on when working for the 8th District is that different judges take different approaches to reviewing an appeal, particularly with regard to what they review first. Some judges review the assignments of error first, some review the statements of issues, some review the table of contents, some review the order or judgment appealed from, and some review the reply brief. Because you don't know what the judges assigned to your case are going to do, you really want to make the most of each of the elements of your appellate brief. Today we're really going to focus on the heart of the appellate brief in our discussions today. And I'm going to begin with the statement of the assignments of error presented for review. What I consider to be the third most important part of your appeal. In prior CLE seminars that we've covered here with the 8th District, we've covered what is, in my view, the first and second most important parts of your appeal. One, a timely filed notice of appeal, and two, the record on appeal. If you don't have those two items, or you don't have what you need for those two items in your appeal, persuasiveness really doesn't matter. So why do I call the assignments of error the third most important part of your appeal? It has to do with Appellate Rule 12A1. Appellate Rule 12A1 tells the Court of Appeals what it must do in an appeal. On an undismissed appeal, the Court of Appeals shall review, affirm, modify, or reverse the judgment or final order appealed, determine the appeal on its merits, on the assignments of error, the record, and the oral argument if there is one. And then 3, unless an assignment of error is made moot by a ruling on another assignment of error, decide each assignment of error and give reasons for its decision in writing. So when getting relief from the Court of Appeals, it's really all about the assignments of error. The Court of Appeals is required to decide and issue a written ruling on each assignment of error that's raised and briefed. It's not required to address or resolve every argument or issue raised in an appellate brief. I'm sorry, some of these are a little small, but I believe you'll get our PowerPoint slides, so you could be able to see some of the sites or whatever that's in here that might be a little small here. You should be able to get them in a written format. So what's an assignment of error? Common definitions are a concise statement of the question to be reviewed, a short description of a mistake alleged to have been made by the trial court. Assignments of error should designate specific rulings that the appellate challenges on appeal. These are different definitions that have been provided. It's important to note that assignments of error are not propositions of law, like you might see in a memorandum in support of jurisdiction with the Ohio Supreme Court. They're not a statement of a rule of law that the party argues should be applied to the facts. They really are a statement identifying a mistake allegedly made by the trial court. There are 2 types of assignments of error. One, general assignments of error, and issue-specific assignments of error. A general assignment of error is a broad statement of a mistake made by the lower court without providing specific details about the error. An issue, something like that might be, for example, a general assignment of error might be the trial court erred in granting the appellee's motion for summary judgment. An issue-specific assignment of error identifies the exact problem with the trial court's decision. Maybe along the same lines, something like the trial court erred in granting appellee's motion for summary judgment because there were genuine issues of material facts with regard to whether appellee breached the contract with appellant. You really want to make sure and review the local rules. Some local rules have specific rules regarding assignments of error and may require specific assignments of error as opposed to general assignments of error. One thing I've learned is that sometimes there are local rules about things you wouldn't expect to be local rules about. So reviewing the local rules at the beginning of your brief writing process or your appeal process and the end of your brief writing process or oral argument is an important consideration. Here I cited the 3rd District's local rule that says assignments of error to the degree reasonably possible should not be general in terms but should be specifically applied to the error claimed. So it's just a word of caution. Look at the local rules. Assignments of error really set the parameters of what the Court of Appeals decides on appeal. So how you frame your assignment of error matters. There's a risk of being too specific or not sufficiently comprehensive with your assignment of error. Where an issue is raised in an appellate brief exceeds the parameters of an assignment of error, the appellate court may refuse to consider it. For example, I cite this Bradley case. In that case, the assignment of error was that the trial court had waited 37 days to issue findings of fact and conclusions of law after trial. The party in the brief made an argument that it was prejudiced because it was not served with the proposed findings of fact and conclusions of law, and the court said, well, that's outside the scope of your assignment of error. In another case, I didn't cite here, but it's State versus Zanny. A separation of powers argument was raised sort of as a sub-argument under an assignment of error that involved due process and the confrontation clause. And again, the court said, that was outside the scope of the assignment of error. There should have been a separate assignment of error with regard to that. There's also a risk of being too general or imprecise with your assignment of errors. You really do have to make sure that your assignment of error identifies the particular action or determination by the trial court that you're claiming was a mistake. There's no catch-all, so you can't say something like, the trial court's judgment was contrary to law. There may be some strategy involved in framing your assignments of error, sort of harkening back to the notion that the appellate court is required to resolve assignments of error and not arguments or issues. So if you want to increase the likelihood that the Court of Appeals actually decides a particular issue that you are interested in, you might think about that in framing your assignment of error. But otherwise, unless issue-specific assignments of errors are required under the local rules, you can use general assignments of error and then use the statement of issues presented to really sort of flesh out what the errors are. And Dave's going to talk a little bit more about that in a few minutes. The bottom line with all this is really think about what you're doing with your assignments of error. I think a lot of times people just sort of, slap them down to comply with the rules, but they can be very, very important in your appeal. So now I'm going to talk about sort of the technical side of assignments of errors. To comply with the appellate rules and be considered by the Court of Appeals, each assignment of error must be raised and argued in the opening brief. You might think that this is sort of, common sense, but you'd be surprised. You can't incorporate by reference arguments made in other briefs that were filed below. It's not uncommon for us to get briefs in which somebody says, I hereby incorporate the reference by reference the arguments I made on page 18 of this opposition, for summary judgment I filed in the trial court. We get that, not infrequently, and you can't do that. That doesn't comply with Appellate Rule 16. Arguments and footnotes generally aren't enough. The argument should be in the main body of the brief. And unless leave's granted, you can't raise new assignments of error in your reply, and you can't raise new assignments of error in oral argument. Each assignment of error must also be argued separately. Although the Court of Appeals has the option to address 2 or more assignments of error at once, the parties do not. And you can't simply incorporate by reference arguments made in support of one assignment of error and ask that it be applied to another assignment of error. Sometimes we see that in cases where sufficiency and manifest weight of the evidence arguments are made. Sometimes we'll have a party that will say, for the same reasons I asserted that the evidence was insufficient, it was against the manifest weight of the evidence. And really you need to have separate arguments for each assignment of error for that. Not to mention that they have different standard of review, so it might be the reason why you would also want to have a different argument. Assignments of error must also be accompanied by citations to the record, be supported by legal authority, and be supported by contentions and reasons. Arguments be supported by argument with contentions and reasons. You have to have a meaningful analysis. Blanket or conclusory statements are insufficient, and the court's not going to make arguments for you. Failing to comply with any one of these requirements is grounds for the Court of Appeals to disregard your assignment of error without addressing the merits. And the source of what allows the court to do that is Appellate Rule 12A2. And courts do this regularly. In the Court of Appeals, if something is not argued separately, if it is not supported by sufficient argument, it's a reason oftentimes courts will disregard an assignment of error. Or they might say, even if we were to consider this assignment of error, and go from there. But courts will sometimes, in the interest of justice, consider improperly argued assignments of error. If you don't want to count on that. I'm now going to turn it over to Dave, who's going to discuss persuasive opportunities in connection with your statement of the issues presented for review.
As a staff attorney with the 8th District Court of Appeals for over 34 years, one of our primary responsibilities is to review the briefs coming before the court to ensure their compliance with the rules, specifically Appellate Rule 16, which specifies the various components of a brief. One of those components is the statement of issues presented. And generally speaking, all too often, the attorneys and pro se litigants take their assignment of error, turn it into a question, and leave it at that. The assignment of error is the court erred in granting summary judgment. This issue presented, did the trial court err in granting the motion for summary judgment? And this is done with mind-numbing regularity. In this, you are missing a persuasive opportunity to convince the court. If you can frame this case through the issue presented the way you think this case should go, you take a big step toward winning your case. Now, there are various ways of doing this. I like the quick punch to the gut and, quick, concise statement of the issue presented. Like breach of contract case. You say, this case is a case about waiver. Or this case is a case about the statute of limitations. E.g., the guy says, he's agreed to sell me his autograph book, and I gave him the money for it, he never gave it to me. The reply is, this case is about the statute of limitations. That transaction happened 16 years ago. It's beyond the statute of limitations. That's how you can frame your case. Now, hopefully, you'll be able to maybe invoke some great principles of justice and law in trying to do this. A good example is the case of State Department against Munez from the U.S. Supreme Court case. In this case, Marcy Munez married Louis, who is a citizen of El Salvador. They wanted to live in the United States. However, United States law requires a person, a foreign national, to go back to their home country and apply for the visa there. Louis goes back. Louis is denied his visa because there was evidence he was engaged in illegal activity. So his wife, Marcy, starts the appeal, goes up to the U.S. Supreme Court, and she and Justice Sotomayor said this case is about the right to marriage and the right to live where you want, and thereby invoking the transcending principles of marriage and personal liberty. In the decisive opinion, Judge Barrett says, no, that's not what this case is about. This case is whether the judiciary has any authority to review visa determinations made by the State Department. That's what this case is about, and she thereby invokes the constitutional principles of separation of powers. Now, that's not the only way you can do this. There's another way of doing that. Let's see if I can bring it up. But I call this what's often called the syllogism. Now, in certain districts, this is required. I believe it's required in the 3rd District and the 9th District. And in this one, you state a principle of law. You have a couple of minor premises dealing with the issues of facts in the case, and then you have your conclusion, a question, like a yes or no question, stating the issue of the case. And the classic example everybody gives is the premise is the excited utterance exception allows a declarant statement to be admitted if it is made under the stress of a startling event. In this case, the Vince victim calls the 911. Policeman shows up 30 minutes later, and Vince tells him, Don hit me with a baseball bat. And the issue then becomes, is this an excited utterance so that the policeman's declaration is admissible hearsay? That's the issue. Let's take a couple of more cases. That's a case involving burglary. The elements for burglary is trespass into an occupied structure by force, stealth, or deception to commit a felony. One of the cases before the court, so that would be your premise. The elements of burglary. The specific minor premise is the testimony of the victim. Vince comes up and he says, I was carrying my groceries into the building, and these 3 guys came out and with guns and robbed me. The issue is that sufficient evidence to prove by reasonable doubt that there was trespass into an occupied structure to complete the elements of burglary. Or another one involving burglary. Trespass would be by force. Trespass, you can have consent to enter a building, and that's privilege to enter the occupied structure, but that can be revoked, and it can be terminated by a violent act. In a very recent case before the court, Vince owed his drug dealer $1,500. He didn't have the money to pay for it. And consequently, both the drug dealer and Vince went back to Vince's apartment with the full knowledge that the drug dealer was going to beat him up because he can't pay. The issue then is, does the full consent to this violent act constitute, full privilege, nullifying the element of trespass? That's how you could frame these issues. Once again, you're missing an opportunity to frame the case if you just turn your questions around. I will finally leave you with the all-important case of North Coast Cookies against Sweet Temptations, Inc., very memorable case name, in which the 8th District Court gives the best common law definitions of an assignment of error and issues presented. Thank you.
Okay, so you've framed your assignments of error, you have your persuasive issue statements. It's time to turn now to the argument section of your brief. So I'm going to touch on 4 opportunities for you to be persuasive in your argument section. Incorporate the standard of review, use argumentative point headings, exploit positions of emphasis, and avoid over-advocating. Okay, standard of review. So Mr. Regas later this morning is going to do a deep dive on appellate standards of review in Ohio. I'm not going to talk substantively about them to step on that presentation, but I propose that you do not need a separate heading and boilerplate section about the standard of review unless local rules require it. If your standard of review is not in dispute, instead of taking half a page to tell the appellate court that summary judgment motions are reviewed de novo, right? Use a sentence or 2, cite a case, and use the rest of the space that you would have spent doing that more effectively. Once you have your standard of review, you state it, you then want to take the next step and actually incorporate it into your argument. So following along with the summary judgment example, with a summary judgment, it's reviewed de novo. The appellate court gives no discretion to the trial court's reasoning. So in addition to including in your brief, why the trial court's reasoning was incorrect or correct, you also need to establish why you win, right? If we're talking about a negligence case and maybe the trial court found there was no duty of care, and so there was no need to address the other issues. With the de novo review, yes, you have to talk about the duty of care, but then you also need to show why you win, or the other side doesn't, all right, on the other elements, right? Breach, causation, damages. So incorporating the standard of review into the structure of your actual argument is really important. One way to then communicate that in your brief is to incorporate the standard of review language into your point headings, which brings me to strategy number 2. What are argumentative point headings? Not surprisingly, they are argumentative sentences that make a point, right? You want to accomplish a couple different things with these point headings, and it helps to think about 3 different categories of people. So you want to think about your reader, right? This is someone, a judge or judicial attorney, who is going to pick up your brief for the first time, read it cover to cover really closely, right? You want them to be persuaded from the very first page, whether they start at the table of contents or whatever part of the brief. And so what's the first page or maybe second page of your document once you get past the cover sheet? It's your table of contents, right? And your table of contents is comprised of your argument headings, right? The headings that you use throughout your argument section feed into the table of contents. So use those headings and that space right on the first page of your brief to concisely say what your best arguments are and how they relate to each other. As a more practical matter in your argument section, including these subheadings and argumentative point headings helps break your argument into chunks that are easier for the reader to digest. Everyone reading these briefs are also reading a lot of other briefs, right? And just generally reading, and it's tiring and it's hard to get through all of those briefs. So the easier you can make it for the reader, the more persuasive your words are actually going to be. Second, you want to think of someone using your brief, right? This could be the same reader maybe a couple of days later, right? The judge, judicial attorney is remembered you made a point about something, but where is it? I need to find it. Craft your argument headings so that it's easy for someone using your brief to find what it is that you're arguing. And then lastly, think about yourself as the writer. Taking some time to draft these argumentative point headings helps you really grapple with what your arguments are and how to succinctly state them and organize your points. So at a basic level, to make argumentative point headings, you should be using complete sentences. Okay, that's easy enough. The trickier part comes in to figuring out how to balance including enough specificity to make the headings concrete without making them so long that the reader and the user are just going to skip them and not read them all together, right? So your heading is too long if it goes more than 2 or 3 lines. If you use all caps for this, right, no one's going to read that 2 or 3 lines, so consider not using all caps. But on the flip side, your headings are too vague. If you could take the same heading from another brief and copy paste it into a brief for a different case, okay, right, that's not specific to your case. Or if your opponent could take that heading and put it in their brief, right, then it's not persuasive enough to your side of the argument. So if you're not sure how to go about crafting these, you can start with this default formula. So start with a conclusion that you want the court to accept or an action that you want the court to take, and then include the reason why the court should accept that conclusion or take that action. If you have just one reason, you can do that in one single heading, right? You don't necessarily need any subsections. But if you have a lot of different reasons why the court should accept that conclusion or take that action, you can include the why as separately as subheadings underneath the broader heading. So for example, the writer here has 3 reasons to support their argument about why the court should hold a specific thing about this Fourth Amendment exception. Rather than trying to put all 3 of these reasons into one long heading that would be, 5 or 6 lines that no one's going to read, they break that up into 3. Each reason why is its own subheading that more clearly communicates what the reader is trying to say. It also has the added benefit then in your argument section of breaking up these reasons why into easily digestible chunks. One of the reasons why you want to break up your argument into easily digestible chunks, other than the fact that it is easily digestible for the reader, is to exploit positions of emphasis in the brief. So this is strategy number 3. The general principle here is that readers pay more attention and remember things better when they come at the beginning or the end of a mental or physical break. So strategically, you want to craft your argument section to create more beginnings and more endings. So one of the ways to do this is to use these argumentative point headings. The heading itself is a point of emphasis, right? It stands alone on a page. It's usually bold, right? You can't get a better point of emphasis than that. And then you can also create more positions of emphasis under a subheading by breaking up paragraphs, right? You're creating more beginnings of paragraphs and endings of paragraphs. You also can use a short 1 or 2 sentence paragraph, right? I know that might startle some of you. You can have a 1 sentence paragraph, right? Maybe when you are learning general rules of English, right? The paragraphs have to be 4 or 5 sentences long. Well, now we're in an advanced appellate seminar, right? You can do it, a couple times, right? Don't overdo it. That might just get annoying, but that can be a way to really create points of emphasis and more beginnings and afters, right, on either end of it. So once you have your positions of emphasis, you want to put your best points in those positions. So, at a global level, put your strongest issues first, or your strongest, within each issue, put your strongest arguments first. Unless, of course, you have a threshold issue like jurisdiction or standing. Of course, then you maybe want to flip that around. Like, for example, the problem we're working on in class right now has a jurisdictional issue. And our students briefs are due today, and we've been talking a lot about, okay, do I put that issue first because it's threshold, or do I move it second because maybe the merits argument is stronger, right? So if you have something like that, of course, disregard what I'm saying. But within each issue, then, use your paragraphs to really emphasize the points you want to make. So short, specific topic sentences to take advantage of that position of emphasis at the beginning of a paragraph. In your topic sentence, state your conclusion as if it were the truth, right? Don't waste that precious space at the beginning of a section by saying, the next issue is, right? Or the appellant argues, right? Just say what the issue is, right? Get rid of that space and really exploit that position in that prime spot in your brief. And, oh, yes, sorry, there was an animation there I forgot about. Don't do that, right? Okay, finally, the last strategy, avoid over-advocating. Don't attack opposing counsel, right? This can be really tempting, especially when they're just wrong, right? So, you're gonna see sentences like this a lot. Maybe not a lot, hopefully not a lot, especially after today, right? But in his opening brief, Jones lied by saying his appeal was untimely, or appellant is trying to distract the court, or strategically misrepresents this case, right? Now that might be true, but you don't want to be the one to put your credibility on the line to make that assertion. So instead you want to rephrase the wording a little bit to get rid of explicitly attacking the other side, and implying what their intent is. So, I don't know, do we have maybe a minute? Does anyone want to guess or propose how you would maybe rephrase that first one about the Jones lied by saying his appeal was untimely?
How about just saying, despite the appellant's protestations, this appeal is untimely?
Perfect. We don't talk at all about whether he was doing that strategically or not. Okay, for the sake of time, I won't go through the other ones. Okay, another way to avoid over-advocating, right? Don't lie to the court. I think we got a question about that the last time the 8th District was here was a pet peeve, or just one of the judges was saying, well, you're just misrepresenting the record, right? Or what a case says. It's hard to lose your credibility faster than that. So stick with what you can support in the record. And then more at the sentence level, watch out for adjectives and adverbs. That's usually a sign that you're kind of slipping into over-advocating, making generalizations that are not, or conclusions that are not persuasive. So instead, you want to use words that signal you're giving more concrete, specific information. So, if you have to say, clearly this is the right way to go, if you have to say it's clear, it's not clear, right? Use stronger nouns, use stronger verbs, use more specific language, right? Instead, look for words that you can add into your sentence, like precisely or specifically, and then add those details to show what specifically or precisely it is you're talking about.
I would just remind everybody what Stephen King said on writing, the adverb is not your friend.
Yes. And then finally, with the over-advocating, keep your reputation in mind, right? While maybe over-advocating at a specific level, attacking opposing counsel, lying about a case, sure, it'll hurt your credibility in that particular argument. but Cleveland's a small legal community, right? If you get in the habit of doing this, this will build your reputation of becoming maybe untrustworthy or not a good advocate, and I don't think there is a more efficient way to miss all of your persuasive opportunities for all of your cases. I'm going to turn it back over now to Tony.
Technical requirements. I'm not going to spend a lot of time on this, but I would be remiss if I didn't at least mention the fact that complying with the technical requirements are really an important part of the brief when you file with Court of Appeals. They're set forth in Appellate Rule 19 and the local rules. In particular, take care to avoid including unauthorized personal and private information in your appellate brief. That's an issue we see come up a lot, the names of minors, victims of sexual assaults, and there's some other personal and private information that's specified in the local rule. Technical requirements really do matter. If your brief doesn't comply with all requirements, your brief could be stricken, your appeal could be dismissed, or you could receive a non-compliance order. If your brief does contain the names of minors or victims of sexual assault in violation of the local rules, it will be stricken, but you'll usually be given an opportunity to file an amended brief that complies with the rule. If your brief substantially complies with the technical requirements of the rules, but it's non-compliant in one or two minor respects, the footnote type's too small, the margins are too narrow, but you're not doing it in a way to evade the page limitations, you may be issued a non-compliance order, something like this one. You may not realize this, but the 8th District actually tracks the issuance of these non-compliance orders. So if an attorney is repeatedly non-compliant, despite prior warnings, it may increase the likelihood that a more severe sanction will be imposed for future non-compliance. So nothing's more of a mispersuasive opportunity than having your brief stricken or your appeal dismissed. So you just want to be careful about that.
If I may interject, the court is really trying to protect the children, and if there is a minor in any way associated with your case, please make sure there is no way this minor is identified, even if you use initials for the minor, but then use the minor's last name later in the brief so that you can put together this child, is F-fungible. The court will strike that because that effectively identifies a minor. We're really trying to protect the kids.
Before discussing oral argument, I sort of want to take a little detour and raise an area you might not think about when considering persuasive opportunities in connection with an appeal. Mediation. As you may know, the 8th District has a really robust, successful mediation program. Nothing that's said in mediation ever makes its way to a panel, but preparing for the mediation, preparing a mediation statement, and participating in mediation may help you focus on what the real determinant issues are in your appeal and where the strengths and weaknesses lie. There's always value in determining your own fate. Successful mediation can avoid the need for taking advantage of some of the other persuasive opportunities we've mentioned up here. And you can request mediation at any stage in the process. So I just wanted to give a shout out to Newton, who's in the back, who is our court mediator, and encourage you to take advantage of that mediation opportunity. Now turning to oral argument. One of the greatest persuasive opportunities can be effective use of oral argument. Whenever I attend an appellate judges panel, the question is almost always asked of the judges, how frequently has oral argument changed your mind in a case? In my opinion, that's a very narrow view of the value of oral argument. Personally, if you have something that's worth saying, and if your client's willing to pay for it, for you to participate in oral argument, I would never waive oral argument. Oral argument can provide an opportunity to address potential issues with the record that you may not have realized have come up during the course of an appeal. It can allow you to reframe the issue in a different way than was presented in the brief. You can answer questions from the court. You can address issues that the court deems significant that may not have been addressed in the parties' briefs. It really just gives you an opportunity to sort of seal things up in connection with the appeal. If you didn't file the last brief, it's the only opportunity you have to respond to that brief. And clarification of issues during oral argument can lead to better opinions down the road. It's also not just an opportunity for you to persuade the panel, but maybe an opportunity for one judge on the panel to persuade another judge on the panel based on the questions asked by the judges. Pulling back the curtain a little bit, with regard to how things work in the 8th District, as you may know, in the 8th District, 3-judge panel is assigned, with 1 judge assigned as the writing judge, approximately 6 weeks before oral argument is scheduled. If no oral argument is scheduled or requested, then a date will be assigned when the case is ready for consideration, which is usually the date the oral argument would have been scheduled had it been requested. Everybody gets a notice when that happens. I'm sure you've seen those notices. In the 8th District, memoranda or draft opinions are not generally circulated among the panel members before oral argument. The judges do not generally conference about a case before oral argument. They usually conference about cases after oral arguments are completed for that day. So if an oral argument is held, what's said during that oral argument will really be fresh in the judge's mind when they conference about a case. It may be the last thing that the judges actually think about the case before conferencing. So that's really something to think about when you're deciding whether to waive oral argument. Just as a reminder, you now have to request oral argument. If you request it and decide you don't want it, file a motion to waive it. If you are an appellee and don't file an appellate brief, you will generally not be permitted to participate in oral argument. Almost universally, the judges dislike motions for continuance of oral argument. The judges have busy schedules. The panels change from week to week, so it may be a while before the panel members sit together. There's limited courtroom space. If you think you need a continuance of oral argument, maybe consider a Zoom argument. They've really gotten much better now that we've gotten sort of the system down. Or better yet, be proactive. If you know that you are going to be unavailable for a period of time due to a long-planned vacation, a trial, a planned medical procedure, file a notice of your unavailability with our court administrator court assignment commissioner as set forth in Local Rule 21D. And if it's reasonable, the court usually honors those requests. So you can avoid having oral arguments scheduled at a time when it's not convenient for you for legitimate reasons. If you do request oral argument, be prepared and have something to say. Our 8th District judges come to oral argument prepared. They've read the briefs. They've reviewed the transcripts. They've read the cases. As one judge told me, don't spend your 15 minutes regurgitating the facts of the case. We know them. Choose 1 or 2 key issues to highlight why you should win and focus on those. Be prepared for questions. Our judges like to ask lots of questions. Know exactly which relief you want the court to give you. And if there are multiple potential ways to resolve an appeal, know what relief you want in each scenario. And know what relief you don't want and why. I mean, in certain cases, the relief is clear, this is an issue, but when there is an issue, it really is sometimes surprising that the court will ask a party, what exactly do you want? And it's surprising the number of times that somebody may not know the answer to the question or not be able to articulate it specifically. And if you're the appellee, be prepared for the question where they may ask you is, the appellant says they should get this relief, do you agree? Be prepared to that question. What is not a mispersuasive opportunity? Filing an application for reconsideration or en banc consideration in the usual case. It's not a second bite at the apple. The standard for reconsideration isn't actually set forth in the rules, but it is pretty clearly established in the case law by now. An application for reconsideration is appropriate where there's an obvious error in the decision or an issue that was not considered at all or not fully considered by the court when it should have been. It's not for use when a party simply disagrees with the logic or conclusions of the court. It's not a means to raise new arguments or issues, and it's not a prerequisite for further appeal. Likewise, en banc consideration is not, in the usual case, a mispersuasive opportunity. En banc review is intended for the rare case in which a court like ours, where there are many judges, the decision of one panel conflicts with the decision of another panel on a dispositive issue of law. And in the 8th District, there are very specific requirements for en banc applications that are set forth in our local rules, including the 1-paragraph statement of the dispositive point of law on which the 2 decisions conflict, and the identification of the specific paragraphs in each of those opinions of the conflict. Any application for en banc consideration that does not comply with the requirements of the rules may be summarily denied. You do need to remember that if you're filing both en banc and reconsideration, they have to be in one application. And I've been asked to remind everyone that Local Rule 23A, in terms of filing of frivolous motions, does apply to applications for reconsideration and en banc considerations. So. Now, at the outset of this presentation, I told you that when I was preparing for this presentation, I sort of canvassed the court and asked for their feedback regarding what practices detract from the effectiveness of an appellate brief or oral argument, or that can just make the appellate process more difficult. I wasn't entirely honest with that. What I really did was ask the court for their pet peeves. And so we don't have a lot of time, but you will get all these in your materials. And
But I think we might actually be out of time.
oh, we're out of time?
We're
Okay.
direct you to the materials.
Okay, so I will have to direct you to the materials, but there's a number of pet peeves here. I'm sorry we ran out of time to include them, but they'll be in the materials. So listen, just some of the things that the judges and other members of the court find can undermine your effectiveness with your appeal. Thank you.
Well, good morning. We're going to move right along. I am Judge Eileen T. Gallagher in the 8th District Court of Appeals. Our next presentation is Third Time is a Charm, an overview of the Ohio Supreme Court's third edition of its writing manual. Between our two panelists, they have combined over 40 years of writing experience and appellate practice. Today's presenters are Amy Chiam-Tai. Amy is in her second decade at the 8th District Court of Appeals. And prior to that was an assistant prosecuting attorney in the appellate division at the Lake County Prosecutor's Office. And our next presenter is Holly Marie Wilson. Holly has spent over 20 years as an appellate advocate, most of those years as a partner at Reminger. So I would say between the two, we have experts in writing, especially appellate writing. With that, Amy and Holly.
Good morning, everyone. It's always nice to talk in front of a group who enjoys writing and understands the importance of the written word and oral advocacy. And for this reason, we can geek out a little bit about citation rules when usually you talk to people about this and you just kind of watch their eyes glaze over. So the topic today is the Supreme Court of Ohio's new writing manual. It is the third edition. It became effective in June of this year. The history of the manual, pretty simple. We have what began as the manual of forms and citations used in the Ohio official reports. That came out in 1985. That was really Ohio's first stab at trying to create a uniform citation system that was not the Blue Book. That manual was updated in 92, 2002, and then in 2012 we have the first edition of the Ohio Citation Manual. Now, of course, we're in our third.
And just a word about the history of the manual. You know from writing prior to our third edition, we would always focus on the date of May 1st, 2002. And the significance of that date was that was when the Ohio Supreme Court established a repository for opinions from the Court of Appeals, the Court of Claims, and then selected trial court opinions. So in establishing that repository, those cases would be posted on the Ohio Supreme Court website starting May 1st, 2002, and they would have a website. So you would see, for example, I'm just making this up, a 2004-Ohio-1962. As you're going to learn through our presentation today, we're not going to focus anymore on the May 1st, 2002 date.
So why the changes? Most legal research today focuses on electronic resources. We don't need 3 separate hardbound volumes of books that have to be updated and paid for every year and that fall out of completeness very, very quickly. So with utilizing electronic databases, parallel citations are no longer needed or useful. And that's probably the biggest takeaway from this manual. We're doing away with parallel citations. And why does that help? Well, as a practitioner, you have limited space in your brief to get across your message. And what you don't want is to take 3 lines of parallel citations that just take up way too much of the brief. And you start glazing over. You get to the point where you're reading the brief, skip the citation, try to find where the sentence picks up, and go from there. So when people have reviewed the new writing manual, they've, of course, come to the conclusion, rightfully so, that it makes opinions and briefs more readable. Sentences are no longer bogged down with long citation sites. And now that we have all of the Ohio opinions on the Ohio website or using the Ohio website, everything's quick and easy to find. And the goals of citation, of course, they haven't changed. You want to provide the reader with sufficient information so that the reader can decide which authorities to check and in what order, where to find those authorities, and again, you don't want to consume too much. Yeah. Reactions from the legal community are exactly what you'd expect: simplification, readability, and simplifying the citation process.
All right, and just remember that really the goal of the citation is so that your reader knows what is the main site that they want to go to check. You want to give them accurate information so that they can easily retrieve that site, and you don't want the citation to never be a distraction to the reader getting to the substantive portion of your argument or your analysis.
One of the interesting points you'll find in the preface to the new manual, starting with the 2nd edition, the court let us know that Ohio judges and lawyers are not required to follow the manual, but the committee hoped it would be useful in the writing process. That's changed. We now have the 3rd edition, and in the 3rd edition, the court strongly recommends that practitioners use this. So that, that's the sign. Use the new manual, use the sites. You want your writing to be credible, and one of the ways we prove credibility is to follow the rules. Although the judiciary doesn't have to, because you also get to do what you want to do.
Right, and I would just add to that too. Use the manual in a way that makes sense. If something doesn't make sense to you, even though you want to be in compliance, but if it really doesn't make sense for what you're trying to do, and there's something that you want to kind of point out a little differently, you can still do that.
What are the new features and updates? The first one, and it should have been obvious, and who knows why it took this long, but when you access the manual online now, it's clickable. If you find the rule you want in the table of contents, you click it and you're brought right to it. Makes life easier. Also, there is a cheat sheet, and I'm obviously not going to go over this thing because I can't even read it, but 90% of the citation questions you have, you're going to be able to find on that cheat sheet. So start there. If your question's not answered, move forward into the manual.
And this cheat sheet is clickable too. So on that left-hand side, for example, under jurisdiction where you see Supreme Court of Ohio, if you click on that, it'll take you to that page in the manual that discusses citing an Ohio Supreme Court case. And then I believe at the bottom of the cheat sheet, there might be, some like rules that you can also click on, and it'll take you right to that page in the manual.
So a couple of the big changes and what they look like, you'll see up on the screen. And again, the first scenario is very simple, just what a change it makes between the second edition citation and the third edition. You've cut out the Northeast Reporter, you've cut out the Ohio Reporter, you're now left with the website paragraph. It's all you need when we're talking about a Supreme Court decision. If, for whatever reason, you don't have an Ohio website available yet, it's coming. They're working backwards. They'll get there eventually. But if not, you want to stick with the Ohio State Reporter. The Northeast Reporter, at least in the state of Ohio, is now considered obsolete. There's no need to use it.
So here's an exception that comes up sometimes with our court, and the particular case that we've cited is State v. Tompkins, which we use a lot in our sufficiency of the evidence analysis. This case has a website, so you can see it's at 1997 Ohio-52, but there's no paragraph numbers. So in this case, even though there is a website, we're not going to use it. We're going to use the official Ohio Reporter, and that's it. And we're going to delete the citation to the Northeast Reporter. So even though the Ohio Supreme Court didn't start putting the cases on their website until May 1st, 2002, they went back and did websites for some older cases, so you might encounter that situation.
Court of Appeals citations are also going to look a little different. Specifically now, we no longer have to put in the county. So, second edition, 10th district, Franklin number, case number, and then the Ohio website. Now, State v. Jones, Ohio website, we're going to let you know, though, that it's the 10th district. So you still keep the appellate court in there. We're just going to drop the county and the case number. Again, save space all the way around.
So just generally, in a nutshell, if there's a website, you're going to use that and nothing else. If there's no website, you're going to cite just to the official reporter. And then if there's no website and no official reporter, then you're going to use the electronic site, which is going to be your Westlaw or your Lexis site.
Citing to the United States Supreme Court has also changed. Again, concise. We're going to use the official U.S. reporter when available. When it is not available, we're going to leave in the blanks for the U.S. reporter and put in the Supreme Court's citation until the official reporter catches up. Also, a very slight change for reported federal circuit court cases. The only difference, and this is super minor, but when you're citing the circuit court, 6th Circuit, 2019 in the example, you're now going to have a space between 6th and circuit. Again, a very minor change. Unreported cases, we also have a slight change, and that is going to be, again, we're dropping the case number. Just stick with either the Lexis or the web or the Westlaw site. I swear I'm pushing the button. All right, Ohio constitutions and statutes. Again, very minor changes. We're simplifying the process. We're making it a little easier to read. We no longer have to write out Ohio Constitution, Article 4, section. Instead, you see the abbreviations there on the screen. Revised code, citing the revised code chapter, same as well. Instead of writing out the word chapter, we have CH period.
And just notice now that article is lowercase, and we're using the scale probe, which is the section symbol instead of writing out section. We're going to use the section symbol for constitutions and secondary material. So like if you're quoting a restatement, you can put the CWRU in there. We're not going to use the CWRU for the revised code, so it would still be RC 2929.19, or for the United States Code, it would still be USC 42 1983. You don't.
Okay. Other citation changes, very quickly. We now have the ability to use a permalink. Often in briefs, we find ourselves citing to specific websites, web pages. Those pages change over time. Sometimes they're deleted altogether. And of course, when we're writing and when we're advocating, we want to be as specific as possible. Using a permalink allows an author to freeze that citation in time. So if the court's looking at your brief 6 months later, 2 years, 3 years later, the website that they pull is going to look exactly the same as the one you want to reference in your brief. Also, again, a couple little rules here, but they're significant. Use of the phrase emphasis in original is now going to be preferred instead of emphasis sick. And the parenthetical cleaned up. It's starting to find our way into legal writing. It is still fairly controversial. It has some good uses, mainly getting rid of those monster block citations. However, the court wants us to use that parenthetical sparingly. So cautiously, if it starts gaining traction, maybe this gets revisited. But in the meantime, err on the side of not including it if you can get away with it.
Some other style changes. We're going to use ellipsis instead of asterisks to denote omissions in quoted material. And there's a space between each ellipsis. Avoid archaic feminine suffixes such as administratives and kind of err or side more to gender neutral language. We don't want to say stuff like it was a manly effort. We all know the caution against using block quotations, and the reader's temptation when they see block quotes really is to just skip over it. So be careful about your use of block quotations. When you use sick, we're not doing it to, kind of sneer at the writer. We want to connote that we're quoting exactly as the intended quote is, and we're not using it to kind of jeer at what someone has written. And then avoid acronyms. Doctor abbreviated is okay, but use abbreviations and acronyms that people are going to recognize and know right off the bat what they are.
And that also entails not necessarily using an acronym for every single party in the case. If you can get away with it, we want to try to avoid those types of confusing acronyms. Changes regarding capitalization, very few. We now capitalize the S in state when we refer to the state of Ohio. Proper nouns are capitalized, so city of Cleveland, the C in city is going to be capitalized, unless you're just referring to the city in general. Also, and this hasn't changed, but when you're referring to a higher court, you're going to capitalize the C in court.
And just a slight change with the placement of footnotes. In the second edition, the footnote went after the year, and now it's going to go before the year. If you have a website, then the footnote would go right after the website or the pinpoint site. And then just a general caution about footnotes, you want to use those sparingly. Again, if it's really important, it should be in the body of your text. Do not place citations in footnotes. I would say the only exception to that would be maybe if you have a bunch of string cites with parentheticals, that might be appropriate to place in a footnote, but otherwise your citations should be in your text. And just remember, when you're thinking about using a footnote, you think about, how important is this? If it's something that you're thinking about placing in a footnote, maybe it really isn't that important and you don't need it. Or if it is important, then obviously it should be in the body of your text.
All right, the Oxford comma, this is the big one, the controversial. Oxford comma, it's also known as the serial or the Harvard comma. It's used to clear up confusion and follow the rules of commas in lists, and is used to separate the final two items of a list that contain 3 or more items. It's always placed before the final coordinating conjunction. And of course, I had to copy that from somewhere because we sort of know what Oxford comma is, but defining it, I wanted to put a joke in here, a comma joke. I looked online, they were all dirty. So I stuck Amy, Holly, Jennifer, and Sarah love to eat ice cream. I thought that was about as easy as I could get. That's not going to offend anyone in the room. Obviously, the Oxford comma is the one you find after the name Jennifer and before the word and. I was actually on the committee when this manual was being discussed, and it was days of discussion over the Oxford comma. Its popularity kind of goes up and down, but now in the state of Ohio, it's enshrined in our manual. Use the Oxford comma.
Okay, structure of the judicial opinion. There's no major changes. So the components of an opinion, you have head notes, and the head notes are not something that the court writes. They're written by the Supreme Court's reporter's office, and they're officially not part of the opinion. Then a syllabus is not something that the 8th District Court of Appeals uses. It's not mandatory, but if it is used, it's written by the author of the opinion, and it has to be approved by a majority of the court. It summarizes the legal principles of the opinion, and generally the syllabus paragraphs are taken verbatim from the text of the opinion, with citations omitted. In your opinion, and our first panel kind of talked about this, tell us if you're staff attorney and you're writing for the court, what's the disposition? What are we doing? Is the judgment affirmed? If it's affirmed in part and remanded, what's going to happen on remand? And then that can kind of be extrapolated to the briefs, and the first panel talked about this. In your briefs, tell us what it is that you want us to do, because we can, if you give us a clear request for relief, we can use that right in our opinion if we agree with you for our disposition. And there are writings of examples of opinions in the writing manual for you to take a look at. So the outline of a typical opinion. Introduction, you're identifying the main issue, you're providing the factual and procedural context, and you're stating your conclusion. Just a brief word on the facts and the procedural part. Sometimes, as judicial attorneys, we get cases that have been lingering around for years, and there's a ton of procedural history, and there's a ton of factual history. Kind of narrow your factual and procedural history to the issue on appeal. So it doesn't, if we have say a divorce case that's been going on for 5 years, we don't need to know everything that happened in the case. Just, what are the facts and the procedural history that are relevant to deciding this appeal is what we're going to put in our opinion. So I kind of already. All right, the legal analysis. We're going to articulate precise terms that are presented in the appeal. We're going to review the standard of review, and like Melissa said in the first presentation, sometimes our standard of review, we're not going to spend a whole page going over the standard of review for a summary judgment, because really everybody knows what that is. So for easier readability and preservation of space, we're going to try to keep it simple. And then our sources of legal principles and how they apply to the facts in this case. And then finally, our conclusion, which summarizes the basis of the decision and what we're doing, and how each assignment of error is going to be decided. Okay, types of opinions. We have majority opinions and lead opinions. The majority provides the court's explanation for the judgment, and it's joined by more than half of the participating justices. The lead announces the court's judgment, and it's not joined by more than half of the participating justices. We can also have separate opinions, which can either concur with the judgment, concur with the judgment only, or concurring in part, dissenting in part. Sometimes these opinions you'll see it's just as simple as concurring in judgment only. Sometimes they're actual separate opinions that explain why it is that the judge is concurring, and they might want to write something separate, or why they're concurring in judgment only or concurring in part.
Any questions? Perfect. Thank you all for your
So, I'm not frequently use parentheticals, so I'm just trying to better understand why.
Use the mic, please, for the Zoom audience.
Oh, I'm sorry. So I said I not infrequently use parentheticals to like maybe highlight a particular, what the holding was in the secondary site. I'm kind of wondering why that's frowned upon, or how, if there's information you want to convey in that secondary site, do you just talk about that case more fully in the paragraph?
Exactly. Just put it in a sentence and then the citation.
Okay.
On occasions, there is a reference to citations omitted when they have a block paragraph and you don't want to have 32 different. Should I repeat it?
Yes.
All right. Where there's a block paragraph, many times there's in parentheses citations omitted so that you do not cite the 32 different cases in there. Is that to replace cleaned up, or is that still usable, or?
I still use citations omitted. Cleaned up has a similar connotation, but people find it, are still taking offense to the cleaned up versus citations omitted. So I stick with citations omitted.
Can you put one citation omitted for the paragraph, or for each area where the case is not being cited, you then put citation omitted? In other words, when you clean it up, you get rid of all of that stuff, and that's why you have cleaned up. But if you do citations omitted, do you need to do it for each case that is then being omitted?
I would do it once. I think just to keep it a little more succinct, that would be my thinking.
I just want to say on Wednesday, the Ohio Supreme Court released a serial comma case, Oxford comma case.
It's here to stay.
All right.
Thank you all.
10:15, thank you very much.
Ohio Edison had an easement and they were going to spray pesticides under the telephone pole to get rid of vegetation, and they looked at the language of the easement to see whether it included
Well, good morning, everyone. It is now 10:16, and our session's supposed to start at 10:15. When he talked about the comma, I said my AP English teacher would be mad about that Oxford comma, and I hate that comma too. Just like Judge EA, both of us say, nope, I'm not using it. But I guess we've been overruled, huh? Yeah. Right. Well, my name is Anita Laster-Mays, and I am a judge at the Ohio 8th District Court of Appeals, and it is my honor to introduce these two gentlemen for this next session on be careful when moving to dismiss an analysis of CWRU 12. But first I want to give credit to Judge Celebrez's Judicial Attorney Candace for putting this panel together. So we have two dynamic speakers, Marcel Duhamel and Matthew Fazikis, both of Vari's. Marcel is a partner in the Cleveland office, and he is also a litigator and private lawyer. His practice includes privacy, class actions, consumer protection, banking litigation, complex litigation, bankruptcy, and appellate practice. And he often lends his expertise to the legal community just to assist us and just educate the legal community. Matthew Fazikis is an associate attorney in the office, and his practice includes he's part of the litigation group, and his practice includes commercial, oil and gas, energy, workers' comp, bankruptcy, and creditors' rights disputes. And so we are happy today that they have come to share their talents with us, and thank you, and the floor is yours.
Thank you very much. Good morning. Thanks for the opportunity to speak to you. And the first question I want to answer is why? Why are we talking at an appellate seminar about Civil Rule 12, which obviously doesn't apply to appellate proceedings, right? Well, the reason is because, in my view, any successful trip to the Court of Appeals starts in the Court of Common Pleas. And if you screw up on Rule 12 in the Court of Common Pleas, then regardless of what the merits may or may not have been of your argument below, you're going to run into trouble when you get to the Court of Appeals, because the Court of Appeals is very likely to apply these rules technically as they are written, which is appropriate. So it's important to understand how these rules actually work. And there are a few traps for the unwary as well, because despite the fact that the Ohio Civil Rule and the Federal Civil Rule are nearly verbatim in almost all respects. In a few key areas, the Ohio courts interpret these rules quite differently than federal courts, and we'll talk about that a little bit. So the way we're going to divide this up, I'm going to talk about dispositive motions in the rules 12b 1 through 7, and Matt is going to talk about non-dispositive motions under rules 12e and 12f, although calling 12f a non-dispositive motion, or 12e a non-dispositive motion, can be a little misleading, and also the mechanics of filing Rule 12 motions below. All right, so first let's talk about subject matter jurisdiction. Subject matter jurisdiction is the subject of a Rule 12b1 motion. The standard is whether or not any cause of action is cognizable by the forum that's been raised in the complaint. What subject matter jurisdiction is not, two things. The first one is arbitration, right? So we will occasionally see a defendant move to dismiss a complaint on the theory that there is no jurisdiction in the Court of Common Pleas because there is an arbitration provision in the party's contract. Generally speaking, 12b1 is not an appropriate method to try to compel arbitration in the Court of Common Pleas. The Pappas case from the 8th District is a good example of this. In that case, the defendant moved to dismiss, argued that, gee, there's an arbitration provision, the parties agreed to arbitrate, therefore the court lacked subject matter jurisdiction. Not so, said the 8th District. The court had jurisdiction. Instead, what the court should have done was stage the litigation pending an arbitration, and that's typically the correct way to do it. You bring a motion to stay the litigation pending an arbitration, and then either the plaintiff or the defendant in that case goes out and demands arbitration of the issues that have been raised in the complaint. There could be a different outcome perhaps, depending on how the arbitration provision is actually written. Because one thing that the 8th District did talk about in the Pappas decision was the precise language of the arbitration provision, which did not actually expressly say that the parties agreed that exclusive jurisdiction for any dispute would lie in an arbitrable forum. So query what would have happened had that arbitration provision been written that way, so that what it had said, instead of the parties agree to arbitrate, it had said something along the lines of, further, the parties agree that the Court of Common Pleas will have no jurisdiction and the only jurisdiction is in an arbitrable forum. Would that have then supported a 12b1 motion to dismiss the lack of jurisdiction? I'm not sure, but that question wasn't resolved by Pappas because it wasn't presented in that case, and I haven't seen it presented. I have, however, seen arbitration provisions drafted that way. I've drafted some arbitration provisions that way. So how that's going to be interpreted by a court remains to be seen. And this is an important area where there is a huge difference between federal practice and state practice. In federal court, a standing question goes to subject matter jurisdiction. So 12b1 motions in federal court are the appropriate way to raise the plaintiff's lack of standing to bring a complaint. Not so in Ohio. As the 5th District put it, there is a clear distinction between the requirements of subject matter jurisdiction and standing. And standing in an Ohio court cannot be raised on a 12b1 motion. It can, however, be raised on a 12b6 motion. We'll talk about that a little bit. It matters because there's a question about whether or not you can consider matters extrinsic to the complaint, right? In a 12B1 motion, often you can consider matters extrinsic to the complaint. So you can raise issues outside the four corners of the complaint in arguing that the plaintiff lacks standing. In 12B6, that's more constrained, right? Generally speaking, with some exceptions, you're confined to what actually appears in the complaint. So to argue that the plaintiff lacks standing on a 12B6 motion, as opposed to a Rule 56 motion, you have to argue that either on the face of the complaint, it's clear the plaintiff lacks standing, or alternatively, you've got some other material that the court can consider on 12B6 outside the four corners of the complaint. That's rare in Ohio, but there are circumstances where that can happen. There's also a distinction in let's talk about it in the 12B2 context, personal jurisdiction. Personal jurisdiction is the subject of 12B2, not 12B6. Right? So if you want to move for lack of personal jurisdiction, you have to do it under Rule 12B2. As a reminder, right, a court has personal jurisdiction if two things are true. The defendant's or the defendant's conduct falls within Ohio's long-arm statute, and conferring the jurisdiction would comport with due process of law. Generally speaking, though, if the defendant is found within the state, you're going to have personal jurisdiction over that defendant in a court of common pleas, really anywhere in Ohio. Venue is a different topic. We'll talk about venue in a moment. B2 is resolved at the Court of Appeals de novo, not abuse of discretion. And here, too, there is a difference between federal practice and state practice. In federal practice, there are two types of challenges to personal jurisdiction, facial or factual. A facial challenge turns entirely on the allegations of the complaint. A factual challenge turns on information that is extrinsic to the complaint, and in a factual challenge, the court can consider areas outside of the complaint. In Ohio, that distinction exists, but it's a little bit different, and it really turns on the conduct of the trial court. The rule in Ohio is simply this. If the Court of Common Pleas conducts a hearing, then anything that is properly admitted at the hearing can be considered by the court in ruling on the motion to dismiss for lack of personal jurisdiction, and the plaintiff bears the burden of proving jurisdiction. On the other hand, if the Court of Common Pleas does not conduct a hearing, then the court's inquiry is limited to what appears on the face of the complaint. So if you want to raise on 12B2 issues that are not in the face of the complaint, it's going to be very important that you ask the trial court to conduct a hearing. Because if you don't, and the court considers that information anyway, there is a risk that the Court of Appeals will reverse simply because the court considered information that was extrinsic to the complaint. B3 is fun. This is improper venue. Venue motions in Ohio are, again, different than venue motions in federal court for this reason. There is no such thing as forum nonconvenience in Ohio. There is, however, forum nonconvenience in federal court. What does that mean? In Ohio, the question really is binary, with one exception. There is either proper venue or there is not proper venue. And if there is proper venue, then whether it is convenient to the parties or not is beside the point. Venue is proper, so the lawsuit can proceed in that jurisdiction, in front of that court. In federal court, even where venue is proper, there are times where a court will transfer to a more convenient forum. On the theory, gee, most of the witnesses are in that venue, for example. Here it doesn't matter. If the defendant is located in Cuyahoga County, you're going to have proper venue in Cuyahoga County, notwithstanding the fact that all of the defendant's employees might be in Hamilton County, right? But if you can find the defendant here, you can bring them here. What that might mean is there could be multiple counties that have proper venue over the same case. So, too bad, right? If it's inconvenient for you to litigate in that particular forum, it doesn't really matter if there is proper venue. What's interesting about this, however, to me, is that the standard of review on 12b3 is abuse of discretion as opposed to de novo. And I'm not sure why. I tried to figure that out in advance of this seminar, right? I can find the source of this ruling, but I can't tell you what the policy is that suggests that whether venue is proper is discretionary as opposed to de novo review. But what I can tell you is that the law in Ohio is overwhelmingly clear that this is reviewed on an abuse of discretion standard and not a de novo review standard. We don't very often see 12b4 motions, but they do exist, and they are distinct from 12b5. 12b4 goes to the sufficiency of process, and sufficiency of process is all about what is actually in the summons. Right? So, do you have a summons that properly checks the boxes and that attaches the complaint? If the answer is yes, you have sufficient process, which is distinct from sufficient service of process, which we'll talk about in a second. That's under Rule 12b5. But here too, under Rule 12b4, for reasons I'm not entirely sure of, this is reviewed on abuse of discretion. It is not reviewed de novo. Why? I don't know. But ultimately, it is in the trial court's discretion to decide whether or not service was sufficient. If the court is going to dismiss for insufficient service of process, or insufficient process, I should say, that dismissal should be without prejudice. If the court were to dismiss with prejudice, it is likely that that would be reversed on appeal. Insufficiency of service of process is a little more common than insufficiency of process. This is really when the plaintiff fails to serve the defendant with the summons within a year of filing the complaint. Or when what the plaintiff says constitutes service, the defendant argues was not really service. Here too, this is reviewed for abuse of discretion, not de novo. And here too, I can't tell you why. I don't know why, what the policy is that supports a de novo, or I'm sorry, an abuse of discretion review here as opposed to a de novo review. But I can tell you that appears to be the law. There are service by publication rules, but it is really important if you're going to attempt to serve by publication, you check the boxes. Because there are good reasons for service of by publication to be disfavored, right? There's a really good chance that the defendant didn't actually know that they were being sued when you serve by publication. So if you are going to serve by publication, you must file an affidavit that states all of the efforts you made to determine where the defendant could be found and the efforts you made to serve the defendant at that location. And if you fail to do that, your service of publication will likely be deemed to be insufficient service. That's what happened in the Lewis v. Butson case. Because the plaintiff there had not actually filed an affidavit that specifically established all of their efforts in enough detail, the Court of Appeals concluded that the affidavit was insufficient and service of publication didn't work. So I'm a civil litigator, right? So Rule 12b6 is one of my favorite rules. It's an interesting rule. Failure to state a claim upon which relief can be granted. There is a lot of paper, a lot of ink has been spilled on what is the distinction between notice pleading on the one hand and pleading sufficient facts to state a claim on the other. And here too, there is a difference between federal practice and state practice. We'll talk about that in a moment, but I also want to mention Rule 12C. Rule 12C is theoretically identical to Rule 12b-6 with this exception. Rule 12C can be filed after you answer, and Rule 12b-6 is filed before you answer. They are otherwise identical rules. You file a Rule 12C motion because you want to argue that the complaint fails to state a claim on which relief can be granted. Only difference between 12b-6 and 12C is when it is filed. 12C is filed after the answer. 12b-6 is filed in lieu of an answer. If that's true, query, why would you ever file a 12C as opposed to a 12b-6, or a 12b-6 as opposed to a 12C? Two answers. There are times where it may make sense to answer the complaint and then file a Rule 12C. There are times where I've done it. And in particular, one weird anomaly that can result in 12b-6 practice. If the Court of Common Pleas allows that motion to linger for a very long time, and if the Court of Common Pleas does not stay discovery or the rest of the proceedings while it's considering a Rule 12b-6, you could, in theory, find yourself in the situation of a year after filing your motion to dismiss, after having taken and defended a half dozen depositions, after having fully briefed a motion for summary judgment, and while attending the final pretrial on a Friday afternoon with trial scheduled on Monday, the Court of Common Pleas announces, I am denying the motion to dismiss. Well, the defendant has never answered. And if the defendant has never answered, the defendant has also never had to file a counterclaim. Because under Rule 13, right, your counterclaim is due when the answer is due. So in theory, you could now have, on the morning of trial, a counterclaim filed for the first time. The other problem with, that could militate towards filing a Rule 12C if you are concerned that could happen to you, and you want to make sure that your counterclaim is brought in a way that the Court of Common Pleas is going to pay attention to. Right? So if I'm likely to have a counterclaim, I'm more likely to file a Rule 12C than I am a 12b-6. The other potential trap, you file a 12b-6, my parade of horribles plays out, and frankly, you forget that you didn't answer. Right? You've been litigating this case for a year, and you just forget that you didn't answer. And then you want to raise some argument that constitutes an affirmative defense, and you never pled the affirmative defense because you didn't answer. You're out of luck. So there are times where it makes sense to answer and file a 12C. Having said all of that, my personal experience is that the district courts in federal court are a little more familiar with Rule 12C than the common pleas judges are in Ohio court. So sometimes when you file a Rule 12C motion in an Ohio court, you have to take the time to explain to the common pleas judge that it really is identical to a 12b-6 motion. It's just a question of timing. 12b-6 and 12c are both reviewed de novo. In Ohio, prevailing on a 12b-6 motion, if you were the moving party, is arguably a little bit harder than it is in federal court. Why? Well, two U.S. Supreme Court decisions called Appellate and Appellate established a standard that requires not only a short, plain, concise statement of the claim, but also that the plaintiff pleads sufficient facts that give rise to a plausible plausible claim for relief. That plausibility standard is different than the standard that had been articulated by the U.S. Supreme Court case in a case called Conley v. Gibson, which is still the standard in Ohio. Right? So in Ohio, the question is there any facts, are there any facts consistent with the complaint that could give rise to liability? If the answer is yes, then the complaint states a claim. So federal court's a little bit more likely to grant a 12b6 motion than a state court. It does not follow, however, that you cannot get a 12b6 motion granted in Ohio, because short, plain statement does not mean conclusory allegations, right? It's not enough to say, defendant tortiously interfered with my contract, I win, right? You still have to plead sufficient operative facts so that if those facts were true, the plaintiff would prevail. What the plaintiff in Ohio does not have to do is plead with any specificity those facts. So they have to plead operative facts, but they don't have to prove their case in the pleadings. I should point out the 8th District has been very clear, by the way, in Coletta. The court has not adopted Iqbal and Twombly. Those cases have been cited by appellate courts, and in a few cases they've even been cited for the proposition that the plaintiff needs to plead plausibly. But for the most part, Ohio courts have been pretty clear that the Iqbal and Twombly so-called heightened pleading standard, if that's what it is, has not been adopted in Ohio. Standing in Ohio can be brought under 12b6, not under 12b1. This gets interesting because often standing is going to require some information outside the context of the complaint, right? It's not going to be that often that a plaintiff's complaint fails on its face to assert proper standing because you don't have to allege standing, right? So often you're going to want to point to something outside the complaint that suggests that the plaintiff doesn't have standing. Well, that gets interesting. Generally, right, a court can't consider anything outside the scope of the complaint or its attachments on a 12b6 motion. But first, it is clear if the plaintiff attaches anything to the complaint, the court can consider that. But in addition to that, the court can take judicial notice, and I want to talk about judicial notice on 12b6 motions here too, because I think there's a little bit of an unsettled area here, because there's some tension between the decision of the Ohio Supreme Court and subsequent decisions of Ohio appellate courts on this topic. And I don't know how that tension is ultimately going to get resolved. Right? So generally speaking, a court can take judicial notice of facts generally known in the jurisdiction, capable of accurate or ready determination by resort to sources that cannot reasonably be questioned when ruling on a 12b6 or 12c motion. Interestingly, though, the 8th District has said that a court may not take judicial notice of prior proceedings before the court, even if the same parties and issues are involved, right? Which is another way of saying the court can't take judicial notice on a 12b6 motion that raises, for example, res judicata. Very different in federal court. In federal court, res judicata is always resolved on 12b6. You would never have summary judgment on res judicata. That would go to 12b6. In Ohio, there is some clarity, or a bit of a lack of clarity, because there is a case with Everhart v. McIntosh, State XRL Everhart v. McIntosh. It's not on the slide, but if anyone's really interested, it's at 115 Ohio State 3rd, 195, in which the court said, the Supreme Court said, courts can take judicial notice of public court records available on the internet, which implies that on a 12b6 motion raising res judicata, for example, if the prior proceeding appears on the public docket of a court, on the public website, then on 12b6, the court can take judicial notice of it. The appellate courts in Ohio have been less than entirely consistent on this topic. Some courts have said, we will consider that on a 12b6 motion in the res judicata context or in the standing context. And other Ohio appellate courts have said, nope, it's not attached to the complaint, and therefore it's improper on 12b6. I don't know how that's going to play out at the end of the day. 12b7, failure to join the party under Civil Rule 19 or 19.1. This is an often abused rule by litigants on both sides of the V. Rule 19 requires that a party has to be joined when any of the following is true, right? The party's absence will preclude complete relief from being given. The party claims an interest in the action and is so situated that disposition of the case without her would be impractical. Or she has an interest as an assignor or assignee or subrogor or subrogate. A ruling on 12b7 by the Court of Common Pleas is reviewed by the appellate court de novo. But generally, despite being a motion to dismiss under Rule 12b7, courts don't actually dismiss the case. What typically a Court of Common Pleas is supposed to do is direct the plaintiff to join the necessary party and then dismiss the case if and only if the plaintiff then fails to do that. Or if it is simply impossible to join the necessary party. If you can persuade the Court of Common Pleas that joinder is necessary and it is simply not possible for the plaintiff to accomplish that, then a 12b7 motion can result in a dismissal. That'll turn it to my colleague.
Thanks, Marcel. And before I jump in, I want to give two shout-outs. First, to Candace Waba for coming up with the pun title for our presentation, as well as thank the court for giving us the opportunity to speak with you all today. And actually, a third shout-out to Drew Fleming. He's an associate in our office. He helped put this PowerPoint together and do the research for us. So if he's watching online, thanks, Drew.
You know, it's embarrassing that I didn't bring that up.
That's why you have associates, Marcel. So we're going to start with Civil Rule 12e. As Marcel mentioned, calling Rule 12e and then Rule 12f as a non-dispositive motion can be misleading, but it generally isn't. So under Rule 12e, you can move the court for a more definite statement when the pleading is so vague or ambiguous that a party cannot reasonably be required to frame a responsive pleading. Well, what does that mean? That's a great question. There's not a ton of case law interpreting when a pleading is so vague or ambiguous that a party can't respond to it. Its most common application is in conjunction with Rule 10. And under Rule 10, there's two situations when there's certain attachments you have to include with a complaint. The first is when your claim is based upon a written instrument, you need to attach that written instrument to your complaint. So if it's a breach of contract action based on a written contract, you need to attach that contract. The second application is in malpractice cases, you need to include what's called an affidavit of merit with your complaint. The failure to attach a document in compliance with Rule 10 is not grounds for dismissal under Rule 12b6. Courts have been unanimous in holding that Rule 12e is the proper remedy for a defendant based upon a plaintiff's failure to comply with Rule 10. So if you get a complaint that doesn't comply with Rule 10, you file Rule 12e, the trial court should grant that motion and order that the plaintiff file a new complaint or an amended complaint with the attachment. If the plaintiff then fails to do so, then the trial court can then dismiss the case. But if you decide to move for 12b6 based on failure to comply with Rule 10, you're going to get reversed on appeal, so you're going to want to avoid that. Next, Rule 12f. Rule 12f is your motion to strike. And under Rule 12f, a party may move the court for an order to strike any insufficient claim or defense or any redundant, immaterial, impertinent, or scandalous matter. Like Rule 12e, there's not a ton of case law providing guidance on what those words mean. There is case law that suggests Rule 12f is limited to pleadings. You know, we as litigators tend to refer to pleadings broadly as anything filed in court. I mean, we might have our file that has a pleading section or a pleadings clip, but Rule 12F is limited to pleadings as defined in Rule 7, so that's your complaint, an answer, a reply to a counterclaim, a counterclaim, a cross-claim. So don't use Rule 12F to strike something that isn't one of those things. There's probably a case or another rule that could give you a basis to strike something else that's with the court. For example, Rule 56 would allow you to strike certain affidavits that don't comply with the rules. I don't want to spend a ton of time on this slide. There's sort of a really academic distinction under Rule 12 that kind of doesn't matter at the end of the day. But in the Neff versus Corrigan case, the Supreme Court of Ohio has suggested that Rule 12F should be used when you're moving to partially dismiss a complaint as opposed to the entire complaint. And in this case, the trial court used 12F to dismiss an entire complaint, and the Supreme Court of Ohio said that was incorrect. You should have used 12B6, but then the court said it didn't matter because it failed to state a claim anyways. Right? If you look at the prong of 12F, it's a legally insufficient claim or defense. That sounds like failure to state a claim to me. And on the flip side, if you partially move to dismiss under 12B6, maybe you should have used 12F, but there's case law within the 8th District that holds it doesn't matter. If the ruling was proper under 12B6 or 12F, who really cares? So moving now, I think, to the more interesting portion of the presentation, and the more practical portion of the presentation is your mechanics for filing your Rule 12 motion. So the timing for filing a Rule 12 motion is the same as filing your answer. You have 28 days from service to file a Rule 12 motion. Now, as Marcel talked about earlier, certain motions you don't have to file before you answer, but should you choose to, you have 28 days before answering. And there's 3 distinct categories of additional constraints with respect to Rule 12 motions. The first is your 12B1 motion for lack of subject matter jurisdiction. That can be raised at any time after you answer, at trial. You can even raise it for the first time on appeal. And the basis for this is pretty simple. If a trial court lacks subject matter jurisdiction over the action, it can't enter judgment in the action. So you can't, courts have held that parties can't consent to subject matter jurisdiction or waive subject matter jurisdiction. The court either has jurisdiction or it doesn't. The second category is 12B2 through 5. That's personal jurisdiction, venue, and the 2 service rules. And in this situation, we'll talk about it on the next slide, you either waive it by failing to move to enjoin it in a Rule 12B motion, or you don't include it in an answer if a 12B motion has not been filed. And the third category is 12B6 and 12B7. Similar to 12B1, you could file this really at any time because Rule 12C gives you the opportunity to file a motion for judgment on the pleadings. And the rule is explicit. You can raise these defenses in a Rule 7A pleading, your motion for judgment on the pleadings, or even at the trial on the merits. And as I was thinking about this, well, why would you wait until the trial of the merits to move to dismiss? Would you want to do that earlier, save your clients some time and money? And what I thought of one example could be, there's a statutory claim in the complaint, and the day before trial, the Ohio Supreme Court says that statute is unconstitutional. Then you have the opportunity at trial to say, Your Honor, this case no longer states a claim based on this new case. So under that second category of motions, as I mentioned, you will waive them if you don't join them with a Rule 12B motion, or if you fail to include it in your answer. So by way of illustration, if you move for a 12B2 motion, and the court denies that, you can't then move for 12B4. If you have a defense under 12B2 and 12B4, you need to join them at the same time. And if you move for a 12B motion, you can't then later raise any of these motions because you put it in your answer. Conversely, if you don't move under Rule 12B and you preserve these defenses in your answer, you could raise these at any time, and I'm getting the 5-minute time, so I'm going to skip ahead. Because that's the most interesting part of our presentation. 12B6, again, you don't really waive it. I kind of explained this, because you always have the opportunity for 12C or raising it at the trial of the merits. Okay, so the Ohio Supreme Court's addressed the issue of, well, does active participation in a lawsuit waive your right to raise a 12B5 defense for insufficiency of service of process? And what the court has done in 2 decisions has held that active participation does not waive this defense so long as you comply with Rule 12H. And that's, as I discussed, the raising it in your answer or including it in the Rule 12B motion. So in 2007, the Ohio Supreme Court in Cuyahoga versus University Urologists of Cleveland, Inc. addressed this very question. And in this case, the plaintiff attempted service by certified mail. The certified mail failed, but the defendant nonetheless had notice of the proceeding, appeared, and litigated the case for over a year. The defendant did not file a Rule 12B motion, but instead included that defense of insufficiency of service of process in its answer. Despite participating in the case for over a year, conducting discovery, and filing a dispositive motion before trial, the trial court determined that because there was no service, it could dismiss the action. The plaintiff in turn said, wait, hold on. Service, the whole point of service is to provide notice to the defendant and give them an opportunity to appear and defend the case. That was achieved here, even though technical service had not applied. The 8th District agreed with the plaintiff and reversed the trial court's decision, but the Ohio Supreme Court agreed with the trial court for the simple reason that the rules are explicit in how you preserve these defenses, and the defendant followed it. And the quote from the case is, whether or not the defendant's strategy constituted gamesmanship or good litigation strategy, they followed the rules. So in the aftermath of Cuyahoga, Ohio Courts of Appeals begrudgingly applied Cuyahoga as being unfair. And it is to an extent, right? You appeared, you came to the action. What's the harm of, you didn't actually sign the green card with the complaint? And this is in contrast to the federal standard. Under federal law, at least within the Sixth Circuit, active participation that would suggest that you're going to defend the case on the merits waives your right to assert personal jurisdiction and service. This makes sense in a way. But just this year, the Supreme Court reaffirmed Cuyahoga in Ackman versus Mercy Health West Hospital, LLC. This case is even worse than Cuyahoga. In this case, the defendant, it was a medical malpractice case. The plaintiff got good service on the defendant hospital, but didn't get good service on the individual defendant. And the problematic portion of that for the plaintiff is a hospital's liability, medical malpractice is based upon vicarious liability. So if the doctor's not liable, the hospital's not liable. Because the defendant doctor was never served, the defendant properly preserved the 12b-5 defense in their answer, and then the day after the statute of limitations lapsed, moved to dismiss under 12b-5. And what's important is that under Rule 3, a case isn't commenced for purposes of a statute of limitations until service is effectuated. And so what happened was the trial court found, yep, there was no good service on the defendant, and therefore we're dismissing them, and we're then compelled to dismiss the hospital because its liability is premised upon the defendants, and you can't refile the case because you never commenced the case in the first place under Rule 3, so the saving statute doesn't save you. On appeal, the Supreme Court said, look, Cuyahoga is still good law, and we're going to affirm Cuyahoga for the simple reason that it's predictable. Unlike the Sixth Circuit standard, we know when a defendant preserves or does not preserve a Rule 12b-5 defense based on just looking at what the rule says. In contrast, the court cites to a 2021 Sixth Circuit case in which for the first time the Sixth Circuit addressed whether filing a notice of appearance constitutes a waiver of your personal jurisdiction defense. So I think the Supreme Court took the practical approach of we don't want to have to, every time there's a new situation, give an answer. Just follow the rules and you preserve your defense. And on one final point, both the majority and the concurring opinion relied on Rule 1. Rule 1 provides that the rules should be interpreted to affect just results and to eliminate impediments to the expeditious administration of justice. On one hand, if you're the plaintiff, you lost the case on a mere technicality. That's not a just result. But for the defendant, when a defendant follows the rules, it wouldn't be just for them to allow the plaintiff to proceed despite doing what they were supposed to do. So with that, I'm giving you a cue card to say that it's time for questions. So if anybody has any questions.
Before we do that, there's one last practice pointer, both at the Court of Appeals level and at the trial court level. Look out for amended complaints, which reset all of these preservation requirements, right? So you file a motion to dismiss, the plaintiff amends the complaint. Whatever you said in your original 12b-6, it's as though it was never said, right? Now there is an amended complaint. So whatever you think you preserved with respect to that first complaint, it is no longer preserved. Once there is an amended complaint, you must assert whatever it is that you want to preserve. And if you don't, the fact that you asserted it in response to the first complaint will not help you, because an amended complaint simply takes the place of the first complaint. It's as though the first complaint was not served at all, except for relation back in the statute of limitations.
Thanks so much, Marcel and Matt. We're going to take a break until 11:15, and then we'll pick up with one final session before lunch.
Did you see how I said that? Mark fixed it.
parking, watching other gentlemen mix no angels. I was there 20 minutes after, just to yell at those people with idiotic towels.
Did you keep your shirt on?
Anyway.
You had your shirt on. I didn't. Were you wearing a shirt?
I did not have a cold. This is strained vocal cords. But no, I didn't paint myself either. Okay, where am I? This button. Thanks. Can you guys read this? Because I can't over there. I gotta go. Get glasses. In the past few years, the Supreme Court has redefined how a lower court can be found to abuse its discretion and merged appellate review of civil criminal claims that a judgment is against the manifest way of the evidence. That was the reason that we're up here to talk, but I'm going to highlight those changes. But before I do that, I have to review appellate standards to a bit, from de novo to abuse of discretion to manifest way a little bit, and I'll talk a little bit about what's in between. So, I think one of our earlier speakers noted that the standard of review should be part of every appellate brief and argument. It's probably all you're going to get for advocacy out of me on this, other than stuff to think about. But one thing to think about, some district courts, including the one next door, up there, no, you go back. Appellate Rule 16A7 in the 9th District, for example, says each assignment of error shall be separately discussed. That's in Appellate Rule 16. But it shall include the standard or standards of review applicable to that assignment of error under a separate heading placed before the discussion of the issues. I think every judge over here, since it, would appreciate that in embracing the 8th District too. Especially if you guys are disagreeing about what standard of review is being done. So, talking about standards of review, let's talk about the definition. There it is. Definition. Anyone? Okay. Generally, these judges interrupt me. And they're being very nice to me today. So, what's standard of review? So, like any good appellate lawyer, what did I do to prepare for this? I tried to find a definition. I went to the Ohio Revised Code, my favorite place to find anything in the law, because that tells us what we have to do. It wasn't there. There's no definition of a standard of review. They say to use some standards of review. No one ever defines it. I went to the Ohio Constitution. We seem to amend it every couple of years. Maybe it's there. It tells us that we can overturn cases on manifest weight of the evidence, which is standard of review, but it doesn't tell us what that means. So I went to Judge Painter's appellate practice book. I went through it, it's this thick. I went through the table of contents. Surely there was a definition for standard of review. There wasn't. So I went to the dictionary. And guess what? It's not there. It's not there, and that's the latest edition of Black's, or the latest edition that I could afford. So I had to come up with my own definition. So this is just one way to think about this. One way to think about what a standard of review is to look at what the purpose of the courts are, right? So we have 3 levels of courts: the trial court, appellate court, Supreme Court. What am I on? Thanks. Trial court serves to do what? Resolve disputes, right? They can't handle it themselves. They go to the trial court, file a complaint, answer. We heard all about that. How to get those dismissed in the last half hour. But they serve the problem is you have 2 kinds of cases, civil and criminal. And so maybe we're going to have some different standards of review for those kind of cases. The Supreme Court serves to do what? Someone please help me. They make the law. Okay. Maybe I should ask this question. What does the Ohio Supreme Court have to do? They actually have in the Constitution and some statutes.
Okay, they have to resolve cases in which they have original jurisdiction.
Thank you. That's exactly what I was going to say, David. You actually paid attention back in law school. So, they have to do certain types of cases, but for the rest of the time they're there, the other 11 and a half months that they are sitting, what do? Whatever they decide to do. Right? So, and we heard about this in the manual earlier, didn't we? They decided that the Supreme Court gets a capital C, but the trial court doesn't. Yeah, so they get to do whatever they want to do. Now there's an appellate, and so we know there's 3 levels. Middle level, or actually the most important level, because this is where all the appellate work gets done. Appellate court serves to do what? I'm not going to ask you, because I'm going to run out of time. Serves to review a trial court's resolution of dispute. It's that simple. That's what we're there for. The assignment of error. They did this wrong. We're going to tell you if they did it wrong or not. Important about some of the limits on the appellate court, it has to be a final order. So those 12 B's are kind of iffy. But what's the goal in resolving the dispute? When I'm thinking of, now remember I'm saying this in the context of trying to define what a standard of review is. So if we think about the goal is to ensure that the trial court used the correct law and procedure to resolve the dispute. If that's a primary goal of the appellate court in Ohio, then we can kind of understand what a standard of review is. Standard of review is applied to certain aspects of the trial court's resolution of the dispute. And it's dependent upon what the trial court decision is being reviewed. Okay, so if we're reviewing a verdict, we use a manifest weight standard. If we're reviewing the introduction or exclusion of evidence, we're using standard. Someone say it.
Well, that would be abuse of
Well,
discretion.
everyone knows that you're all lawyers and smart. Abuse of discretion. Thank you. So, earlier we had a presentation where someone asked, how do we decide which standard of review to apply to which decision? I have no clue. But the federal courts actually kind of tell us, give us guidance. They say that there's 3 basic categories of decisions, and you review them on appeal with different standards. If you're talking about a question of law, we look at de novo. If we're talking about questions of fact, we review it for clear error. We never use that in Ohio. We never say that, but we have it in a couple of standards. And decisions on matters of discretion are reviewed for, to be redundant, abuse of discretion. We kind of follow those guidelines. We just never put them out there. So if an appellate court uses the standards of review and applies them to different aspects of the trial court's resolution of dispute, what do those standards of review do? And I think I'm getting to a circular definition, but we'll get there. Do they ensure uniformity in appellate decisions? I don't know. Okay, they kind of do. Look, see, she's cheating. Yes, I'm there. Do they make opinion writing easier, Judge?
Yes.
Great. Psychic. So they actually, standards of review serve a lot of purposes, but for this half hour, 20 minutes that I get to talk to you, I have one way of thinking about it. Standards of review determine the amount of deference an appellate court gives to the aspect of trial court's decision being challenged by the appellant.
You know, when I thought about this, I was trying to come up with what is a standard of review. So I looked at its purpose. It determines the amount of deference. Now, I just used the word deference. So I know you're all smart, you're all lawyers, you all have fast minds. You're thinking to the last slide. Because that's the big dispute, manifest weight of the evidence. So, don't jump ahead of me. Okay, anyone, how many standards of review are there in Ohio? I came up with an exact and precise and technical definition. How is it? Okay. But guess what? All of them fit a pattern. De novo review. What is it? Over again, right? And in the context of my definition, what does the de novo review do?
Without deference.
You're cheating. You can't look over. You can't look at me. Thank you. No deference given, right? Whatever the trial court did, we don't care. So, summary judgment. What do we do? How do we review it?
They know.
But, thank you, John. Exactly. That's why there's no definition of standard of reviews, because not only do we apply one, we apply another one. And what is, I mean, I don't even know anymore, but what's the standard of review, Judge Boyle, of an agency decision going to the trial court appeal to our appeal? But what happens when it gets to the Supreme Court? What do they do? I have no clue. I really don't. Anyway, de novo review. What about abuse of discretion review? Again, I came up with a highly, highly technical and precise, right? We're all lawyers, right? Any scientists in here? No? Any patent lawyers? Any engineers? Okay, so you guys know that this is as precise as we get. Lawyers, right? An abuse of discretion review is, there's a lot of deference given. Okay, that brings me back to the 12B6, the venue, 12B3.
Venue is B3.
I paid attention. 12B3, you asked, why is that reviewed abuse of discretion? I'm going to answer that at the end of my abuse of discretion.
I look forward to it.
There is a reason, and I think I figured it out after reading a few hundred cases in preparation for this, to come up with these technical definitions. So, manifest weight. Come on, everyone knows. Everyone knows if we gave no deference and we gave a lot of deference, my technical definition, a really lot of deference, right? So, the standards review they just exist on a continuum from no deference to a great amount of deference.
These are coming back in appellate briefs at us.
And I hope they come in a separate section so we can ignore it. No deference given, great amount of deference given. What happens if there is no deference given? Do we have that standard of review? No. Yeah, no deference. What if we give complete deference? Is that a standard of review that we have? No, because then that wouldn't be reviewable. Except, there's always exceptions. Anyway, so so now that I kind of put you in the mind frame to think about what a standard of review actually is, let's talk about abuse of discretion. Prior to 2021, the common definition, who wrote that, who read it, who knows it by heart? Everyone? And abuse of discretion is more than the error of law or judgment. I highlighted that part. We know what it's unreasonable, arbitrary, unconscionable. I don't know what those mean. Because if it's not reasoned, it's no good. If it's arbitrary, it's a dark. If it's unconscionable, no one could ever do it anyway, right? But that doesn't help. I mean, how is something that the trial court admits evidence and says A, B, C, and D, that's why I'm admitting it. It's reasoned. So I don't understand this that much, but we're going to talk about more than an error of law or judgment. Where'd that come from? There's one thing to note here, 1940 syllabus law. Does everyone miss syllabus law? I sure do. They talk about the meaning of the term abuse of discretion in relation to the granting of a motion for new trial. And they said it connotes more than error of law or judgment. Where did they get that from? No one knew, because no one ever read a case from 1940 in this room, probably. I don't see anyone old enough to do so. But in 2010, Second Appellate District Judge Fain said, wait a minute. This whole Steiner, quoting Blakemore, said, called that definition an offensive formulation in State v. Bowles in 2010. And they said, oh yeah, he actually went and read the 1940 case Steiner and said, oh, you cited the second edition of Black's Law, which in the 10 sub-definitions actually had an abuse of discretion could be more than an error of law. But he then pulls out the 11th edition, finds out it doesn't work, and he says maybe that definition came when they were trying to make a point. When a curative law is involved in appellate review, the mere fact the reviewing court would decide the issue differently is enough to find error. But in contrast, the issue on review has been confined to a discretion of the trial court. The mere fact that the reviewing court would have reached a different result is not enough to find error. So let's go back to your venue. If venue is proper in 88 counties in Ohio, if the person lives in Ohio, right? The judge gets a motion for change of venue. Is the judge mandated to do anything? Is he mandated to move it?
Yeah.
Is she mandated to keep it?
Not on an abuse of discretion review, no.
No. In the law, you said it's a venue, and I know that there's like two standards that are kind of there, but they're amorphous, and it's hard to really prove them. But the judge can keep it or not.
Yes.
That's why it's reviewed for an abuse of discretion, because either resolution of that dispute or that aspect of the dispute is correct. It's not mandated to do anything. That's why I think we apply that abuse of discretion to certain things. That's what, and I couldn't find someone saying that because no one wrote a definition of standard in the case law. But that's what I think is happening with abuse of discretion. But anyway, after 2010, how long did it take for Judge Fain to be listened to? Anyone know?
80 years?
11 years. The Supreme Court took note in 2021 in Johnson versus Abdullah. They said, and they acknowledged, hey, we said this. We actually said that it implies that the attitude is more than the error of law or judgment is the standard. And you know what? Some judge down in the second district said this is offensive. And then they went on and looked at Black's Law from the second edition to the 12th, I think wrong, or whichever. And then they did something which they're only allowed to do. They said, oh yeah, Steiner, we got to put that in a box and say, yeah, that was about a motion for new trial. That really wasn't what we were talking about. And they went through and explained that not a trial court, notice the small c, not an appellate court, notice the small c, but not even the Supreme Court. They didn't write the manual, it just came out after this. They used a small c, has the authority to commit an error of law. So, that was in 2021. What was going on before when we were all practicing law, which I'm going to go back to Blakemore and Johnson, quote, more than error of law. I found 2,500 cases citing to it as being more than error of law up until Johnson. Anyone have a guess as to how many cases cite that after Johnson? Only 116. Congratulations, judges. And more than a significant amount cited it to say this is not what we're talking about. So that's what an abuse of discretion is. That whole concept of making an error of law. Anthony, does that end it? Judge makes an error of law, and it's reversed, period.
Not if it doesn't matter. Not if it's not.
So you're telling me that there's a standard review of abuse of discretion? Could it be harmless error?
You're running out of time.
Oh my gosh. Manifest weight of the evidence. Sorry, guys, I'm having too much fun with you. Manifest weight of the evidence. We have civil cases, we have criminal cases. Are there two different standards? Anyone? Civil lawyer? Criminal lawyer? Criminal lawyer up
Sufficiency
there.
of the evidence?
Huh?
Sufficiency of the evidence?
There's a sufficiency standard, but I'm talking about manifest weight. Appellant asks says manifest, this verdict is guilty versus manifest weight of the evidence.
I know you know the answer.
Standard's the same between the two cases.
There we
It's
are.
supposed to be.
It's supposed to be, correct. It's supposed to be easily, versus Volkman, 2012, gave 3 reasons, it's the same. What slide am I at, Easley? Yeah. Prior to 2012, there was a civil standard used. Civil standard would confuse the sufficiency standard of review in a civil case, which gives great deference to the trier of fact. See this, where am I? Now I'm trying to get through this. Okay, manifest weight, there's one standard, it comes from State versus Tompkins. Okay, I want to talk about Seasons versus Cole, which was a statement about the civil standard before it was merged. I think I skipped it, unfortunately. The rationale in the Supreme Court in 1984 said in the civil standard, we're going to give some deference. We're going to give deference to a trier of fact's decision. In other words, it's kind of circular. They came up with this verdict, so when we're reviewing it, we're going to give deference about that verdict. But then Easley talked about why we only have one standard. And so what is manifest weight standard now that we have one after Easley? It says that, and State versus Tompkins in 1997 said that Court of Appeals may determine that a judgment of a trial court is sustained by sufficient evidence, but reverse as against manifest weight. So we know we can do that, and we know it takes 3 judges because that's in the Constitution. To do that, it concerns, and this is what Tompkins first said, that decision on manifest weight is the inclination of the greater amount of credible evidence offered in the trial to support one side of the issue rather than the other. It indicates that the jury, that the party having the burden of proof will be entitled to their verdict if, on weighing the evidence, they find the greater amount of credible evidence sustains the issue to which is to be established before them. And this is what I like, because we're not scientists. Weight is not a question of mathematics, but depends on the effect in inducing belief. So if something is against the manifest weight, it means it didn't convince you. It also, Tompkins also went on to say when a court of appeals reverses a judgment of a trial court, that it's against the manifest weight of the evidence. And we've all read this. The appellate court sits as a 13th juror, disagreed with the finder's resolution of conflicting testimony. I want to go back and pretend we're all the Supreme Court justices and look at Steiner, that they put it in a box. I want to think about this as when we use this 13th juror analogy, that we remember that Tompkins said this is when we're looking at conflicting evidence, not when we're looking at the entire case. I think that's where we're at, and then we have the complete standard, which gets to what it's about. It says, whether in resolving a conflict in the evidence, the jury clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a new trial ordered. And that power should not be used except in the exceptional case in which the evidence weighs heavily against the conviction. So we know that what we're doing here with manifest weight standard, in general, we're giving that entire case and that verdict and what supported it some deference. We're giving it a lot of deference because it has to be patently and completely wrong to be reversed under the Townshend standard. So it's clear, right? Everyone understands that. Not really, because in RZC, the United Supreme Court in 2023 last year addressed the standard review to review a juvenile court's award of permanent custody. Okay, and this is where that old civil standard was coming up into play. And in ZC, they said, knowing that there was one review, they repeated the Tompkins overall manifest miscarriage of justice language, but then talked about giving deference to the finder of fact. And that was in 2023, after 2021, after 2011, with Easley saying there's one. Tompkins doesn't talk about that deference, but we still have that appear in RZC. Now, that deference was used in a civil case to determine whether the case was sufficient, and it was going to be found to be sufficient if there was some kind of credible evidence going to every aspect. Civil or criminal has a slightly different sufficiency. There's only one manifest weight of the evidence standard to be used, but does that, I think the real issue coming forth because of RZC and because of Tompkins and because of Easley saying we only have one, is there any deference to the finder of fact or to the verdict in a manifest weight review? And I'm ending now and giving these guys this, but if you really want to know the issue,
You're not answering a question.
I'm not answering a question. For once, I get to appear before all these appellate judges and not be an advocate. So take a look at State versus Riello. It came out last week or the week before, and it's 3307. It's not, and the 8th District should be in parentheses. I guess I didn't read the manual. So now I know. Thank you. If there's time for questions.
This is why you don't split your time in oral argument. It never works. So our second half is on sealing and expunging because, as you know, the laws have changed a lot. What is the difference? What is the current status of the law? So we brought in 2 experts on that topic as well. We have Anthony Miranda, who's been an assistant Cuyahoga County prosecutor for over a decade dealing with appellate, post-conviction, and expungement issues. And we also have Tom Lampin. He's an assistant county public defender's office, also deals with appellate, post-conviction, expungement issues, and, side note, has been part of a team that has actually argued before the United States Supreme Court and won. So with that, I'm going to let you take off because we kind of cut into your time. Thank you, guys.
Yeah, let's see if we can get this done in 30 seconds a slide. So, yeah, just right off the bat, what is sealing and expunging? Generally speaking, they're both ways to sort of get rid of a criminal record, right? They work a little differently on the back end. They go a little bit further or not as far. But the general idea is, you want to restore someone's legal rights, the right to own a gun, things like that, and you want to repair their reputation, making them amenable to employment, housing, things like that. We'll get into some of the differences on the back end in terms of what they do, but they sort of work the same way. It's the same statute that creates them. It's the same basic process you go through. So the threshold requirements, if you're going to get a record sealed or expunged, first thing you got to look at is whether the underlying offense qualifies, and we'll dig through that, but your crimes of violence, higher degree felonies, not going to be eligible. Step 2, you got to make sure that the case you're working with has been finally discharged, right? So if they're still on probation, you're not eligible yet. If you haven't paid your restitution, you're not eligible yet. Court costs are a little different. They can still get your application denied ultimately, but it's not an eligibility threshold. It's just a small distinction to be aware of. You can't have any other cases active separate from the one you're getting sealed or expunged. And there's waiting periods for different degrees of offenses. You can seal a misdemeanor pretty quickly versus a felony. You're waiting typically a couple years.
So we wanted to start briefly with how much the law has changed. So from 1975 to 2012, Ohio had what was called the first offender law. So what that meant is that you could only seal a conviction if it was your first offense. If you had a second or a third offense, any other misdemeanor or felony offense, you could not obtain relief. And so we've got an example of that in 1975. Somebody was convicted in 1966 of embezzlement. 8 years later, they moved to seal that conviction, but they're not qualified because they have a prior assault and battery conviction. So that's the law for more than 30 years. It's a very restrictive eligibility criteria. In 2012, the first offender concept is eliminated, and the General Assembly adopts an eligible offender definition, and the definition is basically the person has not more than one felony, not more than 2 misdemeanors, or not more than 1 felony and 1 misdemeanor. So a little bit of wiggle room. You can have a second conviction, but still not a lot of eligibility. The big change came in 2018 when the General Assembly widened it out to include up to 5 felonies of the 5th or 4th degree. And so it was that change where we started to see people with drug offenses and theft offenses where you're more likely to see multiple convictions obtaining relief.
All right, so where we're at now, 2023, the legislature made another really big expansion on who's eligible and what is eligible for expungement. And the way things work now, the focus is generally on the underlying convictions themselves when you're looking at eligibility, for the most part. First and second degree felonies, never going to be expungible, at least under the current law. Any violent felony is not expungible. A violent misdemeanor can be expungible. And one important thing to note here, sexually oriented offenses now can be expunged as long as you're not a registered sex offender anymore. So while that registration requirement's in place, you can't get your record sealed. And separately, any offense against someone under the age of 13 is not eligible. That's not just sexually oriented offenses. That's if you knock over a lemonade stand, you can't get that expunged either. The main takeaway from these changes, it doesn't feel like if 2023 was just a year ago, right? So as of just as recently as last year, there's a large number of now sealable or expungible cases that weren't eligible even just a year ago. If you have any number of 4th or 5th degree felonies, violent misdemeanors, low-level sex offenses, not too long ago, those weren't something you could seal or expunge. Some numbers Anthony gave me just to kind of give you a sense of the scope here. Since eligibility has been expanded, we're seeing around 3,000 to 4,500 expungement applications per year. Anthony's also quoted me that there's about 10,000 people getting indicted every year. So, kind of looking at these trends, looks like these numbers are pretty much going to stay where they're at. About a third to a quarter, a half or so of what's being indicted in Cuyahoga County eventually becomes sealable or expungible. So we're going to keep seeing these numbers. And that's a lot, right? There's a lot of these to deal with. I know Anthony's office is kind of managing drinking from a fire hose here. Now you might have noticed there was a little bit of a gap when I was talking about what's eligible and what's not for 3rd degree felonies. This is where the statute works in kind of a strange way, a little bit more like it used to work prior to 2012, where you look at the overall criminal history. That's the statutory language there, but here's kind of mechanically how it works. If you just have one third-degree felony, you can get that sealed as long as you don't have more than 2 other felonies. So 1 F3, 3 total felonies, you're in good shape. If you have 2 third-degree felonies, those can be expunged as long as that's it. You don't have any other felonies, and you don't have more than 2 misdemeanors. So a little bit less permissive there. And if you have 3 third-degree felonies, you're going to have them forever. Those can't be sealed or expunged. Mechanically, it works a little differently depending on how those convictions are arranged. And the thing to keep in mind here, you can't half seal a case, right? You can't half expunge something. You can't half destroy a file. So if you have eligible and ineligible convictions in the same case, that's not eligible. But if they're in separate cases, you could at least seal, for example, some 5th-degree felonies, even if those are preventing you from sealing a 3rd-degree felony.
I have a question.
Yeah.
So what you just said, does that mean like if someone gets to felony court on the OVI misdemeanor, but then they find other stuff in the car, guns, drugs, whatever you want to name it, those won't be eligible because the misdemeanor OVI is not eligible to be sealed or expunged, so then the rest of them can't be?
If they're all in the same indictment and it's a part of one conviction, then yeah. And as another note, you can't seal your misdemeanors to get under that threshold and then come back and seal your felony 3s, because a sealed conviction still can be accessed by a court. Yep.
On your OVI cases, though, make sure you take a look at the rule about sealing multiple records, because if you obtain a resolution on the OVI that is not itself an OVI or I believe a physical control, you will be able to seal that record. So if you can get it down to something that's not an OVI, you may be able to seal the felony record that came out of it or other misdemeanors that came along with it. And it's in that rule about sealing records of multiple cases that you see that bit about OVIs specifically.
Great point.
So we're just going to move a little quickly through some of these. Obviously, the details and sites are all in the slides. Final discharge, that means you got to be done with your prison sentence, done with your supervision, pay your fine, pay your restitution. You don't have to pay court costs to achieve final discharge. If you have any pending criminal proceedings, that's going to disqualify you. So if you have a pending indictment or complaint somewhere, you got to resolve that first. If you have arguably an active arrest warrant, that's going to disqualify you until you resolve that. There's currently a conflict among the districts about whether or not being on probation in a separate case would disqualify you. I don't know that the 8th District has answered that, so that's something to be aware of. There are specific waiting periods for you to wait after you have achieved final discharge, so depending on the level of the offense. For example, if you're convicted of a sexually oriented offense, you have to wait 5 years from final discharge, and then to seek to expunge, you would have to wait another 10 years to achieve eligibility for that. And so that's just a chart that Tom has.
So real quickly, just to get through the differences between sealing and expunging, probably a nice top-level way to think about it is sealing a record kind of controls access to it. It removes the public's ability to find it and limits who else is eligible to look at it. An expunged record, the file is physically destroyed and can only be used in very, very specific circumstances. With sealing, you can probably imagine generally the occupational screenings that can access that, healthcare, education, that type of thing. And a sealed conviction can come back if you're applying to seal another conviction. That's why you can't kind of chain your way up to sealing a F3. Expungement, little different. Like I said, the file is physically destroyed, except in very, very narrow circumstances, really outside of applications to become a law enforcement officer, or if for whatever reason you got convicted of something that disqualifies you from holding public office. Those are some of the only circumstances where a expunged conviction can be used. They can be introduced in court, but not for purposes of sentencing. A sealed conviction can be used for purposes of sentencing as an enhancement. expunged convictions can't.
So we just lay out the process, at least in terms of how it works in our common police court here. Generally, you file the application. Prosecutor now has a statutory obligation to notify victims, which did not previously exist, and so that's happening at the beginning. The court has to order the probation department to prepare a report. The prosecutor then files a response once the report is obtained. Typically, if the prosecutor and the victim are not opposing, typically these are granted without a hearing. If there's some kind of opposition, then a hearing is scheduled. This is just an example of a report, how to read it, what to look for the relevant parts, the relevant conviction, whether there's financial obligations outstanding, whether there's pending criminal proceedings.
So those EIRs are really important. Like that's how the state's response gets formulated. That's the main thing the court looks at. Just from having worked on a lot of these are some things that can come up. They're common enough, you'll probably run into them eventually, but they're weird enough to take up time to resolve. The main, probably the most important one, not a lot of times, because the court changed how its payment processing worked in 2007, you can run into a situation where your client paid their restitution, paid their probation fees, their fines, but it doesn't show up in the court's accounting system now. I know when it happens, but I don't know why it happens. And you can get that resolved. You can go to the finance department, get an old statement for the pre-2007 accounting system. But that's gonna flag on the investigation report and make it look like they're not eligible when they are. I've run into instances where someone else with the same name has charges, and those show up on an EIR. Anyone who's done criminal defense has probably heard their clients say, no, I swear that wasn't me. But sometimes that is actually true. And it's pretty easy to resolve ultimately if you dig into it a little bit. Birth dates, addresses won't match up. And lastly, convictions from different jurisdictions, they can show as unresolved or as still pending when they're not. And that generally you want to call a out-of-state clerk's office and ask them, because you never know. Sometimes they'll say, oh, we dismiss everything if it's been inactive for 5 years, and that's not reflected on the docket, but your client doesn't have an active case. And very briefly, there's some legal issues surrounding the need for a hearing as just bottom line practical matter. If the court is going to deny the application, they pretty much have to hold a hearing, or they risk getting reversed. If they're going to grant it, I know the state's been waiving their right to a hearing. So if you're going to get it granted, you might not have to have a hearing.
So there's more material in there, but maybe we'll end there and ask if there's any questions.
Yeah, go ahead.
The trial court converts restitution to a civil judgment. Is restitution paid? Is it eligible for expungement?
You want to repeat the question so everyone can hear?
If the trial court converts a restitution order to a civil judgment, does the offender become eligible to expunge?
That's a good question. I would think so if it's no longer part of the sentence, because the issue with restitution is you need final discharge. If that conversion gets it out of part of the sentence, then I would think so. But
So there's a case pending in the Supreme Court, TWC, which is 2024-0265, where trial court basically waived restitution, and the 10th District upheld it as kind of being civil in nature, and so the Supreme Court has that in front of it now.
I was going to say, I had that exact issue in our problem. The court didn't think that they were ineligible, but the problem we ran into is the trial court judge didn't like it.
That's always a problem.
one thing I do want to toss out here real quick is in the materials there's a template letter that you can give to your clients if down the line they get their sealing, they get their expungement, but commercial background checks still show the conviction. There's some federal law that governs background checks, and this kind of walks through how that would work, but that's just available for you down the line.
Well, Matt makes a good point. Say you meet all of the qualifications, but the trial court's inclined to deny the application, and then if so, what standard would apply on review?
It seems to me that you all have written repeatedly that it's an act of grace and that it's an abuse of discretion standard.
Yeah.
That's right. Yeah.
Okay, we'll be here for a minute if anyone has other burning questions. Do I get to announce lunch? So, okay, free lunch out in the hallway. Grab your lunch for 15 minutes and we'll get started at 12:15. Thank you, everyone.
I'm used to it. Everybody's saying, she's been talking to me for years.
Hello, everyone. We're going to get started for our lunchtime segment. Please continue to eat and enjoy your meal. My name is Erin O'Toole. I'm the court administrator at the 8th District Court of Appeals, and I want to thank Case Western for partnering with us again this year. They've been very supportive, and we really enjoy putting on the seminar, which is a lot of work, to which I want to also thank our Court of Appeals judges and staff who put this together for you, and it's at the right price, free. So in this segment, because it's lunchtime, we want to keep it more interactive. So please, these are going to be the landmark Supreme Court cases from the Cleveland area. And we have the honor of having Professor Jonathan Enton, who is the David L. Brennan Professor Emeritus of Law at Case Western Reserve University, teaching us about this. He has a very distinguished bio that's in your material, so please take a look at it. But to highlight a couple things, he's published over 150 articles, books, chapters, essays, and reviews, appearing in prestigious publications at schools as Harvard, Yale, Columbia, Northwestern, and Texas. He also has been published in a number of social science periodicals. I think this is going to be a great presentation because among his many awards, 5 graduating classes honored him as the Teacher of the Year. 2 other classes selected him as Administrator of the Year, and the Law Alumni Association gave him its Distinguished Teacher Award. So I feel like we're going to get a great education here today about all these landmark cases out of our area. Also, I was impressed to learn that he was a law clerk to Justice Ruth Bader Ginsburg when she was a judge on the U.S. Court of Appeals for the District of Columbia Circuit, and he did appellate litigation at Steptoe and Johnson in Washington, D.C., where he helped to exonerate an innocent man who came within hours of execution. And when I was speaking with the professor prior to his presentation, he noted that as one of the most significant things in his career, which I think is very telling given the impressiveness of his resume. So without further ado, we are going to take calls or questions from Zoom. So please submit your questions that way as well, because I understand we have a large Zoom audience. Thank you, everyone.
Thank you, Erin. I feel like what I'm going to talk about, some of you probably know more about some of these cases than I do, and so I do want to encourage questions and comments as we go along. I'm honored to be here, if only because we hear a lot these days about the disjunction between the bar and the legal academy. And programs like this bridge a big piece of whatever gap that may be. Thank you for having me. Now, as the title of this talk indicates, a fair number of important Supreme Court cases arose in Greater Cleveland. I first became aware of this after I arrived here to join the faculty more than 40 years ago. Until that point, I had never been in Cleveland except to pass through. That's not an editorial comment, it's just like I never had occasion to be here. Now, to put it kindly, I am directionally challenged, so I have a really hard time finding my way around. And sure enough, I was having trouble navigating around Greater Cleveland. But then I noticed, as I said, a fair number of important cases arose in Greater Cleveland. And so I decided that maybe I could get a better sense of the geography if I figured out where, the sites, that's sites with an S, not sites with a C, right? But if I could figure out where some of these cases happened, I'd have a better sense of the layout. So I did that, and then in the spring of my first year on the faculty, I was asked if I would contribute something to the annual faculty auction. And so I decided this might be different from, say, the typical host some students for lunch or dinner or something like that. I mean, those are a lot of fun, but I figured this might be sufficiently different, and it sort of took on a life of its own. So I have done this tour, I've done this legal history tour almost every year since I've been here. Today is a little different because usually I do this in a motor vehicle of some sort, and we are actually driving around. Sometimes the vehicle is a car, sometimes it's a van, and a few years ago it was a bus because somehow Chief Judge Sutton of the Sixth Circuit found out about this tour and he roped me into giving it as part of the Sixth Circuit Judicial Conference. So this is going to be a little bit different in a couple of ways. First of all, we're not moving. And that means that, at least I'm not, I don't know about you all, but when I do give the tour as a mobile event, it's organized more or less geographically. I'm going to stay a little bit with geography, but today, because we aren't constrained by geography, I'm going to try to organize things as well a little bit along substantive lines. So let's start maybe with perhaps the biggest case that we have had around here, and that's in the zoning area. The landmark Supreme Court case on zoning is Village of Euclid against Ambler Realty Company back in 1926. Now, a little background. Zoning actually began as a device to promote residential segregation. So we had, in the early years of the Great Migration, where a lot of African Americans were moving from the rural South to cities and up north, a number of cities like Baltimore and Atlanta enacted zoning ordinances that, as a practical matter, made it difficult, if not impossible, for black folks to live in traditionally white areas. Now, the U.S. Supreme Court rejected Louisville's racial zoning ordinance in 1917 in a case called Buchanan against Worley. That did not stop efforts to promote residential segregation, but that's a subject for another day. Meanwhile, New York City adopted the first comprehensive municipal zoning ordinance in the country in 1916. That ordinance was ultimately upheld by the New York courts. It never got to the U.S. Supreme Court. So the case that actually got to the U.S. Supreme Court was the ordinance in Euclid. If you look here, I don't have a pointer, but you can kind of see the green stripe on this map that goes southwest to northeast. That's Euclid Avenue. And that's the front of some acreage that Ambler Realty owned. On the west end of that plot was East 196th Street. On the east end, it was East 204th. And the lot actually went back to the railroad tracks, which were the nickel plate railroad tracks. This was a great case, not just because it was the first zoning case to get to the U.S. Supreme Court, although it was. It was a great case because of the lawyers involved. The ordinance had been written by James Metzenbaum, who was the older cousin of Howard Metzenbaum, who served for many years as a U.S. Senator. On the other side, representing Ambler Realty, was Newton Baker, the Baker of Baker Hostetler, a former mayor of Cleveland, former Secretary of War under President Wilson. Now, when the case got to the court, it was argued in early 1926. Justice George Sutherland was not able to participate in the case at that point, and the court deadlocked. So the case was re-argued in the fall of 1926. This time, Justice Sutherland was there, and he wrote for a 6-3 court upholding the facial validity of the Euclid zoning ordinance. Sutherland analogized zoning to nuisance law, and he said, in nuisance law, we figure out whether a nuisance exists by considering a building in connection with the circumstances and the locality. He said, a nuisance may be merely a right thing in a wrong place, like a pig in the parlor instead of in the barnyard. And then he added, if the validity of the legislative classification for zoning purposes be fairly debatable, the legislative judgment must be allowed to control. And so Euclid is the case that made it possible for cities around the country to engage in zoning. Not every city that does zoning does it the same way Euclid did. There's plenty of ongoing debate about zoning, but Euclid is a really important case in this area because the entire history of American land use regulation would have been quite different if Euclid had come out the other way. Now, next case is City of Eastlake against Forest City Enterprises. This is a 1976 case, sort of a special for the 50th anniversary of Euclid. Eastlake is actually the third zoning case that the Supreme Court took. It took after Euclid, 2 years later, it had a case called Nectow against the city of Cambridge. That case said that there were some circumstances in which a zoning ordinance as applied would be unconstitutional if it deprived the owner of all economically valuable use of the property. And then, for the next 48 years, the Supreme Court did not take another zoning case. Well, so this is the Eastlake City Hall. It's the best sort of site that I can think of for this case. But a little bit of background here. Forest City Enterprises wanted to rezone some land that it owned in Eastlake so that it could build a high-rise apartment complex, which would have been a new type of building in the city. And as a result of the controversy that arose from this proposal, the city amended its charter to require that any rezoning decision approved by the zoning board would be subject to a popular referendum, and the rezoning would be allowed to go through only if at least 55% of the folks who voted in the referendum voted yes. Needless to say, Forest City was not happy about this, and they challenged this in the state courts. And Forest City actually won in the Ohio Supreme Court, because the Ohio Supreme Court said that this kind of classification that we're talking about, rezoning was a legislative act, and the city government could not delegate its legislative power. It had to exercise that power by itself. Now, that subject of what legislative power in what circumstances might be delegated has been an ongoing source of debate at the federal level, and I think that particularly in light of the result of the last presidential election, and the fact that several current Supreme Court justices have suggested that they're interested in reinvigorating the non-delegation doctrine, I think we're going to see some cases on those lines. I'm not in a position to predict how they will come out, but I think it is safe to say that non-delegation is going to come back as an issue. Now, so the city, having had its charter provision invalidated by the Ohio Supreme Court, took the case to the U.S. Supreme Court, and the U.S. Supreme Court said there's no unconstitutional delegation of legislative power here, because ultimately authority rests with the people. And this charter provision simply confirms for the people that they have the ultimate power. So no constitutional objection here, the court says. Now, Euclid, or not, Eastlake comes back in a way a few years ago. Some states have independent redistricting commissions. The people in Ohio just rejected a proposal for that here in Ohio. But in 2015, the Arizona Independent Redistricting Commission was challenged on constitutional grounds, and the Supreme Court said, well, and the theory was that the Constitution says that state legislatures are supposed to determine the ground rules for voting, and the argument was the Independent Redistricting Commission wasn't part of the legislature. That was indeed the whole point. The Supreme Court said that, well, Arizona, like Ohio, vests ultimate sovereignty in the people. The people adopted the redistricting commission through an initiative and referendum process, and that was sufficient to bring it within the legislative power. It's the same kind of reasoning that the Eastlake Court used in upholding the 55% supermajority requirement for rezoning in that city. Now, third case in zoning, Moore against the City of East Cleveland. East Cleveland had a really complicated definition of a family for purposes of its zoning ordinance. Only a single family could live in a unit. And it turned out that Inez Moore had a complicated family arrangement. She was in the house, and she lived with one of her sons, a fellow named Dale, his son, Dale Jr., and another grandson, John Jr., who was the son of her other son. And under the terms of the zoning ordinance, because the two grandsons were not siblings, or pure siblings, right? She couldn't live in the house with them. And so the city authorities cited her for violating the zoning ordinance. Basically what we had was the two grandsons were cousins, not brothers, and that ran afoul of the ordinance. Now, I can't show you exactly where the house is. I used to drive past there. The house is long gone. As I recall, and I, subject to correction, I think that this vacant area in this picture is where the house had been. It's actually not very far from here. It's less than a mile. It's over on Garfield Road in East Cleveland. When the case got to the U.S. Supreme Court, the court said it was a 5-4 ruling, and it was 5-4 because the theory basically was that the zoning ordinance violated Inez Moore's substantive due process rights, and those of you who remember your constitutional history know that substantive due process came down to us, particularly from the early part of the 20th century up into the 30s, with a kind of a bad reputation. And so there were some justices who, as a matter of principle, simply would not rely on anything that looked remotely like substantive due process, even though the dissenters in this case actually had a lot of sympathy for Inez Moore. They just thought that it was inappropriate for the court to rely on substantive due process to strike down anything based on that history. Okay. Now, let me turn from zoning to criminal procedure. And the first of these cases is, of course, MAP. My wife and I used to live maybe half a mile from the house where Dolly Mapp got busted. And I once walked her over there to show her the house. And we were greeted by a boy who couldn't have been more than about 8 or 9 years old. And he saw me pointing at the house, and I think justifiably wondered whether I was casing the joint or something. And so he asked me if we needed help. And then I thought for a second, this is actually an obscenity case, and I will explain it in more detail in a second. But I'm thinking, now I'm going to tell an 8 or 9-year-old kid about obscenity. So, you know, I thanked him. I just said something really famous happened here a long time ago, and we were just noting that this is where it happened. Okay, so what happened? Dolly Mapp was the girlfriend of Archie Moore. Archie Moore was a very successful boxer. He was, for an extended period, he was the light heavyweight champion of the world. And when Muhammad Ali was making his way up the ranks to fight for the heavyweight championship, one of the last people Muhammad Ali fought was Archie Moore. Archie Moore fought until he was almost 50 years old, and I don't mean like Mike Tyson coming back. I mean like Archie Moore fought well into his 40s. In fact, there was always some controversy about his age. His mother claimed that he was younger than he said he was, and he at one point explained that that was because he was 3 years old when he was born. Anyway, so Dolly Mapp was involved with Archie Moore. At that point, Don King was in Cleveland, and his house had been bombed. So the Cleveland police started investigating, and I think in part because Dolly Mapp was involved with Archie Moore and Don King was involved with boxing. So the police focused on her to see what they could find out. They thought she was a person of interest in connection with the bombing. So they went to her house looking for evidence. And she told them, as one of my colleagues has a sign on his door upstairs, come back with a warrant. And so the officers went away, and a few hours later they returned with a piece of paper that they waved in front of her that they said, this is the warrant, which she promptly grabbed and stuffed down the front of her dress. And the officers, shall we say, retrieved it. And then they headed upstairs. Now, this is the house, and this is the best picture I can get, and it doesn't really show the relevant part of the house. You can see the front door, but if you look in the driveway, and I tried to get a better angle on this, there is a side door that goes up to the second floor, and that's where Mapp was, right? And when the officers came and forced their way in, they forced their way in the side door, went up the stairs. Now, when they got upstairs, they found some stuff that they claimed was obscene under Ohio law. Mapp argued, first of all, that this wasn't her stuff. It belonged to a fellow she had rented out part of the upstairs to. The police didn't think that that was sufficient to distract them from focusing on her. So she got busted for possession of obscene material. And she defended at trial on the basis that the Ohio obscenity law violated the First Amendment. She was convicted. I mean, she did also argue something about the validity of the search, although it was a little awkward to make that sort of argument because at that time, we're now talking about the late 50s, at that time, although the Supreme Court had held that the exclusionary rule prohibited the introduction of unlawfully obtained evidence in federal court, the Supreme Court had also said that the exclusionary rule did not apply to the states. That was a case called Wolf against Colorado from 1949. So Mapp's main defense, although she did say something about the Fourth Amendment, her main defense was that the law violated the First Amendment. So he takes the case up to the Ohio Supreme Court on appeal, and if you read the case in the Ohio Supreme Court, you see the court lays out, Mapp says that this law violates the First Amendment for these reasons. Right? Here's what the law says, here's what we think the First Amendment means, she's right. This law does violate the First Amendment. And there's a nice discussion, at the very end of which there is a quaint paragraph that says, however, only 4 of us, now remember, this is 4 of 7, right? Only 4 members of this court agree that this law violates the First Amendment. Under a provision of the Ohio Constitution that was then in effect, that had been adopted in 1912 as a progressive reform to keep courts who were enamored of substantive due process from striking down progressive reforms, the voters in their wisdom amended the state constitution to say that no, the Ohio Supreme Court could not strike down any law as unconstitutional unless at least 6 of the 7 justices agreed. 4 is not 6, conviction affirmed on this point, right? So anyway, so Mapp winds up appealing to the U.S. Supreme Court. She did, in fact, raise the First Amendment argument there, but the U.S. Supreme Court decided that it wanted to revisit Wolf against Colorado, and so this is the case in which the Supreme Court overruled Wolf to the extent that it said that the exclusionary rule did not apply to the states, said it did, and by the way, the search in this case was unlawful, and therefore the state had no basis for prosecuting Mapp because the evidence, all the allegedly obscene material had been unlawfully seized. So, now, for what it's worth, going back to the warrant, the Ohio Supreme Court noted that no warrant was ever introduced at trial, and the court questioned whether that piece of paper that the officers waved actually had been a warrant, although that turned out not to matter to the way the case turned out. Okay, one more, Terry against Ohio. I think most all of you know about this. This is a case that's downtown. You can see Euclid Avenue and Huron going off to the side. This is an old photograph, but I think this old photograph kind of captures what was going on. Okay, there is a historical plaque downtown near here that notes Detective McFadden, who noticed Terry and a fellow named Chilton on a Thursday afternoon. He saw them pacing up and down, first along Huron and then along Euclid. At some point, they stopped to talk to a third guy, a fellow named Katz, who went away. They kept pacing back and forth, and Officer McFadden decided, or Detective McFadden decided that this was suspicious, right? He didn't have probable cause to stop them, right? But he stopped them anyway, and he frisked Terry and felt a firearm under his coat. He eventually took Terry and Chilton into custody, and this case winds up in the U.S. Supreme Court, where and by the way, I think Terry was represented by Lou Stokes, who used to talk a lot about this case because he had been in it, he'd been involved in it so extensively. And I think, as you all know, the Supreme Court said that you don't need probable cause to do a stop and frisk. You just need reasonable suspicion. And although there was certainly plenty of debate about whether the fact that Terry and Chilton were pacing up and down gave grounds for reasonable suspicion, Detective McFadden said, look, I've been doing this for 30 years. This looks suspicious to me, and the courts accepted that, and so that's how this case came along. Now, one last one in the criminal procedure area, that's Shepard against Maxwell. I think most of you know about this case. I was struck by how many people to this day have very strong views about the Shepard case. Now, a lot of the people I know who have strong views think that Sam Shepard was framed, and a lot of other people I know who have strong views are convinced that he killed his wife. I have not tried to sort that one out. I don't, right? But it is striking to me that this case, this murder took place on the 4th of July in 1954, so it's more than 70 years, and we still have people who are strongly invested in whatever version of things they had. Now, so Sam Shepard was an osteopathic physician, and I think whatever actually happened in this case, the fact that Sam Shepard and his father and his brothers were osteopaths has something to do with the way a lot of the professional classes in Cleveland looked at him. My dad was a family doctor who was making house calls in his 80s. He was an MD. Right? You never wanted to get him started on either chiropractors or osteopaths. And I think his views were pretty typical, right? So the Shepards were already looked down on by the MDs, of whom there are so many and have been so many for so long here. So that didn't help. It also didn't help that apparently back in the 50s, the Shepards used to perform abortions for the pregnant female patients of some of their MD colleagues who, because abortion was unlawful in Ohio, would simply do referrals. Again, how much of this, that's all useful background. How much of it explains what what actually happened in the case, that's a whole other matter. But now, I'm not sure if this is the actual house. In fact, I understand that the house was later taken down, but this is the location of the Shepherd House over in Bay Village, right? And the history is pretty well known. This Shepherd was tried in a kind of a circus atmosphere. The Ohio Supreme Court described the proceedings as having been conducted in an atmosphere of a Roman holiday for the news media. Lots of inflammatory coverage. There was a radio station that was given space literally next door to the jury room during the trial. There were wires and mics all over the inside of the bar in the room. In any event, when this case got back to the Supreme Court spent 15 pages simply summarizing the atmosphere surrounding the trial. Now, Shepherd was convicted at trial in 1954. The Ohio Supreme Court affirmed the conviction. The U.S. Supreme Court denied cert, although Justice Frankfurter, who used to talk about the significance of a cert denial, Justice Frankfurter wrote a separate statement saying, don't take the cert denial as necessarily an endorsement of what the Ohio Supreme Court did in this case. But that looked like the end of the story until a few years later, a then young lawyer named F. Lee Bailey decided that maybe he could try to get a habeas case going, and in fact, that's how Shepherd against Maxwell wound up in the Supreme Court. The court wound up setting aside the conviction precisely because of the inflammatory atmosphere surrounding the trial. Sam Shepherd was then acquitted on his retrial, and then, as I recall, he for a time he was a professional wrestler and died in 1970. The last piece of the Shepherd against Maxwell story is that years later, the son, Sam Reese Shepherd, who was 7 years old at the time that his mother was killed and slept through whatever happened, brought a wrongful imprisonment case against the state, and without going through all of the procedural hurdles, the Ohio Supreme Court refused to decide up front whether the cause of action died with Shepherd himself, Sam Shepherd, or whether maybe the estate might be able to maintain the action, and without addressing whether there were statute of limitations issues, sent the case back to the lower courts where it was tried, and the jury came back and ruled against the wrongful imprisonment claim, at which point Sam Reese Shepherd's lawyers appealed to the 8th District, and the 8th District then concluded that the claim was personal to the defendant, Sam Shepherd, and in any event, it was years too late because we were now talking about more than 30 years since Sam Shepherd had been acquitted at trial. Okay. Now, I want to talk a little bit about the First Amendment, partly because I spent years teaching the First Amendment. And I'm not going to spend a lot of time talking about Jacobellis because Judge Gallagher did a wonderful job last year talking about this case, and I really can't add much to what he had to say. But let me at least, this is the old Centrum Theater building, which is where the movie was shown. A couple of things to think about. A friend of mine who clerked for Justice Potter Stewart said that Justice Stewart said in the interview that he was convinced that he would go to his grave remembered only for having said in Jacobellis that I can't define obscenity, but I know it when I see it, and the movie at issue in this case is not it. Fair enough. Now, Jacobellis is not a great case except maybe for that line. It's a 6-3 ruling. There are 4 separate opinions siding with Jacobellis, none of which is subscribed to by more than 2 justices. And one of the 6 justices simply says, I side with Jacobellis, but he doesn't say a word about why. Right? So I know it when I see it may actually capture what was going on in this case. Now, I should say, just from my perspective, I have a little connection to this. I had never seen the movie in this case, Les Amants, The Lovers, for years and years and years, until the Cleveland Heights Historical Society brought the movie back to mark the 50th anniversary of the bust. And so I called over to the Historical Society to see if I could get some tickets for my wife and my mother-in-law and me. And when I told them who I was, they said, would you talk about the case? I said, on one condition, and that is that you let me bring Peter Krause, who was at that time a Plain Dealer reporter and is now writes for Cleveland.com, because Pete Krause had apparently found out about my tour and that the Centrum Theater was on it. He was doing a big story about the case, about the bust. And so he came to talk to me. We had a good conversation. He didn't really need to talk to me. He had a whole lot already. But he drove me up to Euclid Heights Boulevard, parked there, stood me in front of the theater, and had a photographer snap a picture of me under the marquee, which ran on the front page of the Plain Dealer, below the fold. And for several months afterwards, some of my colleagues referred to me only as the Porn King. Okay. But for more substance on this case, I really do commend you to Judge Gallagher's talk last year. I've seen it. I thought it was terrific, and I don't want to step on his lines. One more. This is one of my favorite cases of all time, Lehman against the city of Shaker Heights. And this is not only because I used to live in Shaker Heights, although I did. I actually was intrigued by this case long before I got to Cleveland. Because this is, how can I put it? This is one of the very few cases, maybe the only case I can think of, in which the Supreme Court essentially said political speech has less First Amendment protection than any other kind of First Amendment protected speech. Here's why. Shaker Heights used to operate its own rapid system. It's right, the blue and green lines are now part of the RTA, but they were, for decades, they were run by the city of Shaker Heights. And the city of Shaker Heights had a policy prohibiting political ads on the rapid. In 1970, a young Jones Day lawyer named Harry Lehman ran for the state legislature. He was running, by the way, against an incumbent who was a young Baker Hostetler lawyer named Richard Hollington. Richard Hollington's daughter was in my very first class. I think I may have met, I know I met Harry Lehman a couple of times. I think I met Richard Hollington some years later, but anyway. So Harry Lehman wanted to buy some space on the rapid cards for a campaign card that was going to say something like, Harry J. Lehman is old-fashioned about honesty, integrity, and good government. That was it. By the way, if you're interested in seeing it and you have a chance, go into our law library, go up to the 3rd floor of the library by the stairway, and we have one of those cards because Harry Lehman donated his files on the case to us, and that included the advertisements. In any event, Lehman had to go to the U.S. Supreme Court, where he lost in a 5-4 decision that had no majority opinion. The plurality of 4 said that the city of Shaker Heights was engaged in a proprietary, not a governmental activity, and therefore the First Amendment didn't apply at all. The 4 dissenters said, this is First Amendment activity. The city has opened a public forum by saying that it will accept advertising for essentially any lawful product or activity except political speech. And under public forum doctrine, you can't make those sorts of distinctions. The crucial vote, the deciding vote, was cast by Justice William O. Douglas. This was I think his last full term on the court, and he did some other peculiar things that term. Justice Douglas decided that the city should win because he thought that the passengers were a captive audience and could not look away. And in support of this, he cited one of his own dissenting opinions from about 22, 23 years earlier. It turns out that the old DC public transit system used to run audio on their trolley cars. Justice Douglas used to take the trolley from his home to the Supreme Court, and he was infuriated about this because you couldn't cover your ears, right? Okay, I get that. There's no audio on Harry Lehman science, right? But that was the basis for Douglas going along. Okay, now, all right. Now, Harry Lehman won anyway. He served 10 years in the legislature. He chaired the House Judiciary Committee for a good chunk of that time. Then he opened and managed the Columbus office for Jones Day for many years. Richard Hollington went on to a distinguished career at Baker. He did return 40 years later to the legislature. He was appointed to fill the unexpired portion of Matt Dolan's seat in the legislature when he resigned to run what turned out to be unsuccessfully for Cuyahoga County Executive. Hollington thought he was going to be done at the end of the term, but it turned out that Tim Grandel, who is now in the news for other reasons, Tim Grandel had been elected to that seat, but he was already in the state senate, and after the election he decided he'd rather stay in the state senate, and so there was a vacancy that Hollington managed to fill for a while after that. Now, one more, City of Lakewood against Plain Dealer Publishing Company. This is actually a challenging case on the tour because this is a case about newspaper vending machines on public sidewalks. Let's just say it's been years since there were newspaper vending machines on public sidewalks. But basically what was going on in this case, and here's the Lakewood City Hall, the ordinance in Lakewood said you couldn't put a vending machine on a sidewalk without a permit from the mayor, but there were no standards in the ordinance to explain what grounds the mayor could use to turn down an application. And so the Plain Dealer took this to court, and the U.S. Supreme Court said, look, this is a classic First Amendment violation. It's a licensing scheme that gives unfettered discretion to the administrator, right? It's not a unanimous decision only because what's at issue here is the public sidewalk, and some justices thought that this was a little bit different because it's the public sidewalk, which would be essentially permanently occupied by the vending machine. But nobody disagreed that the ordinance lacked standards and that was a real problem. Okay, now, let me close with two cases involving, well, they're due process cases, or they were decided as due process cases, but they actually involve the Cleveland School Board. The first of which is the LaFleur case. This, by the way, this is now the Drury Hotel. It's the only photograph I have. But this used to be the old Cleveland Board of Education building. So just bear with me and imagine that this is the board building. Now, LaFleur is a wonderful case in a lot of ways, and there are a bunch of connections between the case and this law school. But basically, the Cleveland School Board had a rule, fairly common rule. Pregnant teachers had to stop working in the classroom at the end of their 4th month. In other words, right before they began to show very much. And the teachers could come back at the beginning of the first term after the baby turned 3 months old. So there are 2 teachers in this case. Jo LaFleur, who was pregnant and told she had to stop teaching. And then there was another woman named Ann Nelson, a pregnant teacher, who also was told she had to stop teaching. Ann Nelson was married to one of our students, and her husband came to one of my colleagues and said, "What do we do?" And that wound up getting my colleague Lou Katz involved in the case. Lou represented Ann Nelson, Carol Agins represented Jo LaFleur, and also another connection upstairs, Lou's sweet mate, a fellow named Sidney Picker. Sidney's wife, Jane, taught for many years at Cleveland State. They were both involved with the Women's Law Fund here in Cleveland. And so when the case went to trial, Carol Agins and Lou Katz were representing the teachers. And Lou has a story about going to a pretrial conference with the district judge. And when Lou came in, the judge said, "Good morning, Professor Katz." And then when Charles Clark, the Squire Sanders partner, who was the lawyer for the school board, came in, the judge said, "Hi, Charlie." And so, Lou said he figured it was going to be an uphill battle, and let's just say they lost a trial. They won at the Sixth Circuit, and the case was argued in the Supreme Court. Jane Picker argued the case in the Supreme Court, and she argued it as an equal protection case. She said, women are being treated badly because they are women, and that's a classic equal protection violation. Well, the Supreme Court then, and to some extent now, has had a lot of trouble thinking about pregnancy in equal protection terms. The same term that the court decided LaFleur decided another case called Geduldig against Aiello, in which the court said a classification based on pregnancy is not gender-based. It's a classification between pregnant women and non-pregnant persons. I am not making this up. In any event, so the court, as I said, the court had a lot of trouble with this, and so the court clearly was uncomfortable thinking in equal protection terms, and so it treated this as a due process problem. That is to say, this was a conclusive presumption that all pregnant teachers were unfit to work after the 4th month, and that, the court said, was unacceptable. You needed to have some sort of individualized determination. Right? Not what Jane Picker argued, but a win is a win, as they say, right? Okay. Although I will tell you that the Supreme Court, for good reason, fell out of love with conclusive presumption analysis not long afterwards, which raises the question, how would this case have come out had it been litigated a few years later? Last case is Loudermill, also the school board. Loudermill was a security guard who had said on his job application that he had never been convicted of a felony. It turned out that he had been found guilty of grand larceny, which he claims he thought was a misdemeanor, not a felony. I'm not going to vouch for the man's credibility. I'm just telling you this is the claim. Okay. Eventually, the school board discovers that he had this conviction, and they fire him for lying on his job application, summarily. And they say, you can have a formal hearing after you're fired, but not You can't have anything before. Well, it turns out that Loudermill made a due process argument, right, and local connections, right? You all know in order for due process to be triggered, you have to have a liberty or a property interest, right? And a property interest is created by an independent source like state law. This all comes from a case called Board of Regents against Roth, and there's a local connection to that too, because Steve Steinglass, the longtime professor and then dean at Cleveland State, argued the case in the Supreme Court on behalf of Roth. And by the way, one other small plug for Steve. If you have not seen his book on the Ohio Constitution, you should. Shameless self-promotion, I just published something in the Cleveland State Law Review, etc., which is their online supplement, about the book. The title of my piece is The Last Word on the Ohio Constitution, and I think that's a fair summary of the 17 pages of verbiage that follows. So check out Steve's book if you don't know about it. Anyway, but it turns out that the U.S. Supreme Court had suggested in a plurality opinion some years afterwards, a case called Arnett against Kennedy, that maybe the state could define not only the nature of the property interest, but the procedures for its vindication, right? On the theory, the court said that you have to take the bitter with the sweet. It's the whole package. That part of the case, Arnett against Kennedy, was a plurality opinion. And so Loudermill is important because the court said, no, Arnett is wrong. The state gets to define the substantive property interest, but that's a matter of state law. But the means for vindicating that state-created interest, that's a federal matter. The state can't give with one hand and take away with another. And so the fact that the school board was willing to give Mr. Loudermill a pretty elaborate hearing months later couldn't make up for the fact that they gave him no process whatsoever before they fired him. Okay. Now, we need to stop because you have to go on to some substantive things. I want just to, first of all, to thank you for your patience, but I also want to say there are other important cases that arose around the Cleveland area. I've talked about these cases because they're the ones I used to do on tour, but there's a whole slew of other important cases that are worth thinking about. You know, there's the Debs against the United States, which took place in Canton, was tried in the federal courthouse downtown. Eugene Debs's condemnation of World War I. And there's Scheuer against Rhodes, which is an important immunity case that grew out of the Kent State shootings. And one of my favorites, Zucchini against Scripps Howard Broadcasting. Zucchini, if you don't know, Zucchini was a celebrated circus performer. He used to get shot out of a cannon. I remember my grandparents taking me to see him. Well, it turns out Channel 5 ran a clip of him being shot out of the cannon on the 11 o'clock news at a time when he was performing in Northeast Ohio, and Zucchini sued, claiming that they had essentially appropriated his entire act, and it wasn't literally everything, because it was like a 15-minute act, which they had reduced to about 45 seconds, but it was the part where he gets shot out of the cannon, not the build-up. Right? Okay. So the Supreme Court says, oh yeah, the First Amendment doesn't preclude a right of publicity claim here. And there's also the Cleveland school voucher case, right? Zellman against Simmons Harris. I mean, so there's a whole slew of these things. But one of the things that strikes me, even now, is how many really significant cases have arisen in Cleveland compared to lots of other places. And I think that it's a good thing to be able to say this stuff happened here, whether we agree necessarily with how all these cases came out or not. At least these are really useful, significant things, and we can point to them and say we have some sort of connection. So thank you for your patience. I'm happy to take questions in the minute and a half or so that we have left.
What do you think it counts for a relatively high number of cases? Is it because we have such a big legal community relative to our population, or is there some other reason?
I'm not sure. I mean, keep in mind that at the beginning, Cleveland was one of the largest cities in the country. It was an economically really significant kind of place. And I also think that in some instances, we just had folks who were thinking about some of these issues. I mean, many of these cases were litigated by really good lawyers. And, you know, it's hard to get to the U.S. Supreme Court if you're not a good lawyer. But I don't know. I mean, I think about the only other city that comes to mind as being, you know, like a large number of big cases in modern times is San Antonio. There's a major 10th Amendment case. There's a major school funding case, Rodriguez, right? The 10th Amendment case is Garcia against San Antonio Metropolitan Housing Authority. And then there's a big case about the Religious Freedom Restoration Act, City of Bernie against Flores. Bernie is a suburb of San Antonio. I don't have an explanation for that one either, but as I said, I'm hard pressed to think of very many other cases that even any other cities that have that many. So, you know, maybe it's just a coincidence. Maybe there's some deeper explanation. I'm open to suggestions.
Something in the water.
Well, I think we need to move on. Is that right? So, thank you for your patience.
All right, good afternoon, everyone. And I think that we had some interesting information, and that will continue with this session, which is with power comes great responsibility as we talk about contempt, the powers that a judge uses to try to get some compliance. And we know for those of us, I see a new judge that's over at the municipal court that was with us for many years over at the Court of Appeal, that we know sometimes we can get it by just a look, a gesture, a question, oh, I know we're not going there. But when that doesn't work, you have to utilize other tools in the toolbox. So we will talk about that. And we have a very distinguished panel. The Court of Appeals has a great brain trust that we are able to draw from as we try to make sure that we give accurate information in our opinions. So I'd like to first introduce Jake Dicus. And Jake has been recently appointed as Assistant Court Administrator, our Chief Legal Counsel. Now, Jake didn't have a fun fact in his bio, but I know he likes to cook because when we have our potlucks, he's always giving us some interesting dish that he has prepared. Next, we have Darcy Del Toro. She's been with the court for 20 years. And her interesting fact, and I'm sure she's thinking about it right now, she likes to visit beaches across the world. And finally, we have Robert McKillop, who is an assistant public defender. He has a great background, but he has chosen to work with the Public Defender's Office, and we appreciate that dedication. His interesting fact is he competes competitively as a fencer. So, with no further ado, we will present the panel and hear some great information. Thank you.
Thank you. Our presentation is about contempt. With great power comes great responsibility. I'm going to talk about some of the background of contempt. Ralph's going to talk about some of the due process of owned and everything, and Darcy's going to talk about some practice tips. So first, we have the different types of contempt. You can break it down into 4 categories: criminal versus civil, direct versus indirect. Ralph's going to talk more about direct versus indirect, so I'm going to just go over some of the civil versus criminal sections. It's basically based on the sanction that's going to be imposed. Civil is remedial or coercive in nature for the benefit of the complainant. There's usually a condition that you can purge the contempt, so you can relieve yourself of whatever sanction is going to be imposed or is imposed. Whereas criminal is to vindicate the authority of the court or to enforce an order. There's also a different evidentiary standards that apply. In civil, we're looking at a clear and convincing evidentiary standard, and in criminal, must be beyond a reasonable doubt. There are various sources of authority for contempt. In the federal courts, the U.S. Supreme Court has said that courts have inherent authority to regulate proceedings and enforce compliance with its orders. The Judiciary Act of 1789 that established the lower federal courts also included a contempt provision in there for authority to punish all acts of contempt. That was later codified in 1831 into 18 U.S.C. 401. It's remained largely unchanged. Where the changes occurred is in case law and in the federal rules. Federal Criminal Rule 42 provides for notice and opportunity to be heard in a jury trial. However, for direct acts of contempt, the jury trial is there's an exception there. There's an interesting historical analysis of the evolution of contempt powers that's available on the Judicial Center, the Federal Judicial Center's website, jfc.gov, and there's a permalink, which we talked about earlier, there in your materials, so you can use that and go find that paper. For state court powers, the Ohio Supreme Court has also held that courts have the inherent authority to regulate proceedings and ensure compliance with their orders. There's also a statutory scheme for contempt. RC 270501 basically defines acts of direct contempt, those that occur in the presence of the court and obstruct the administration of justice. And then RC 270502 basically is all other acts of contempt defined as indirect contempt. And there's a non-exhaustive list in there as well. Magistrates also have the authority to impose sanctions for contempt. Federal magistrates, they can impose up to a Class C misdemeanor, basically. Anything beyond that has to be referred to the judge. That's 28 U.S.C. Section 636E. Civil Rule 53 and Juvenile Rule 40 also give magistrates the ability to impose sanctions for acts of contempt committed in the presence of the magistrate. That sounds a lot like direct contempt to me, but there's some questions about that. There's also a provision in those civil rules and juvenile rules for review of the contempt finding by the judge. Punishment is determined by the statute RC 270505. For a first offense, a fine is not more than $250, 30 days in jail. Second offense, $500, 60 days in jail. Third offense, $1,000, 90 days in jail. However, there's some tension between the authority of the legislature and courts. Courts have held that they have inherent authority to impose whatever sanction they deem necessary. And I'm going to talk a little bit about sealing here because there's a couple of recent Supreme Court cases that I would argue that a court does not have inherent authority to go beyond the statute. One of those cases specifically is State versus GK. In that case, there were very serious charges brought against an individual, rape, kidnapping, GSI, and along with an obstruction charge. As the case went on, it became apparent that the defendant didn't commit the acts of rape. As part of a plea agreement, the defendant pled guilty just to the obstruction charge, and the other charges were nullified or dismissed. And because the person was not eligible for sealing at the time for that conviction, he brought a motion with the trial court to seal the records of the dismissed charges. Those serious charges which are impacting his ability to do things like find a job, that sort of thing. The trial court, citing to its own inherent authority to seal records, which is a power that's, goes back probably just as far as contempt, said, okay, we're going to seal just those dismissed charges while leaving the conviction in place. The state appealed, and the Ohio Supreme Court said, no, you do not have inherent authority to do something when there's a legislative scheme in place that you could not do under the legislative scheme. So I would argue that there's a legislative scheme in place for contempt, and the trial judge does not have authority to vary the sentence that has been decided by the legislature. But nobody's made that argument yet, so we'll see how it works out. There's also an exception to that, the punishment. RC 270506 does allow for an indefinite jail term, but there are limitations. It does not apply to past contemptuous acts. It is used to coerce some sort of action, and the contender must have the ability to perform the action. Classic example of this, I think, is a journalist who refuses to reveal their sources after they're ordered to by a judge, and the judge places them in jail until they reveal their sources. Another exception is a debtor's prison. Contempt cannot be used as a de facto debtor's prison. Contrary to what some judges, and this judge here in this case, court costs are just like any other civil judgment. You cannot use contempt powers to place someone in jail for failure to pay court costs. They're a civil judgment. They must be collected like any other civil judgment, and that does not include jail. I'll turn it over to Rob. Yeah.
All right, hi. So, there, like many of the other things we've heard about today, that it seems like every court likes to kind of do its own little definition. So there are a bunch of quotes here. You'll get the written materials. I think probably the best and most comprehensive definition of contempt generally is the middle one in the blue area on the slide, which is conduct which brings the administration of justice into disrespect, or which tends to embarrass, which I don't know exactly what that means, or more importantly and more commonly, impede or obstruct a court in the performance of its functions. So for direct contempt, the basic definition is that latter part of that larger definition, interfering with an active court proceeding or hearing or whatever. Generally speaking, the conduct that constitutes the contemner's contemptuous act must occur before, actually physically before the judge or other court personnel, which can include the court bailiffs. There is some suggestion it includes court reporters. The Ohio Supreme Court hasn't said that, but a number of district courts have. Certainly it includes, there's pretty much no question that it includes the bailiff, and obviously it includes the judge. It also includes conduct that is so near to the court that it is constructively in the court's presence. Commonly what you see in the cases is when there's a melee in the hallway. So in the Court of Common Pleas, there's two doors, and one of them has no windows. So it's not actually literally in the court's presence, but if people are screaming and fighting and banging things in the hallway, that very well may disrupt and I guess potentially even embarrass the court and obstruct its functioning. And so that would count as direct contempt. That sort of thing is less common than outbursts in the courtroom or things like that, where it is in fact right in front of the judge. We have a question? Yes.
Yeah, when it's defining the court, and you say it includes the bailiff and the judge, does that include the jury?
Well, yes, it does, and that's actually this next slide. So something weird.
Psychic.
Yeah. So usually, and I'll talk more about the due process or what process is due for direct contempt, but the answer, a little spoiler, is not much at all. The exception is in the rare, extremely rare situation where the contemptible or contemptuous act occurs in the presence of the jury. And so that happened in at least one case, State versus TF, where it's actually wonderful. One of the jurors, during jury deliberation, just brought a bunch of newspapers with stories about the case into the jury room. It was like handing them out and wanting to organize discussions about it. Just totally lawless. I don't know what this guy was thinking, but he got in trouble and was held in contempt and was held in direct contempt. And again, as I mentioned, and we'll discuss in a couple slides, direct contempt, there's extremely limited process that's required, and certainly what is not required is like an evidentiary hearing or an adversarial hearing or anything like that, except in this context, and potentially context of like a fracas in the hallway or something like that. That's only the constructive presence of the court. There, a hearing is still required. So it counts as direct contempt, even though it's not in the physical presence of the court, but merely the constructive presence. But unlike if there is just an outburst in front of the judge, or as sometimes happens, directed at the judge, unlike in that situation where a hearing is not required, when the court personnel is the fact finder in the guise of the jury, then a hearing is required. But that still counts as direct contempt. So I mentioned that very little process is required, and that's true. I mean, some of the cases say that there is no due process is required. I don't really think that that's accurate. I mean, you always have the due process rights. Just the process that's due in this context is de minimis. Essentially what it requires is that the trial court enters a judgment that has a combined finding of fact and conclusion of law or judgment that a contemptuous act occurred and the person did it, and that is it. So that's really not very much, but it's still not none. I mean, the court still has to find and note the facts. But beyond that, procedural due process rights are essentially inapplicable. I mean, you don't have a right to counsel, you don't have a right to allocute or really say anything in your defense. I mean, if you have an outburst in court, you can simply be placed in jail, right? And that's it. It just happens summarily, and it is lawful to do that as long as that fact finding makes its way into some journal entry. And that State versus Pryor case, it was me. I lost it. It was me who was the contempt one. But yeah, okay. Sanctions. So Jake talked a little bit about sanctions. There's an open question most of the time, though. I think part of the reason why the case law in this area is limited is it really is rare that you see kind of capricious punishments here. I mean, I'm going to throw you in jail for 4 hours because you said a bad word to me, the judge. So it's rare that someone is thrown into jail beyond the maximum that's established in Chapter 2705, or where a fine is imposed that is beyond the fee schedule or the fine schedule established also in Chapter 2705. There may be an appeal issue there. Certainly, if you're doing an appeal with a direct contempt, you should make sure that fact finding has occurred and that it's present in the journal entry. There may also be a question, I mean, it's kind of up to you about how much you want to push, like what the boundaries of what the clear law is, how much you want to push those boundaries, but there may be a challenge to the reasonableness of the sanction, particularly if it deviates from those standards that may or may not apply and kind of cover the field as set out in Chapter 2705. And then the probably most important thing is to make sure that the contemptuous conduct that the person was found to have engaged in was in fact direct contempt, which again usually means that it occurred in the presence of the court. In the case of indirect contempt, you do have close to ordinary procedural due process rights. So certainly you have the right to a hearing on the charge, you have the right to assist counsel, to offer testimony or subpoena people to testify. You have far broader set of protections as the contempt order. What indirect contempt is interfering with the court's processes outside of the court's presence. Usually this is things like not responding to discovery requests, ignoring or failing to comply with orders of the court that are issued through journal entries, so like not really to you in the presence of the court. If the court tells you to do something during trial and you simply don't do it, that is likely to be direct contempt. But if a journal entry is issued saying turn over this or send that or whatever, and you don't do it, that may be indirect contempt. Again, you still have to actually disrupt the court process. So kind of merely not complying to the satisfaction of the court may not in fact be any kind of contempt. But the important and the major distinction is that you have the right to a hearing. One of the most common things in the cases is lateness of like a person's physical appearance at a hearing. The attorney will be told to show up to a pretrial conference at noon, and maybe doesn't show up at all, or shows up at 3, and then is held in that is a situation where a person would appropriately be held in indirect contempt. Often what you see is that they are held in direct contempt because the court thinks, well, here I am, the guy's not here. That's happening in my presence. Like I am here alone without this attorney. But in fact, that is indirect contempt, and the cases are very clear about that because the lateness is occurring outside, like by definition, your lack of presence is occurring outside of the presence of the court. Otherwise, whatever you were doing would not be lack of presence. So bear that in mind when looking at things, because one of the rights that you have in that hearing where you can allocute is especially in like lateness or non-appearance situations, but also with missing filing deadlines, especially discovery, especially as I gather, I've done civil law for many years, but discovery issues in civil law especially, you have the right to explain why that happened, right? So there's a big difference between not showing up to a hearing at noon because like you just didn't feel like it. Noon's not a good time. You know, it was unfair to set the hearing at noon. That you can't do. Not showing up at noon because you were hit by a bus is a pretty good reason. So the judge might be furious until you allocute and then explain, well, you know, you're like in a full body cast, and explain, here's why I was not at that hearing, or here's why I didn't send that discovery over, right? So there are, that requirement for a hearing is the major and important distinction. I already said all of this, I think. So yeah, there is a little less discretion in terms of how the issue can be handled between indirect and direct contempt. With direct contempt, you can be essentially summarily punished. The punishments are comparatively mild, but nonetheless, it's a pretty quick process. Most of this is explained in Chapter 2705, as Jake noted, and I didn't leave enough time for Darcy, so.
Good afternoon. Jake and Rob have given you all everything you need to know about contempt, right? So I get to do the fun part. If anyone has, or get out your pen and paper because it's time for a pop quiz. Actually, just kidding. The fun part that we get to do today is what to do if your client has been held in contempt. We're going to talk about some practice tips. An overview of what to do, there are 3 things you need to know. 1 is a direct appeal. 2 is an original action in the appellate court, otherwise known as a writ. The 3rd thing we're going to look at today is a stay of execution of judgment, which is particularly important as the gentleman we're discussing. If your client is incarcerated, the stay is really important. If it's a money sanction, there's other ways to attack that. You can do a stay, of course, but we'll leave it at that. So the first thing we're going to talk about, the first option you want to look at is a direct appeal of the contempt order. The first thing you need, of course, is a final appealable order. The definition for that, as related to contempt, can be found in the statute that you see on the slide. In general, that journal entry needs to have the finding of contempt, and it also needs to have the sanction or the penalty that was imposed. Those 2 things need to be done by the trial court before you can file an appeal. A situation that we often run into that talks about final appealable orders and contempt has to do with magistrates. Magistrates have the power to hold people in direct contempt. As many of you know, magistrates' orders are not final and appealable. So what do you do there? There's a couple different avenues you can take. You can refer to Civil Rule 53, Juvenile Rule 40. They both cover magistrate orders. One thing you can do is file objections to those magistrate orders. If a trial court timely rules on that, your order can become final, appealable, and then you can go on and file your appeal for contempt. If you file objections to a magistrate's order and you're getting no satisfaction from a trial court, you can file a motion to rule on the objections or rule on the magistrate's order, push things along. Again, I can't guarantee you success, of course, but it's a best practice type of tip to do. What we're looking for again here is a final appealable order. One thing that we kind of stumbled across when we were doing the research here is a potential challenge. If you have a magistrate's order and you're not doing the things that we just discussed, can you appeal it? Can you go under the statute 250502 and go through the regular test for a final appealable order? It's a challenge that we don't know has been made. We didn't run across one, so if anyone's up for it, that could be an interesting project. Just don't hold us to anything over here. So the next thing you want to do there now, you want to file your notice of appeal. After you file your notice of appeal in the appellate court, you immediately want to move for a stay. You'll find that under App Rule 7, application for a stay must be filed initially in the trial court. There are very few exceptions to this. Best practice is to file it in that trial court. If the judge grants the stay, you're in business and you can move forward with your appeal. Again, this becomes more important with incarceration, but if the trial court denies your request for a stay, a second step would be to file that same request for a stay in the appellate court. Earlier, I believe it was the first set of speakers, talked about persuasive opportunities. And I think that comes into play here. If you're going to file a motion for stay in the appellate court, include everything, attach everything to that motion that you think the court would need to grant the stay, to rule in your favor. Example would be journal entries and motions, some things like motions to compel, rulings on motions to compel, motions to show cause, rulings on that. Obviously the contempt proceeding itself, if it was done in open court, there's a little known rule called App Rule 10F. It allows you to order or request, a partial transcript from the Court of Courts. In it, you would have that sent up to the appellate court with your motion for a stay. You're arming the folks over the appellate court, the judges and the staff, to rule in your favor there. If this did not happen in open court, the transcript is not available. There's another rule, App Rule 15A. It allows you to attach certain documents to motions. What we're envisioning here would be an affidavit would be a good example. My client was held in contempt, there's no transcript, but here's my rendition, my client's rendition of what went on. That would be helpful for the appellate court. Next, if you can't file an appeal, if these things that we talked about don't work, you don't have a final appealable order, you can file an original action in the appellate court. Those are otherwise known as writs. Typically, we're looking at a writ of habeas corpus. One example, I suppose, of when you would use this, there's no final appealable order. That would be an example of when you could file a writ. An example would be a magistrate's decision that you just can't get satisfaction on, and you don't feel like taking us up on our challenge to see if that's final. You would be able to file a writ of habeas corpus. What about if a court holds you in contempt, but they don't journalize it? They don't follow through with the journal entry. That's another example of when you can file a writ of habeas corpus. I don't pretend to be an expert on writs, but I did put the statute on the slide. Did I not? Sorry about that. There is a statute up there. It's actually pretty easy. The biggest thing I got out of it When you're filing that writ of habeas corpus, you want to attach the commitment papers. The commitment papers usually consist of the journal entry holding the client in contempt. Again, it has that penalty and that sanction there. You can use an affidavit, would substitute for commitment papers if you don't have that journal entry. There we are. No. Okay. There we go. What is a writ? Or I'm sorry, writ of habeas corpus. Who do you file that against? You typically are going to file that against the person that has custody of your client if your client is incarcerated. A sheriff, a warden, a jail official would be the usual party to that. Can you file a writ of habeas corpus against a trial judge or a magistrate? Typically, the answer is no there. Those are usually done through writs of mandamus. There are a couple cases out there that have filed a habeas action and a mandamus action together regarding contempt. The reason that someone would do that, when you're talking about a writ of habeas corpus, you don't really enable an appellate court to get a trial judge or magistrate to do anything. You're enabling us to get a sheriff or warden to do something. With a writ of mandamus, we can look at ordering a trial court to do something. Those would have to be filed simultaneously. That's just the difference there between the writ of habeas and the writ of mandamus. Last option we have is seeking an alternative writ. It's local App Rule 45D2. In a nutshell, this is used when you need an expedited disposition. The form of the writ is all in the rules. It must be in a separate application, and it just allows us to rule in a more speedy manner. This whole end of the portion really has been about best practices and tips, but just the last thing I want to leave you with here is if you do have a client in contempt and you're taking one of these options, you can always call the Court of Appeals. The 8th District number is back up there behind me. Ask to speak to a staff attorney. Let them know what you're filing and when you're filing it. It will help us get staff ready, prepared for it. A lot of these things can involve emergencies if you want to keep your client out of jail. So it helps to give us a heads up so that we're prepared to rule on it. I think that wraps up our presentation on contempt. Thank you.
We're going to take a break and pick up at 2 o'clock.
That's my wife.
Hello, and good afternoon. I'm here to bring you all back from your reverie there for the last 15 minutes to an actually more festive environment, if you can even imagine that, because we are going to hear from Professor Andrew Paulus next. I am Lisa Forbes. I'm a judge on the 8th District Court of Appeals, if any of you don't know me. And I am very excited to have been given the opportunity to introduce Professor Paulus. I'm excited because he is really just a true appellate expert. He's also a friend, and so I'm grateful to be able to tell you that he is in charge of the director of the Appellate Litigation Clinic here at the Case Law School. He also teaches evidence, and he coordinates the appellate practice program, as well as serving as a faculty advisor on the moot court for moot court teams. Before he became a professor, full-time faculty here at Case, and that was in 2011, so if anybody's trying to do the math real quick on how old he is. Okay. Professor Paulus was in private practice at the law firm of Hahn, Lozier, and Parks, where he got extensive experience in trial practice. And he did that for 18 years. So, and I'm just going to gild the lily on this appellate expertise with one more detail, which is since 2008, he has been a co-author of the Ohio Appellate Practice book that is put out annually by Thomson West. Just to be sure that you have the full measure of appreciation for his accomplishments, Professor Paulus got his JD from Harvard and his undergraduate degree, a Bachelor in Arts, from Brown University. So without further ado, I will give you Master Baker and Gardner, Andrew Paulus, to regale us with information about how appellate judges sometimes sometimes can conduct fact-finding on appeal, and it's okay. Thank you.
Well, really sorry. I want to stand for Judge Forbes for the excellent campaign that she ran. So I have on the screen a picture you'll probably recognize. It's Simba, the main character from The Lion King. And with Simba is his uncle Scar, who is the evil guy from The Lion King. And in a minute, I'll explain to you why I'm showing you The Lion King. But before I do that, I want to show you a little clip from the movie Reversal of Fortune.
Your Honors, you may not like Klaus von Bülow. You may think he is guilty of something, but I am here to tell you he is innocent. Our new evidence will clearly indicate.
You know there isn't a single case which allows you to introduce new evidence on appeal.
Well, there is one, Your Honor, and you wrote it. Derek. In Derek, you yourself said that a case based on circumstantial theory rather than fact only stands up if no other theory makes sense. The only way to show a better theory is to present it.
Get on with it.
The first issue is the custody.
So I want to tell you, and I hope Judge Boyle doesn't get upset with me for sharing this, that when I first proposed this topic, I sensed a collective glare from the Court of Appeals at the 8th District for suggesting that appellate courts could actually conduct fact-finding. So I promise you, judges, that I am not going to start encouraging the litigants in the 8th District to start arguing facts in every appeal. But I do want to draw your attention to the fact that there are certain circumstances when appellate courts do fact-finding, and you're aware of all of them. I'm not going to tell you about things that are mostly new to you, but you're going to appreciate that there is a role for the appellate court to engage in assessment of facts, not just sufficiency of the evidence, which of course involves facts, but other things as well. So, first I want to tell you that the pictures that you're seeing there are of, on the left is Klaus von Bülow and his wife, Sunny. And on the right is Jeremy Irons and Glenn Close, who played Klaus and Sunny von Bülow in the movie that I showed you the clip from. And the reason that I showed you The Lion King is because there is a connection here that not everybody appreciates. So Klaus von Bülow was accused of attempting to murder Sunny von Bülow by overdosing her with insulin injections, and she went into a coma, and he was originally convicted. He went up, he got Alan Dershowitz, who was my criminal law professor, and I've always said that the most dangerous place to be in the world is between Alan Dershowitz and a television camera. But Alan Dershowitz represented Klaus von Bülow and then spent the entire semester of my criminal law class talking about that case and almost nothing else. However, and there they are together, and I actually talk about the Klaus von Bülow case in evidence, which I know some of the folks in this room will be taking with me next semester, because there is a very significant case about whether or not work product and attorney-client privilege can be waived when the attorney for the client writes a book about the case. And so, as you might imagine, Sunny von Bülow, who had 2 children from a prior marriage, they weren't very fond of Klaus, and so they sued him civilly after he was exonerated for the crime. And I think it's settled or whatever, but Alan Dershowitz wrote the book, and it became a Second Circuit case in Ray von Bülow about the significance of that. I'm fairly sure, if I remember the holding, that they held that without the client's consent, the lawyer's publication of a book in and of itself can't waive privilege because the client owns the privilege. All right, so why does that connect up with Lion King?
That is strange, man. You have no idea.
It's so weird.
You have no idea.
It's so weird.
You have no idea. You have no idea.
Yes, Uncle Scar was played by the same Jeremy Irons who played Klaus von Bülow, and I'm convinced that that's what they call
saw an Easter egg in The Lion King because of the comment. All right. So why are appellate courts reluctant to find facts? Why do they give you that look when you suggest that it's something that they can do? This part of the presentation for the next 2 or 3 minutes is actually just a cut and paste from something I did 2 years ago when I gave a talk about implicit bias and the role that it plays in wrongfully convicting individuals, and for that reason we need greater scrutiny on appeal. But that's not what this is about. Here I want to show you there are a couple of different reasons why appellate courts are reluctant to find facts. One is the tradition. That's just not what appellate courts do. The other is perceived institutional competency, like this expectation that trial courts and juries are better. And the third is efficiency. You don't want to give people 2 trials every time they go to trial. So the tradition piece is really kind of absurd, especially in criminal cases, because of the 6th Amendment. The right to a jury trial belongs to the defendant, not to the prosecution. So any fact-finding that the defendant may encourage the appellate court to do on appeal is perfectly consistent with our constitutional history. And so to the extent that that's the tradition, it does not bar review of criminal convictions, at least for facts. But, you know, we don't tend to do it. But the other thing is that institutional competency. We heard a discussion this morning about the ZC case, which was decided just last year by the Supreme Court, and it had some discussion of manifest weight. And it explains, ZC does, that the underlying rationale of giving the findings of the trial court deference rests with the knowledge that the trial judge is in the best position to view the witnesses, observe their demeanor, gestures, voice inflections, all this stuff that we kind of loop into credibility, and we say that those in the courtroom on the ground can do a better job of that than those who are looking at a transcript. So that perceived institutional competency is the second reason that I say that courts are reluctant to review facts on appeal. But if you look more closely at that argument, would you turn the volume down a little bit, please? Thank you. If you look a little bit more closely at that argument, it falls apart. So you've got a witness here on the stand, and you've got a jury assessing the witness's credibility. And by the traditional notions of credibility assessment, we are going to assume that that jury can do a better job of telling if Pinocchio is lying than can the Court of Appeals on appeal. But what that does not take into consideration is the fact that there is a transcript of the trial that the Court of Appeals has, and while that transcript does not lend itself readily to things like demeanor and hesitation when you're answering questions and looking shifty and all those things that jurors in the room can actually assess, there are different and important benefits to factual review from the transcript, because only with the transcript can you then go back and sift through all of the evidence to see what the inconsistencies might have been, where the credibility problems might be, and why, on further review than a jury can do in the 2 seconds that a witness comes before them on the stand, you might sense something here bigger. So the literature suggests that there's actually a fact-finding competency at both levels, at the trial level and at the appellate level. Not to say that trial courts and juries aren't better at those demeanor evaluations, although a lot of literature suggests that demeanor isn't as good a measure of credibility as people tend to think it is. But in any event, the idea is that there's 2 roles here. They are different roles, they have different functions, they use different materials, and there's room for both. So that's the predicate for why I think that the institutional competency argument simply doesn't make sense. And so we'll move on to efficiency, and this one I really don't have a really good answer for. Where the efficiency argument is concerned, the idea is that if we let everybody have 2 bites at the apple, then it's going to overwhelm the court system, and you're going to have 3 judges on appeal in every case doing the work that was supposed to have been done by 1 judge and maybe a jury at the trial court, and that's not great for our system. I have no answer to that that's going to be satisfying to you, except to say that by definition, any argument about efficiency is essentially a clash of values, right? Because certainly we can all agree that the more trials you give a defendant, the more we will encroach on or approach accuracy, right? The more times you do it, the more times you have to get it right. And so there is a value in doing it over and over again if you're really interested in making sure that we get to the perfect result. That value is in tension with the cost And so that's basically where we have come out as a judicial system, which is to say that we do not allow two bites at the apple. It's too expensive, no matter how many virtues of it there might be. So, as a justification for not finding facts, that one makes a little bit more sense if you don't value the accuracy as well as you value the avoiding the cause. So, I have here in front of you Appellate Rule 9. I have this here in front of you because I want to draw a distinction between two different mechanisms that appellate courts have to find facts. So the first is based on Appellate Rule 9, which is the there we go. That's Appellate Rule 9, and so some of the things I'm going to talk to you about are factual findings that an appellate court makes based upon that Appellate Rule 9 record, which we all know of as the record on appeal. That is the record. That's the only record. 9A are all the filings in the trial court. 9B is the transcript and exhibits. There's 9C and D if you want a statement or something to swap out for a transcript that's missing. But basically, it's all in Rule 9. Everything the appellate court does has to be based on the record as it's reflected in the Appellate Rule 9 context. Or does it? Actual findings can also be made at the appellate level with new information added to the record. All the actually appellate judges who are like, what are you talking about? Well, let me explain, but I'm going to start with the left one first. What's my presentation just there we go, thank you. Holmes up there is our tech guru, okay.
I did not do it.
Okay. What am I doing, Rob? I'm screwing up.
Just the right arrow key every time you want to
That's
have
what I'm
that.
trying to do, but it's...
So you might accidentally, with your whole thumb, be pressing that middle button. You got to make sure it's only the right arrow.
I'm all thumbs, Rob. Please hit F5 again for me.
Take it from here. Is that okay?
Yep. Okay, so here's the first example that I'm going to give you. Henry the hipster is charged with robbing a bank. The evidence against Henry consists of a single eyewitness, the teller, who initially hesitated to identify Henry as the robber, but eventually testified, that's the guy at the defense table, that's the guy who robbed. Henry says, all right, I'm just going to use the keyboard.
I did not do it.
Henry says, I did not do it. And he offers into evidence a surveillance video showing him entering a grocery store in Seattle, Washington. The trial was here in Cleveland, the defense took place here. On that same date, November 20th, which I didn't put in the front, but the jury convicts him anyway. So you've got the teller with her shaky testimony about identifying Henry as the bank robber, and then you've got a video of him being in a different place across the country on the day of the crime. So what is Henry's option if the jury comes back and says,
Guilty.
okay, so they found him guilty. And as we've already heard a little bit about today, we have a mechanism in Ohio, and by the way, it's unique in Ohio. There are other states that occasionally do it. I've seen Illinois and I've seen New York, but for the most part, if you do a search for manifest weight in all 50 states in the federal system, 99% of the cases that come up are going to be from Ohio. So what makes Ohio so unique? It's unique because we have a constitutional provision, Article 4, Section 3B3, that authorizes manifest weight review. Or does it? What's it say? No judgment resulting from a trial by jury shall be reversed on the weight of the evidence except by the concurrence of all three judges hearing the cause. This is the only reference in the Constitution to manifest weight. And it is a rule of limitation. There is no affirmative right that says you get to do a manifest weight challenge in appeal in Ohio. We infer it by the fact that you wouldn't have a provision that says how to do it if it were something that couldn't be done, right? But this really doesn't give the courts the power to do it in the first place. And it certainly doesn't say anything about how to reverse on manifest weight when it's not a jury trial, where you don't need a majority. It can be 2 to 1 if it's a bench trial, and there's nothing in the Constitution about that. You'll see it in Rule 12, Appellate Rule 12, but you won't see it in the Constitution. So right away, we have steered away from grounding this factual review in something really concrete. We are inferring it from an indirect reference in the Constitution, but it is the weight of the evidence in manifest weight review that is the game. That's what the appellate court is supposed to assess to determine whether or not the fact finder lost the fact finder's way, the 13th juror, as we heard earlier. So I thought it was kind of funny that in 1923, which is one of the earliest manifest weight cases I was able to find out of the 7th District, that the entire decision about whether or not to reverse on manifest weight grounds was just based on who called more witnesses at the trial. It was 8-2. And so whoever had the 2 witnesses won the trial, and the Court of Appeals said, we got 8 more on the other side, plus the plaintiff. We're going to reverse on manifest weight grounds. I'm guessing that doesn't happen much anymore in our appellate system, although there are much more frequent challenges these days to manifest weight than there used to be. So the ZC case says that the thing that a court is supposed to do when conducting a manifest weight challenge is a soup to nuts review of the factual record. The whole thing. For every potential factual basis that the fact finder based its verdict on that is not sufficiently weighed in favor of the victor to support the verdict on appeal. Now, I've highlighted here, consider the credibility of witnesses, because this has been a source of some contention in the law. It starts with this notion that in weighing evidence, even today, even in 2023, when the Supreme Court decided the ZC case, it said that we have to be mindful of the presumption in favor of the finder of fact. The presumption in favor of the finder of fact. What does that mean? What does that mean? I teach evidence, and we cover presumptions in evidence, right? If you have a presumption, it means the other side has the burden of disproving the thing that you come in freely. Yep.
You can, if it's a presumption, it can be rebutted.
Yes. How?
Well, with other evidence.
So not other evidence necessarily that's not in the record for manifest weight purposes. This is
additional evidence.
Well, with the other evidence at the trial, the evidence that came out, the evidence that's in the record, that in the minds of the judges on the Court of Appeals, it overcomes that presumption that the fact finder got it right. So, now, my friend, Judge Baker is only one of the authors of this book.
I'm sorry.
Oh, no. And you said that you couldn't afford it, so I'm giving you this copy. But I want you to know that the entire Appendix G of this book is all about standards of review.
Thank you. I'm glad I came then.
We talked about the ZC case, and it's important because it is the most recent case that discusses manifest weight, and it continues to presume that the jury or the judge, if the judge's record, got it right. So somehow, you have to be able to rebut it, but the case law doesn't really explain very clearly how. It doesn't say how you rebut it. So ZC goes on to say that if the evidence is susceptible of more than one construction, the reviewing court is bound to give it that interpretation which is consistent with the verdict and judgment, most favorable to sustaining the verdict and judgment. This feels to me like a wordier way of saying there's a presumption, although there's a little bit more specificity in this language, because this language suggests that the appellate court cannot choose among competing inferences and do so inconsistently from the way the jury did it. Because the interpretation that is left to the appellate court is only the interpretation that supports the verdict. Now that's ZC 2023, very recent, current state of the law can't be right. Why can't it be right? It can't be right. Why?
It contradicts the constitutional provision.
Not necessarily. I mean, the constitutional provision doesn't give you any rights at all, really. It just says you have to have a unanimous panel. Why can't that be right?
Because
it can't be right because it's not a sufficiency test. Sufficiency tests are the tests where we defer to every inference that the jury found if it's supported by the evidence. And if that's all this is supposed to be, then how is it different? And the Supreme Court has said that it is different. They said in Eastman versus Volke that there is a difference between manifest weight and sufficiency, and that the manifest weight analysis is the same for criminal and civil cases. So why would we do this? Why would we give the interpretation that sustains the verdict? It's basically saying you can have a manifest weight review, but you can't really do it. So I think that's just sloppy language. And in our case here, where Henry he wants a new trial, and that's what a manifest weight reversal gives you if you're appealing from a jury verdict. If you're appealing from a bench trial, it could either be a new trial, or even the appellate judges could just put in the judgment that they think the trial judge should have entered. But this is fact-finding at its core, and here's the kicker.
I see a site and something I don't like.
It's something you don't like because?
Because I think case law over time with the Haas has been misconstrued.
This is my point. There is so much case law that says that when you do a manifest weight review, you don't assess credibility. That's the fact finder's job. Now, we just saw ZC said something different last year, even while it took it away in the same breath. But in the 8th District, there has been a long string of cases that say that you have to defer to the fact finder's credibility determination, and they cite that DeHaas case for that notion. I wish Judge Sean Gallagher were here. Yep.
Can I just say, though, it says primarily and not solely.
Yes, it says primarily. Thank you. I'd like to emphasize that. And I'll get back to that in just a second. Primarily, which can mean, by the way, first in time or more important than the others. So we don't quite know what that means. But DeHaas is a sufficiency case. Yep.
Can any of these cases address the qualitative part of it? Like in your example, it's not a credibility question if I have a video of the guy in Seattle.
Sure it is.
Right? I know she's not credible. I have a video of the guy in Seattle. There's no question that like the qualitative nature of how convincing the evidence on credibility is seems to me to be what should drive how much fact-finding the appellate court will do.
That's one theory of it. I would just caution you and my future evidence students as well not to just assume that what you consider indisputable evidence, like a video with a timestamp, it's still the fact finder's province to say that that's not authentic. Or
do the cases address that idea, though? That if there's a big difference to me between he said, she said, and he said, and he's got a video.
Right. But there is no limitation in the law. What you're saying makes sense, that you're going to have an easier time reversing a manifest weight case when there's such a clear qualitative difference.
But I also feel like the appellate court should be more willing to substitute its judgment in those cases.
And I think it probably is. It's just that those cases don't tend to result in guilty verdicts if the evidence really is so one-sided in favor of the defendant. But I want to get back to the Haas here because, as Judge Forbes pointed out, it says primarily for the trier of fact. But let's see what has happened since 1979, which I think is the first time the 8th District cited DeHaas for a manifest weight, even though there is no ruling about manifest weight in DeHaas. There's a passing reference. I also want to give a little shout out to my former student and now head of the appellate division of the Akron Defender's Office, because this ground zero from studying DeHaas is a crib from him. He used that phrase in a recent brief, and I found it so effective that I stole it from Joe Shelton. Now, in 1979, we began this path. 45 years later, and this is why I wish Judge Sean Gallagher were here, just a few months ago, the 8th District basically said, no, DeHaas has no place in a manifest weight analysis. It's a sufficiency case. Done citing DeHaas. No more DeHaas. And by the way, the assessment of witness credibility is very much part of the appellate court's manifest weight responsibility. So that's the decision out of the 8th District from very recently. I hope it sticks. I hope all the 8th District judges continue to follow it, but guess what? The 3rd District 10 days ago. And the 2nd District 7 days ago. Now, substantial deference be extended to the fact finder's determinations of liability. They saw and heard the witness. They can consider the inconsistencies. This is all the institutional competency argument that I have already explained to you is not sound. It doesn't mean the 2nd District was wrong in not reversing that particular conviction. But the analysis of all of this is completely disregarding, or at least substantially disregarding, the important credibility assessment role that appellate courts in fact do have. And it's not based on the ability to observe the witnesses in the courtroom. It's based on their ability to observe the whole record in totality after the fact. All right. So example number 1 turns out to be an example of manifest weight review. I'm going to give you a couple more examples for the left side, and then we're going to turn to adding evidence to record. So example number 2. Cowboy Dan and Cowboy Dave got into a brawl down at the saloon. Dan was charged with felonious assault. At his trial for felonious assault, Dan's ex-spouse testifies during the state's case that Dan was an abusive and dishonest during their marriage, all of that being inadmissible evidence under 404 and 608. The trial court overrules Dan's lawyer's objections to this testimony. All right, so determining whether to grant a new trial as a result of the erroneous admission of evidence under 404B, an appellate court must consider both the impact of the offending evidence on the verdict and the strength of the remaining evidence after the tainted evidence is removed from the record. What's that? If you are going to excise from the record the stuff that should not have come in, you as an appellate court have to sit and look at the entire case minus what you've excised and satisfy yourself one way or the other about whether the trial result can stick. I don't know how you do that without fact-finding. It's impossible, right? Now, one might say that any time evidence is wrongfully admitted, the appellate court, rather than substituting its judgment for the jury that never heard the case right, should send it back for a new trial every time. What would be the problem with that?
You're doing a lot more trials.
Efficiency, right? That's the reason why you can't do that. But the idea is that you very much have to make a persuasive factual argument in your briefs in an argument if you're going to be arguing that evidence that shouldn't have been admitted taints the entire result. Not only that, but the Morris case goes on to actually switch the burdens here. In a criminal case, if affirming a conviction notwithstanding an evidentiary an appellate court must declare a belief that the error was not harmless beyond a reasonable doubt. In other words, if you find a piece of evidence you can successfully argue was not admitted or was not excluded and should have been, and your client is the criminal defendant whose conviction is now on appeal, it is the state's burden to demonstrate that the erroneously admitted evidence didn't taint the verdict. Okay? Think about that. That's a hugely powerful burden shift just by showing an evidentiary. And it means that when you're briefing an evidentiary issue like this, the factual argument you have to make in order to defeat the state's attempt to argue that it was harmless error is intense, right? It's almost like a summation that you have to do to a jury in your brief and potentially an oral argument to convince the court not to find that the error was harmless. And it's actually, for those of you who are defense counsel, even more challenging if you raise it through ineffective assistance. Because if the attorney at trial failed to object to the offending testimony, There is case law out there, it's a little on the bubble, that says you don't get the benefit of the Morris burden flip. If your lawyer doesn't object, then you have the standard Strickland prejudice burden to show that the outcome was probably affected by the lawyer's deficiency, not by the testimony that gives you a Morris analysis. So, not only do you have to be prepared to argue these facts, you also have to know which side you're on, right? Are you on the side that has to defeat the harmless error, or the side that has to show it, right? And argue the case in a factual way, very much so, to meet whichever of those burdens you have. Why not always send it back to a new trial? I said before, because of the efficiency concerns. But do you appreciate here, just stop for a minute, you've got 3 judges on your panel. You have convinced all 3 of them that this testimony should never have been admitted, at least not during the state's case in chief. Absolutely wrong to admit this testimony. Now, how am I, as an appellate judge, going to decide whether the rest of the evidence is enough, or whether this error makes me feel like it has to all be tried again? I don't have the answer to that question. I wonder maybe if some of our judges can give us some thoughts about how they do it. But if that isn't fact-finding, what is?
I don't think it's fact-finding.
How come?
Because I think fact-finding is saying A or B, this happened or this didn't. When these reviews are being conducted, and I think there's a little bit of selection bias in the case law, correct? Because the cases where there's the credibility, actually, in a criminal case, is just a little bit down here, the state's going to lose. That's been my experience in 20 years as a prosecutor. The state's going to lose those, right? The appellate judges never see them. Number one, so we're getting a selection bias, and we are getting so it's not fact finding. Well, here the example.
Yeah, you're right. It's one step removed from fact finding.
It's not what we want to say is fact. Do I have to say yes or no to this? What I think Judge Gallagher did in Riello and explained very well what Tompkins was talking about, I think, because I've read it 50 times before trying to get up and talk about it, was you're looking at the case and whether it makes sense and whether it does that. I mean, they reversed the manifest weight on a case where the victim testified that the sexual assault occurred. They didn't just say, oh, she said it happened, so therefore it did. So they looked at the credibility, not of her. In fact, they believed her.
Well, the point here is that the individual subjective assessment of each judge on the panel about whether the remaining evidence is enough to sustain the conviction, whether you want to, I mean, it's certainly not fact-finding the way the jury does. I agree it's not A versus B, but you still have to look at all of these facts and decide for yourself whether you feel like the jury was just going to convict anyway beyond a reasonable doubt. You have to understand, appreciate, evaluate, and prioritize the facts that are in the record in order to do that. All right, I'm going to run out of time if I don't keep it moving, I'm sorry. So that takes care of prejudice and harmless error review. Let's look at another one on that side. Rocket was a space engineer for Space Z. She discovered a way to cut the cost of rocket launches by half. At that point, she announced her resignation from Space Z and immediately went to work for Space Z's biggest competitor, Starfleet. Space Z sued Rocket to enforce a non-competition provision of her employment contract and sought a preliminary injunction to stop her from working. The parties agreed that the biggest question for purposes of the injunction was the likelihood of irreparable harm in the absence of the injunction. The trial court denied the motion, explaining it was not convinced that money damages would be inadequate to protect Space Z's interest. So, we have a preliminary injunction, and we have a standard of review. This is just randomly out of the 12th district, but the case law is pretty consistent about this. The preliminary injunctions are reviewed for abuse of discretion, which may be found where a trial court relies on clearly erroneous findings of fact. I'm going to stop there for a second, and I think you alluded to this as well. Clearly erroneous is not a standard that we see anywhere in the Ohio rules. It is a federal concept. It is the standard by which federal appellate courts review factual findings by judges for clear error. There is no clear error provision in any of our source materials, but you still see that it got imported into Ohio law because it is so entrenched in federal law. Judge Claire Dickinson, formerly of the 9th District, who at one point wrote a decision using the phrase clear error, then wrote another decision apologizing to the world for doing so because there is no clear error review in Ohio. Instead, the clearly erroneous standard of review equates to the civil manifest weight of the evidence standard. So said the Supreme Court in State versus Wilson. Now, the problem here, because State versus Wilson was decided in 2007 before Eastman versus Volke, and Eastman versus Volke confirms that there is no difference between civil manifest weight and criminal manifest weight. So the Wilson decision is, woefully outdated in that respect, but it is still good law on this concept that when an appellate court reviews facts, whether it's a jury or a judge who decided those facts, that review is done under manifest weight, which is what we in Ohio essentially call clear error. And so, for abuse of discussion review, where you've got facts that need to be reviewed as part of the analysis, I stuck that in between 1 and 2 actually, because it really turns out to be just another manifestation of manifest weight. All right? And that concludes the fact finding that appellate courts do with the Rule 9 record. Now, I want to show you some things on the other side. Factual findings made from items added to the record. This is, I think, where the agita starts to happen. I can envision someone misinterpreting this presentation and attaching all kinds of affidavits and additional evidence to appellate briefs. Judge Will does not want to see that happen, and I don't blame her. But there are times when giving new evidence to the Court of Appeals is actually okay. So when are those moments? Let's take a look at a new example 3, since we made example 1A. Sharon Holder, who owned a single share of Hydrocon, fertilizer manufacturer, brought a derivative action under Rule 23.1 against Hydrocon and its officers and directors seeking to block a merger that Hydrocon had announced with AgroCrop. The trial court dismissed the action. Holder appealed the day before oral argument. So it's not in the record. The day before oral argument, the Hydrocon AgroCorp, take out the my mistake, publicly announced that its merger was consummated. But Holder thinks there are still steps, such as due diligence, that have yet to be concluded. So the merger itself, she says, is not yet complete. Under Ohio law, when something happens that makes it impossible for a court to grant the requested relief, a case becomes moot. Now, Sharon Holder doesn't think her case is moot because she thinks that there is still an unconsummated merger, notwithstanding the press release from the day before oral argument. AgroCorp and whatever the other company was, Hydrocon, they say it was complete and that this lawsuit has no further ability to afford relief because you can't unring this bell, the merger's been consummated. Court of Appeals, you need to dismiss the appeal because you cannot decide an advisory case. There's no longer a controversy here. What happens? What happens? There is a fact to be found. And that fact is whether or not it's too late to stop this merger. What happens? When pending an appeal from the judgment of the lower court without any fault of the defendant, an event occurs which makes it impossible for this court, if it should decide the case in favor of the plaintiff, to grant him any effectual relief whatever, the court will not proceed to formal judgment but will dismiss the appeal. And Such a fact, when not appearing on the record, may be proved by extrinsic evidence. So, when you are asking a court of appeals to dismiss a case because you think it's moot, and mootness can take many, many, many forms, right? It's moot if there's no relief the court can provide. It's moot if a tenant appeals a move out from a forcible entry and detainer action because you can't give the move out's already occurred. It's moot if a mortgagor, if a mortgagor loses the home in foreclosure and the sale has occurred. It's moot. It's moot if you pay the other side a money judgment and satisfy it fully. It's moot. And if you don't obtain a supersedeas bond and a stay, and the other side executes on a money judgment successfully and satisfies the judgment against your desires, it's moot. Those are just a handful of things that can cause an appeal to become moot. And when the fact that renders an appeal moot is a fact that is not in the record, the only way to advise the court about that fact is with new evidence. An affidavit, maybe authenticating exhibits if they're pertinent to it. I don't know, what else would you want to see?
Death certificate?
Death certificate? Death certificate, yeah, death moots a case, yep. Although there is a rule for that. There's a suggestion of death rule that specifically authorizes that one. But yes, it's a fact not in the record. So the idea here is that there are moments, and mootness is probably key among them, when even though a fact isn't in the record, it can still be dispositive of the appeal. And so that is ultimately what Sharon Holder and Hydrocon and Agricop are going to have to figure out how to do. How to place before the appellate court evidence that will enable the appellate court to make a determination one way or the other about whether this can be undone, which is the sine qua non of not being. All right. So assessing mootness is a moment when factual findings are made from items that get added to the record. Example 4. Gerrymander held the position of official Ohio district redrawer. After years of unsuccessful attempts at redistricting, the General Assembly conferred on Mander the sole and exclusive control to determine political districts in the state subject to statutory procedural requirements, one of which was to publish proposed redistricting plans 6 months before promulgation and to respond publicly to any comments submitted by citizens within 30 days of publication. Karen submitted an objection, and Mander ignored it. Karen sued to force Mander to respond publicly, and he countered that the objection was late, meaning not submitted within the 30-day statutory time. So what would you, if you represented Karen, what would you do? What kind of suit would you bring? Mandamus, right? Mandamus, one of the original actions, one of the writs. Mandamus is a remedy that lies when someone has a clear legal duty to do something and has refused to do it, and there is no adequate remedy in the ordinary course of the law. Right? Mandamus gets filed in the Court of Common Pleas, right?
No.
Gets filed in municipal court, right?
No.
Gets filed in the Supreme Court, right?
Yeah.
Yes, it can. And it also can get filed in the Court of Appeals. That's, by the way, an interesting strategic issue that I have never figured out, and maybe those of you who do original actions have a better sense of this than I do. But if you file an original action in the Court of Appeals, then you have an automatic right of appeal to the Supreme Court. I think we heard something about that earlier today. Not a discretionary appeal. If you file in an appellate court, that's the appellate court is the first court then the Supreme Court serves as an appellate court and you don't have to petition to get in, it's automatic. So what's the advantage in filing an appellate court if it's appealable to the Supreme Court automatically versus just starting in the Supreme Court to begin with? And I get it, there are lots of political calculations that affect that, and perhaps also the possibility that the leverage of an appellate decision might get somewhere even without going to the Supreme Court. But it's never really been clear to me what when you file an original action, how you pick which court to go to. Although maybe starting in 2025 we'll have an easier time deciding. Yes, mandamus is the action here, and it is brought in the Court of Appeals or in the Supreme Court of Ohio. Anybody know what this is?
Our main court.
Everybody know what this is? Yeah. This is the main courtroom in the 8th District Court of Appeals, from which I believe Chief Justice O'Connor filmed her advertisement that we were all seeing in the days leading up to the election. And by the way, if you haven't been to, what's the number on the first floor that was redone?
Courtroom 3.
3 is beautiful now. It's beautiful. So if you have any pull with the court, try to get courtroom 3 or the main courtroom rather than that dinky little. Anyway, you recognize this room, and if you recognize this room, you probably know what that is.
Judge's bench. That's the judge's benches?
It is the judge's bench. Very good. What's that?
That's where the parties sit.
That's a council table. What's that? Bailiffs. Gilmore, Mr. Wright, the court staff that sits there and calls the case and so forth. What's that? Wow, you guys are good. How can you be upset about the notion of fact-finding and appeal when the main courtroom of the 8th District Court of Appeals has a witness stand, right? How often does it get used?
Once every 2 years.
Once every couple of years. Now, the fact of the matter is that when you file an original action, there are, especially at the Supreme Court, and often at appellate courts too, magistrates who do the initial fact-finding, and magistrates do have the same authority to handle appellate matters under Civil Rule 53 as they do in civil and juvenile and criminal courts. So some of that fact-finding is delegated to magistrates in the first instance, at least, in some of the appellate districts and at the Supreme Court level. But there is a courtroom set up for taking testimony, and I've actually, Judge Roby said one time you had to do it, and was it just 3 judges on the bench?
Judge Mays left, but it was a bond. You know
what I
mean? Because you can have bond hearings there. With
Okay, all right. So it wasn't an original action.
Yeah, it's 3 judges up there.
Okay. Judge Mary J. Trapp of the 11th District, a year or two ago, they had a really complicated, major original action and days and days and days of testimony. She started to tell me what it was about, and my eyes glazed over very quickly, so which is probably the case in many original actions, by the way. Just seeing state ex-rel makes me kind of like want to go. So the interesting thing about this seat, it doesn't look a whole lot like a witness stand when you blow it up and reduce the, what do you call that? The resolution. What does it look like?
Look, a chair. A chair.
A chair? Anyone more imaginative? No, you're imaginative. I didn't mean to suggest it. I can't hear what?
It's a Pac-Man ghost. It's like a ghost from the video game Pac-Man.
Yeah, Pac-Man ghost.
I'll show you what it is. Let's first put original actions over here where they go. It's Mufasa! And so, from full circle with the Lion King, Mufasa. Actually, that's grown-up Simba, not Mufasa. And that is the antidote, by the way, to the appellate judge who is not too happy about your attempt to argue facts or introduce facts. Obviously, if it is a direct appeal and there are no issues of mootness and so forth, the only potential factual arguments that you're likely to make are either the manifest weight argument or the harmless error argument, maybe a fact related to a discretionary ruling. But the idea is that, and sort of the larger point for me here, and I actually am very grateful to the court for not only the chance to talk to you about this, but also for the chance to think about the reaction that the topic first engendered, because this is in fact, not the facts on appeal thing, but when you suggest to people something that runs counter to their intuition about what they do or what the courts do or what the legal profession should do, you sometimes run into established reluctance to veer from our canons of what we think the law, how the law works. And so there is a canon that, trial courts find facts, appellate courts look at the law. And generally that's true. But it's important to push beyond the limits of those canons when the law permits it, not when it doesn't. Because if you don't, then you are framing your arguments and you're putting yourself in a smaller hole than you really need to. My point here is that there are many opportunities, whether it's from the existing record or in the instances when you can add to it, to make factual arguments. And I think if you read the best briefs that are out there, even when it's not a manifest weight issue, the facts are so important in persuading the judges on legal questions that if you're not really using those facts to your advantage, then you're missing opportunities even where the issue in your case is not a question of whether the fact was right or wrong. So I'm 5 minutes early and I apologize for not giving you the full hour of time, but yeah, I'm happy to take some questions. Yeah, hey, Maria.
Hey, how are you? A little bit different than your presentation, but in terms of the facts and the record and things like that, if you're on the other end of it, you've got say it's the appellee arguing things that aren't in the record, told that could have been. What is the, and say you didn't reserve any rebuttal time or you have very little rebuttal time. Sometimes the bench runs you out, right? So say you've got, 30 seconds rebuttal time. What do you do in terms of new facts or that kind of argument? Someone comes up, it's totally outside of the brief.
So you're absolutely right. You're coming at it from more of the perspective that most people tend to think about litigation. And so the first thing about that I would say is that you will have, by definition, a very receptive panel of judges to whatever you're able to say in the time that you have, because if you give them the notion that there are facts being described that are not in the record, there's no more winning argument than that. So the question really is about, in the short time that you have, how to collect whatever facts you heard and whether even to try to go through them all, which you might not have time to do, or whether to simply say, 50% of the facts that we heard from the other side are not in the record. I don't have time to explain to you which ones they are and why they're not true, but it's really important that we decide this case based on the facts that are in the record. Here are the ones that matter that are in the record. We should admit something like that. But correct me if I'm wrong, I've never been an appellate judge, but I would imagine if somebody started in an oral argument explaining to you that the facts that you're hearing from one of the oralists aren't in the record, that would be an immediate eyebrow raiser.
Usually stop.
Yeah.
You talked about Morris and this burden shifting situation. With Morris, with the burden shifting, is there something similar in the civil world where the burden shifts if the plaintiff still has, they've got the preponderance of the evidence?
Actually, no, there's not. The appellant, unless you're operating under some other presumption in the law, the appellant always has the burden of demonstrating that the error was prejudicial in a civil case. But you did remind me of something that I forgot to mention. And that is that the Morris decision that says there's this harmless beyond a reasonable doubt burden on the state In Ohio, that is true of evidentiary errors as in Morris, and probably many trial errors that can occur. But it is not true in the federal system. In the federal system, there's a case called Chapman, which makes clear that constitutional errors that occur in a federal trial are subject to the same standard, harmless beyond a reasonable doubt. But evidentiary errors that occur in federal court in a criminal trial, even if they're preserved, it's still the appellant's burden to show the prejudice. And so Morris actually, I think it was Justice Lanzinger at the time, who basically said, we don't have a distinction in Ohio between constitutional and non-constitutional errors, so we are going to apply the harmless beyond a reasonable doubt standard to everything in criminal cases.
During your presentation, you went through many examples showing how it's appropriate in certain specific examples of when an appellate court can fact find. Are you suggesting that that should be taken a next step and appellate courts should just generally second guess a jury as a matter of course, as in addition to those specific limited situations that you went through?
So I gave a presentation 2 years ago at this seminar, and yes, I do think that the degree to which our legal system, the criminal justice system, is infected by wrongful convictions that are themselves the product of implicit bias, that there should be a greater role for appellate courts when there is something going on that smells funny, even if you can't put your finger on it, to say it's just got to be tried again. It's another conversation that's very controversial. I gave it a couple of years ago, but yes, I do think that's not the extension of this. That's a separate topic because it's very specific to the criminal justice system and to wrongful convictions because of the disproportionate way in which people of color are convicted.
Going back to your fact finding in civil cases, I mean, when you go to the motion for summary judgments, we often see that proper 56 evidence isn't attached to the briefs down below, but yet maybe a trial judge used it in its analysis, but then when it comes to us, it is improper evidence. So now we have to, I hate using the word fact find, but now we have to decide how does it affect that ruling on that summary judgment?
Yeah,
with the standards of viewing the evidence in the most favorable light.
The easy way out for you on that might be that I think if you don't object to the admissibility of summary judgment evidence at trial and the judge then relies on it, that it's forfeited for appeal.
What about in the summary judgment realm in the trial court level? Did they need to object to it below?
That's what I mean, yeah. Like if you file for summary judgment and you attach unauthenticated documents, for example, I'm fairly sure that unless the other side objects to the unauthenticated documents, that they are then part of the record that you can consider for appeal. In other words, that the impropriety was forfeited, I think.
Thank you very much for your presentation. It's far above my head because I don't practice in appellate court very often. But one of the things that I thought about when you talked about implicit bias is the Mumia Abu Jamal case that went on for decades, actually. And I had a tiny role in the appellate part of his, when it was remanded back to the same judge who made some really pretty egregious errors. If it comes back to the same judge, where is the justice that, I mean, does it go bounce up again to the appellate court?
Well, if there's error, certainly somebody can try. Some jurisdictions automatically assign a new trial judge to a remanded case. Ohio has never done that, as far as I know. Nice for the successful appellate not to have to kind of walk with the tail between the legs when you go to the first case management conference or whatever else.
So I have a matter where someone's appealing a denial of a motion for sanctions. And they, after the ruling came down, they ordered transcripts of hearings that were held back in 2021 and 2022. And they want to make that part of the record to argue that the
trial judge abused their discretion in denying the motion. And it sounds to me like that, given when these hearings took place, they weren't cited or ordered prior to.
From the same action?
It's from the same action.
Well, if they're from the same action and they were ordered, for purposes of appeal, they're in the record. The question is whether they have any bearing on the issue.
Right. They weren't provided, though. They weren't provided to the trial judge to consider when they filed their motion.
I don't think that's a problem for putting it in the record.
Okay.
You'll have to kind of doodle about the level of attention that work gives to it.
Okay.
In the record, they can be argued from. Thank you very much.
I mean, and it says it's working, but like, it won't work.
Okay, I don't think we're on a break. Good afternoon. I wish I had my gavel. I am Michael Ryan, and I have the privilege to be one of the 12 judges that serve on what I believe one of the best benches in the state, if not the country, and that's the 8th District Court of Appeals, which just happens to be today's sponsor of this sensational seminar. I'm the junior judge, which means that I have the least amount of seniority, and also means that I go last speaking. I go last when it's terms and when it's time to vote. And of course, now you see I go last in terms of introducing the facilitator to speak at our last session. Yes, I do make the deciding vote at times. The subject is very interesting, relevant, and vital to the human sustainability in the legal profession. AI is integral to progression in most areas of our lives. But what, if any, parameters exist regarding its use in the legal field have not been established or aren't widely known? Well, here we have today D. Alan Asbury from the Ohio Board of Professional Conduct, and he's here to educate us about those parameters. Mr. Asbury liked Capital University so much that after receiving his undergraduate degree, he stayed and got his JD. He practiced in the areas of personal injury defense as well as labor and employment matters before taking his talents to the Ohio Supreme Court as the administrative counsel. He moved on from the court, and that's with a capital C, but not the building, and now on behalf of the board does research, drafts, advisory opinions, and assists judges and attorneys who seek guidance about the applicability of certain actions to the judicial and professional codes of conduct to help them avoid placing their licenses in jeopardy. Without further ado, I present D. Alan Asbury for the session titled Artificial Intelligence and Legal Ethics. Mr. Asbury.
Trying to figure out how to use this before I get started. Is there a clicker per se?
It's going to be the right arrow key to advance. I'll take you back to it.
You're right. Well, good afternoon, judges, attorneys to practice in the 8th District. It's an honor to be here. I think we get invited every couple of years to the 8th District. I'm going to apologize right away. My voice I lost earlier this week. It's coming back, so I apologize for the frog in my throat. But today we're going to spend the next 45, 50 minutes talking about artificial intelligence, its impact on the legal profession, its potential impact on our legal institutions, We're going to take a deeper dive into the rules of conduct for both attorneys and judges that are likely implicated and impacted by artificial intelligence. Right now, there are only 8 jurisdictions that have written advisory opinions on this topic, so some of this is somewhat theoretical, but I think Rick, Dove, and I have applied our rules to the current technology and found those rules that are likely the most important to know. So if you've been paying attention over the last several years, you know that artificial intelligence is having a tremendous impact on our economy and on our society. There are a number of industries that are implementing artificial intelligence in their workflow, as well as in the products that they produce. Entertainment comes to mind, finance, the medical field, the weaponry. All of those industries are quickly changing their workflow and products to implement and engage in AI. And I think we would be naive to think that somehow the legal profession and our judiciary is somewhat going to be immune from the changes that we're seeing in the rest of society. I think a lot of people are sounding the alarm that there's a revolution that's going to occur in the legal profession. I don't agree with that. I think it's going to be more of a slow evolution, but ultimately everyone in this room, if they continue to stay on the bench or in practice, will probably encounter artificial intelligence either in their own practices or through opposing counsel. And so I think right now at this stage in 2024, we're really looking at AI as an opportunity rather than a threat. But I don't think we can ignore the quote from Richard Susskind that's on the screen. And he points out that the changes that are coming for the legal profession and for the judiciary ultimately are going to require radical changes in less than 20 years that exceed those changes that the legal profession has implemented over the last 200 years. Just put that in perspective. We've already seen a significant amount of changes so far. So if there's one takeaway today from the presentation, I want to assure everyone in this room that you are not going to be replaced by artificial intelligence. I think the key here is to maintain our independent professional judgment, our independent judicial judgment, which is a phrase I sort of coined for these presentations. And we're going to ensure by implementing those 2 standards that we will still have a role in the legal systems of tomorrow. So if you haven't done any, if you've been living under a rock, artificial intelligence is essentially the simulation of human intelligence. It can reason, it can problem solve, it learns, and it can make some basic decisions. And it does that by taking large data sets that it's either given or it has access to recognize patterns between words and phrases and other information that it has access to. So many of us have already been using artificial intelligence, whether we knew it or not. If you have Netflix, if you're on Facebook, if you use Alexa or Siri, or even Google Maps, there are facets of those tools that do use some form of artificial intelligence. But those are fairly basic. What's happened in the last 5 years is the advent of generative AI, which can create new content. And again, it does that by going out to the data sets, including everything that's available on the World Wide Web, pretty much anything that's digitized, and creating new content. It can create text, movies, video, images, and computer code. The way that artificial intelligence or generative AI works is the use of a large language model. Large language models are a form of deep learning that use transformative architecture that can process and generate human-like text. The architecture is made up of neural networks that are similar to how our brains work, and it's able, again, to learn the relationship between words and phrases without me creating any code, computer code, to tell it what those words and phrases mean. So for example, if I use the word bat in a couple of different contexts, I don't have to write computer code to tell it that there's a difference of the meaning of the word bat in the sentence, I swung the bat, versus the bat flew through the air. It is able to find out and learn on its own that there are 2 different meanings in those 2 sentences. Most of the tools that are available online today, and some of you may already have started using these tools, and all those tools that are available for purchase are using some form of generative AI. And I guess I should have asked at the beginning, can I just see a show of hands of those practicing attorneys that are using artificial intelligence tools in their practice? This is Vegas rules, so don't be shy. Okay. That's about the same. We've given this presentation 3 or 4 times this year, and that's about the same percentage I'm seeing across the state. But to sort of explain even more in a visual manner how generative AI works, again, on the left-hand side, it's got text training data. Again, all of the data sets that it has available to it, including all of the data on the web, regardless of whether or not it's in English, French, or Spanish. It can translate that very quickly. Again, everything that's been digitized, including all of the decisional case law in this country. It's available for free on like fine law and case text, I think is the other format. It also is able to look at all of the images that it comes across and describe those images in text. And then it takes that data set along with the questions and prompts that we ask it and learns from that and is able to produce pretty much answers to any questions that you might have. In my pocket right now is the paid version of ChatGPT 4.0 that if I want to, I can engage in a conversation through audio with it. If you're really lonely, it's a great tool to use to engage in a conversation about any topic you have in mind, about what's going on in your life, etc. Not that I do that. Obviously, one of the great benefits of AI is information summarization. It can take large amounts of text. I was talking to Judge Boyle last month. It can take entire transcripts of hearings and summarize those hearings. We're talking something beyond just the index that's already usually in there from the court reporter, but it will actually summarize, give you the key points, the highlights, the low points, etc. Also, it can do planning for you. One neat feature which I have used is to plan an itinerary for a trip. For example, if you wanted to go to Europe for 2 weeks and you want to hit these countries on these days and these certain tourist locations, it will give you a day-by-day, hour-by-hour breakdown of how to do that. It also can obviously translate any languages. So what are the downsides? Well, with any new technology, you're going to run into some early problems, especially if you're an early adopter. What you will find, especially on the free sites like ChatGPT, Gemini, and Claude, is the sources that AI is finding or using to give you an answer to your prompt aren't being revealed. So you really don't know what the sources are. The paid versions of these tools will give you an idea of where they're looking for information, but most of the time it does not. It can also be difficult to determine whether any of the sources contain biases or prejudices. And that's a number one problem that the ABA has picked up on, that as we begin to rely on AI, it's looking at data sets that have been created by humans. So opinions, editorials, law review articles, statistics that may have a particular bent or are skewed for a particular result. Your AI prompt is just going to reflect and mimic what the AI was able to find in those human-based data sets. The last problem is hallucinations, and you've probably heard about this in the media. We'll talk about a couple cases involving lawyers that fell into this trap, but AI is doing the best it can. It's not perfect, and it will from time to time hallucinate results because it believes, based on the patterns it's seen before and how it's learned those patterns, that this case citation or this proposition of law must be accurate based upon what the AI tool is looking for. And so some attorneys have submitted briefs and motions that contain cases that never existed. The reporter citations are something that even a first-year law student would realize. This is not a reporter. The propositions of law that are cited are completely made up. And so there is some danger. So what's next? We started talking about AI in terms of ethics last December. And things have already begun to move very quickly on the technology front. ChatGPT, Gemini, Claude, they're progressing and changing every month. They're getting better, they're getting faster. But the next thing on the horizon is something that OpenAI, which was created by Elon Musk, which is now a for-profit venture that created ChatGPT, has come up with a platform called Strawberry. And Strawberry is doing things that, quite frankly, the technologists and computer scientists don't understand how it's doing it. That's a little scary and unnerving, but it's able to reason on almost a human level. And it's doing that by planning out how it will answer your question rather than just having a gut reaction to your prompt. It's planning out how to resolve a problem without any human intervention. So that's kind of a backdrop of artificial intelligence if you haven't been paying attention. But in terms of the future impact on the legal profession, there was a seminar the National Center for State Courts held in August. They're holding one about every month now on artificial intelligence. But the technologists that were on that particular seminar said, without a doubt, AI is right now too powerful for lawyers not to use. And last year, ChatGPT was able to pass the uniform bar exam in the 90th percentile. It's expected it'll do even better next year, which is a little scary. I don't know how they give the test to AI, but it was able to do it. Goldman Sachs, which obviously studies a lot of the industries throughout the country for financial analysis, has figured out that 44% of the very basic tasks that we do as attorneys can now today be done by AI. When you look at surveys of how many lawyers and law firms are using AI, those numbers vary. Basically, it's about 10 to 20% of firms, small firms, are using AI in some fashion. The larger law firms, the big law in this country, are using it at a rate of almost 90%, mainly for e-discovery and document review. So another thing that those technologists in the seminar came up with, and I think this is true having played around with some of these tools, is that the competence level is now of that of an intern or even a junior associate in a law firm. And I spoke to a Court of Appeals judge yesterday. I won't name the judge or the court, but he's been using AI tools kind of on an experimental level, and he's quite impressed by what it can generate in terms of what he usually sees filed in the forms of briefs in his court. Right now, law schools are implementing AI use as a key skill. The law schools have figured out, in order for this new group of lawyers who are going to be taking the bar in the next couple of years, when they enter the workforce, they are going to need to know how to use some of the more basic and common AI tools. Also, right now, in most industries, you're not being judged on the work product of others. You're being judged on your own work performance. But eventually, every industry, including law, you'll be judged not only on your work performance, but on how well you use AI in that work performance. So for example, if it normally took you 50 hours to put together a standard estate planning package for a client, and that could be done in 5 hours through AI, clients are going to begin to wonder why they're spending as much money with you if they could go down the street and get it done for less. And the same seminar pointed out within 5 years, every lawyer will either need or will acquire an AI assistant. And that could be in the form of what we see now that's available online. It could be in the form of what Microsoft has just issued, where all of their laptops have an AI assistant running in the background, making recommendations, letting you know that last month you wrote a memo on this particular topic that could fit into the new memo you're working on or the new brief. Constantly working in the background, keeping track of all of your emails, all of your text, and being able to essentially serve you. So that's kind of the overview of the impact on the profession, and why I bring that up is when it comes to the judicial branch, eventually the branch will have to react to what lawyers are doing and what lawyers are using. We'll talk in a few minutes about what tools are available for judges and the judicial branch to use. But in the next amount of time we have left, we're going to look at the ethics rules that I think apply commonly to both judges and lawyers, as well as specific rules that apply to both. So the first and probably most obvious rule is that of competence. Both lawyers and judges have to maintain a certain level of competence when performing their tasks. Every lawyer in the room remembers Rule 1.1 from law school. Competence requires the legal skill, knowledge, thoroughness, and preparation necessary to carry out a representation. And several years ago, the Ohio Supreme Court adopted a comment to that rule that was, of course, put forth by the ABA that gave a definition that really pertained to technology and said attorneys have to remain abreast or keep abreast of the relevant technology. And I think it's safe today in 2024 to say that AI is relevant technology right now. That comment does not mean you have to use the technology, but you at least need to be aware of how it works and how it's available. So that means you have to make sure you know the advantages and disadvantages of using that technology, whether or not you use it. Why? Because your opposing counsel are probably using it. If you are going to implement or utilize AI in your practice, you need to be sure you know how it works. A lot of mistakes can be made if you're not aware of how that technology works and its limitations. You need to make sure that the work product that's being generated is coherent, defensible, and consistent with sound legal knowledge, which we'll see in a couple minutes is not always the case. And if you have a misunderstanding of how the AI is able to help you, over-reliance on it can lead to some dangerous or negative results. So one question I've been asked in several different quarters, including Supreme Court justices, is are we at the point where refusal to use AI rises to a level of a question about competence? I don't think we're there yet. I think it's potentially accurate that we will reach that stage at some point. And the analogy I will use is the technology of email. If you remember, and you're old enough to remember, when email became more popular and was used more frequently, all of the bars across the country immediately wrote advisory opinions warning attorneys about the dangers of using email and the dangers of confidentiality, and they were really sort of holding back from saying, yes, you need to use email. But I can point to a number of cases that we see before the board where an attorney's failure to use email to communicate with a client, not following up with email, not being able to use the e-filing portal for whatever court, those are technologies that today we would say that your inability to use those can give rise to a rule violation, at least of Rule 1.1, if not more of rule violations. 20 years ago, we probably wouldn't have said that. So for judges, they also have a duty of competence. Rule 2.5 points that out. And comment 1 to that rule also addresses the same definition for competence that lawyers have. And so as AI tools are being integrated into the judicial system over time, and I don't think we're anywhere near that, judges, like lawyers, need to have a sufficient understanding of how those tools work. And if they decide to start implementing or integrating those into their judicial workflow, they need to be aware of the advantages, disadvantages, and risks. I think more importantly today, though, judges need to be aware of what are the lawyers using. Are they submitting briefs in the appellate courts? Are they submitting motions and pleadings in the trial courts that are based on AI, that have used AI? I think you have to have a good understanding of that and be wary of what's submitted. There are a number of courts already in Ohio that have either issued standing orders or local rules about AI. Several federal courts have as well. And some of these courts have said, we don't want anything filed that was generated by artificial intelligence. And just my own personal opinion, I think that's a little bit of an overkill because if you start applying that standard, even your word processor is using artificial intelligence to some degree. So it's a question of where do you draw the line. So as the technology begins to increase for judges, I think so will the requirement to maintain competence about what's available, how it's used in their courtroom, and whether or not their adoption of that technology could have a negative effect on their overall decision making. So what are the available AI tools? For those of you who haven't explored this, there are a number of products already being pitched to attorneys, specifically in law firms, that can perform all the tasks that are currently on the screen. I will tell you that all the seminars I've attended virtually in the last 2 years are being run by, obviously, vendors that are pitching their product. So there's no shortage of that marketing and soliciting. But it can do all of the things that we see on the screen. There's one product that Thomson Reuters has ultimately acquired, that's Co-Counsel. I'm not making a pitch here, but for $250 a month, each attorney in your law firm can have this on their desktop. And it can do all of the things that are on the screen in front of you. The one thing I think is somewhat exciting is the ability to predict outcomes in a case, whether that is what would be the potential settlement value, what would be the potential damages if we go to trial, and more importantly, how will Judge Smith rule on this particular motion for summary judgment based upon their prior rulings? Or how have a certain panel of appellate judges ruled on these particular issues in the past? It can do this in less than 5 seconds. Can all of this be done now manually? Yes. Does it take a long time and effort? Absolutely. Are most attorneys willing to bill their clients for that sort of thing? Probably not. But those tools are already here. For judges, you have the same tools at your fingertips, especially with respect to legal research. How many of you are using Lexis or Westlaw right now in your practice? And how many are using the AI function in those tools? Yeah, both Lexis and Westlaw have adopted an AI version of their research tools. I've used them. They're good if you want sort of an idea of where to start. Are they capable of giving you everything you need to know to write a memo to a client or to write a motion or a brief? Absolutely not. Will they get there? I think so. It's just a matter of time. For judges, there's also the opportunity for tools that will conduct document review and analysis. So everything that's filed in a case, especially for trial judges, is available at your fingertips. You can organize it any way you want, but the advantage will be you can ask questions about what's been filed. You know, if you don't quite remember whether or not a particular piece of evidence was admitted, you can ask it, did we admit the evidence on this particular item that was found at the crime scene? It can do all of that, and it can analyze what's available in both terms of evidence and what the attorneys have filed in terms of pleadings, motions, and briefs. Obviously, it can translate for you. There's some caution that's been issued by our Bruno Romero at the Supreme Court. There's really no substitution right now for human live translation, but I think we'll get to a point at some point in the future whether or not we just allow AI to translate, especially for witnesses that don't speak English. Sentencing and risk assessment tools. I raised this at the Court of Appeals judges and seminar in the fall and learned something that Ohio does have a tool like this. It does use an algorithm. I think the University of Cincinnati helped adopt this particular tool. It's very good at what it does, but the tools I'm talking about here go way beyond just a basic algorithm. They're using artificial intelligence. Other countries and jurisdictions are using these outside of the United States to predict the risk assessment as well as the potential sentence for any particular defendant. Also, we already talked about summarization of cases. Those tools are there. My advice usually to judges, if you're going to use these tools, while the summaries are nice, obviously you and your staff should go back to the original documents if you're citing to those in any particular decision. And then there's the usual group of scheduling, calendaring tools that judges can use to sort of speed up the judicial efficiency by deciding we're going to have a status conference in this case instead of that case in order to keep the docket moving. So that's a quick overview of the tools that are available or will start to be available, especially for judges. So an example of an AI tool that I use occasionally is ChatGPT, and the prompt that I wrote is asking for a legal memorandum to discuss whether or not a business client has liability for a fall on the common area connected to their property. And I'm using these examples to show you the level of competence that you probably should have if you're going to use these tools. And I give it a little bit additional facts that the damages are probably in the range of $75,000 right now, but I do direct it to use Ohio decisional case law and jury verdicts when making a recommendation to the client. And I know this is fairly small, and the point isn't to look at the detail here, but it did a pretty nice job of outlining the seminal case law in Ohio about falls, especially with the accumulation of ice or snow. It does make a recommendation to the client that the potential jury verdict here could be 100 to 300,000, and potentially we need to look at a settlement in the range of 50 grand. This would be a first-year associate level memorandum, and that's probably about as good as I could write, even at my age, at this stage. So, yeah.
Can I just ask, was this ChatGPT
ChatGPT
that you
40,
used?
the paid version, yeah. Yes.
Where are they finding the jury verdict information?
Well, you're a step ahead of me. The competence level that has to be utilized here is, what are the sources that AI is using to come up with this recommendation? Where did it find the jury verdicts? Because the sources of those have, I think, dried up over the last several years, unless they're going into something like Westlaw or Lexis to find it. A lot of the bar associations, especially in Columbus, used to keep a running catalog of the jury verdicts and settlement values in the cases in Franklin County. Do you have a question?
Yeah, and maybe I just don't know how ChatGPT works, and I don't want to sound like one of the people who said like don't use email, but does this, all this information that you put in, does it go to OpenAI who like keeps it on a server? So like if I'm saying a bunch of work product and privilege information and I'm sending it to a server that's who knows where, which is I guess what I'm doing with email as well, but like it just seems scarier because it's thinking instead of merely storing.
Another good point, and our next section is confidentiality. But the paid version of ChatGPT is not keeping the prompt that I wrote, so no one else can learn from that prompt, and it's not keeping the work product that it generates. The free versions do keep everything. So that's the example of a legal memorandum. But what if I'm a judge, and we're going to get into caution. Some cautions for judges to observe. So this prompt is, and I have a typo here, the defendant has filed a motion for summary judgment arguing that there are no genuine issues of material fact that compose liability, consulting Ohio case law on the standard for summary judgment, draft a court decision granting summary judgment to the defendant in the case. Now the warning here is, in 2 sections from now, again, back to our independent judicial judgment, we shouldn't be using AI tools to make decisions. But that being said, if I've already made the decision I'm going to grant summary judgment, there's really no harm in sort of checking to see what's out there, especially on a novel subject. This obviously isn't novel. The case law has been pretty static in this area for the last 30 years, so I wouldn't expect any surprises. But again, ChatGPT generated this in about 6 seconds. It goes through the standard of review. It does cite Drescher versus Burt, which I didn't have to tell it, which is the case you see in almost every one of these summary judgment decisions. It breaks down the analysis of the case law in Ohio. It sort of hallucinates, I think, a little bit about what the damages are here and the facts. I didn't give it a lot, but it does come to a very well-reasoned conclusion that summary judgment should be had in this particular matter. So the purpose, again, of this is to show you, A, the power of the particular AI tools, but also the drawbacks, knowing what the sources are here. I don't know where they're finding the case citations. I don't know if they're accurate. I didn't review it. I don't know if the propositions of law that are cited are reflected by those cases per se, and that's something you would have to go back and do manually. So independent professional judgment and judicial decision-making, another common area here.
Can I stop you just one
Yes,
second?
Judge.
On your last screen, you know, the template of the, okay. Can the outside world see that I did that?
Not if you're using a paid product.
Okay.
Yeah. The danger, I'll just say this now, the danger of using the free products is AI is learning from the prompts that I wrote, because it may find out something I didn't know before. And it's going to store your prompt and the work product that it generated to be used in future questions and prompts that are asked. And that's the danger of using this if you're not using a paid product where the terms of service tell you we're not keeping anything, we're destroying everything. Westlaw and Lexis guarantee that they are not keeping anything that you write into their AI versions right now.
Can you, this is a question that I really hammered Lexis on, and I still didn't love the way they were describing the answer to me, because in the end, taking the information they were feeding to it while they themselves were not going to store it in any session, in any fashion.
Yeah.
Essentially changing. And it still gave me pause as to how they were able to control the flow of the information if it still has the fun of the chat. You understand that better than I did?
I don't. They are making these assurances that they're not keeping anything. How they prevent it from backflowing into the general chat GPT is probably way beyond my knowledge base. I think there's good reason, Judge, to be hesitant right now.
I'm not judging
Oh, I'm sorry, court administrator. I think there's a good reason to be hesitant right now. I will tell you at the Supreme Court, we have not purchased Lexis Plus or Lexis AI. There's some hesitancy with using that. We do, for some reason, have Westlaw AI version because of the concerns that you raise, quite frankly.
Do you anticipate that the Supreme Court could perhaps give future along reviews by courts of these terms?
Yes and no. We'll get to that too. If we weren't what I would call a home rule state, it might be easy. A couple states have issued essentially policy statements about what products courts can use, who can use them, what you can use them for, what training is required, and what information you can't put in, especially non-public information.
I have a question.
Yeah.
Recently, I was involved in reviewing, preparing actually the products in Westlaw and Lexis.
Oh, good.
And I won't say which side we fell on, if at all, but my worry and my concern in terms of ethics is not only what the output is, but where the resources are for the input, because I happen to know that DEI is still, ideas around DEI are still in their infancy stage in our country, and what we're doing is paying attention to some groups of people and not really paying attention to the others. So if we are not getting input from African Americans on the same level of effectiveness, and indigenous people and Asian folks and Latinx and Latina people, then we end up with a biased and skewed unintentional bias that's going to affect everything we do.
Yeah.
And AI just eats that up and uses it because that's what's available. So is there any attention at all being paid to that part of the AI thing before it gets to be the only thing we do? Because we know in our country, if it becomes easier, that's the way we do it. And so everything we get on our phones and on our emails, and if anyone else looks at email anymore, and our computers, they're all kind of pushing the idea of AI before it's ready. I mean, before that part is ready anyway.
I mean, we're at the early adoption stage, and I will use a video game analogy. If you ever played video games, we're at the level Pong right now. This technology will continue to advance and get better, and I think ultimately be able to weed out what is obviously biased data, opinions, and editorials that are relied upon by ChatGPT and others to generate results that don't reflect those biases. I know that may sound like science fiction now, but there are whole 2-hour seminars on AI.
I hate to push back on that, but we still have laws in our books that are based on enslavement.
Oh, I understand.
So, you go to some states like Maryland, there's still slave and master in their civil procedure. So I don't buy that we'll get rid of the stuff that turns out to be biased.
Well, I'm not sure we'll get rid of it because it's going to be, once it's on the internet, it's on the internet forever, right? But I think the AI tools will get better at determining, because it can do what is called sentiment analysis. It can read something and determine whether the writer is angry, whether the writer is empathetic, whether or not they want to be persuasive or argumentative. It's able to read and pick up those sort of cues. And there are whole seminars based on your point about how we need to use AI to ensure that it's not reflecting and enhancing or even magnifying the biases that are already contained in the data sets, laws, and rules that we have. So it's a point well taken. And I'm sure we'll develop a whole seminar on it here.
The question was, are we doing anything about that?
Are we?
Yes, or are we waiting for AI to fix itself?
I mean, there are elements of these companies that realize that this is a problem. I mean, I've read articles about it. It's a significant issue. The ABA is taking it very seriously. And all of their recent AI report that came out this summer spent a large part of their time working on this and talking about it. Good questions. So, where were we? Independent professional judgment. So, of course, lawyers have to exercise independent professional judgment, and that also means not relying entirely on AI to replace our judgment. We can use AI to enhance it or supplement it, but we should never rely on AI entirely to make a decision or to give advice to a particular client. And I think that's going to be easier said than done. And so at least one of the, I wouldn't call it an opinion necessarily, but the California Task Force report's the only one I've found right now that says absolutely attorneys should not delegate or abdicate their independent professional judgment to AI. And over-reliance on it can hinder the ability of the attorney to use their critical analytical skills to analyze issues and facts, as well as problems for clients. So in the context of AI, one of the things I've already talked about, a couple of these points, I think that's going to be important ethically is if you're using AI in your practice, number one, you probably should tell your client you're using it. And if you're using AI to assist you in making a recommendation about how to proceed in a case, you should let the client know how you're using AI and how AI came to give you that particular recommendation. And again, that's easier said than done because sometimes AI is not telling us the sources of how it came up with the answer to your prompt. So for judges, there is a responsibility to decide Rule 2.7, and it says a judge shall hear and decide matters assigned to them. It's very simple. The original reason for this rule is sort of the common law maxim that a judge has a duty to sit. When the judge is assigned to a case, he or she should hear it out. And the rule is really designed to prevent judges from coming up with frivolous reasons to avoid sitting on a case. Not because of some legitimate disqualification basis, because it's too complicated or it's not something that they like to actually work on or preside over. That's why the rule is in place. But a couple of judicial opinions have said this rule does have application in the context of AI. And the reason for that is pretty simple. Parties that come before judges have an expectation that the judge is actually going to decide their case. If the judge delegates the decision-making to someone else or something else, like AI, the problem is that that person no longer has really had an opportunity to be heard that's guaranteed by the Constitution. So for judges, the code expects you to use independent judgment again in reaching your decisions. It's a task that cannot be delegated or abdicated. There are transparency concerns if you're using AI entirely to reach decisions, and there are obvious due process concerns, as I mentioned earlier. There's one advisory opinion so far that points out very clearly that a judge should never use AI to reach a conclusion on the outcome of a case. And I think that's a principle in our American judiciary that will not change. But other countries are using AI to do exactly that, and we'll look at that in a minute. The permissible uses for judges when it comes to AI are on the screen. We've talked about a lot of these already. especially with regard to research and summarization of case documents. But what could go wrong if a judge used AI to reach the final decision in a case? Well, we do have an example out of Brazil last summer. Brazil has an entirely astronomical backlog of cases right now in the millions. And so the Brazilian government decided to contract with OpenAI. Thought this would be a great idea. Let's give them these tools to help get these decisions off the docket, or these cases off the docket. One judge, falling behind, decided, today I'm just going to push enter, and whatever spits out, that's the decision in the case. Never read it, didn't review it, filed it. The parties get it. Some other colleagues look at it and wonder, what the heck? None of the cases that are cited in support of his decision even existed. They were completely hallucinated by AI. Well, like the U.S., they have a judicial disciplinary system, and he was referred to that system and was ultimately sanctioned. So that's what can happen. But again, other countries are using AI almost entirely for their judges to make decisions. China is probably the biggest user. Every judge in that country is required to use AI when reaching a decision, and if they want to deviate from the AI-generated decision about the outcome in a civil case, damages, or the sentence of a particular defendant, they have to give a written reason why. And even that written reason why is subjected to an AI review. So, the good news in China, their workload has been reduced by a third since they've introduced the use of AI. So back to your question about, what can we do? Delaware and Utah last year issued very broad policies about AI use in their jurisdiction. So your presiding judge and probably the administrative judge in Ohio would have to decide who's going to be allowed to use it. Are the judges going to be allowed to use it? Are our staff attorneys going to be able to use it? Are they trained? Also, they have to basically agree they will not use the AI tool to reach any decision if they have any decision-making authority. And they cannot share non-public information in any of the tools through the use of questions or queries. So confidentiality, again, back to your point earlier, there's, I think, commonality in both for lawyers and judges with respect to confidentiality. Lawyers, you're familiar with Rule 1.6. In the context of AI, you should not be disclosing client-related information to an open AI tool like ChatGPT, with the caveat, unless you're using the paid version. The free versions of these tools are not guaranteeing, in fact, their TOS says, everything you write in as a prompt and everything we give you is our property. It's no longer yours. And we're going to keep it forever. And we're going to learn from it. And we're going to use the answers we gave you and the questions you gave us to answer future prompts of similar users. So the question for lawyers who are using any of these tools, is any of the information that I'm inputting into the prompt visible to the vendor or to third parties? And is anything that I'm getting back from AI or giving as a prompt being used to form questions or answers to questions that might inadvertently reveal the identity of my client? If you can't answer those questions with a resounding no, then you probably shouldn't be using that tool. Again, Westlaw and Lexis say that they're not using those prompts and the information they give you for any other purpose. They're destroying them after you use them. I can tell you from personal experience in Westlaw AI, once you get a result from them, you better copy it and paste it somewhere because you go back and it's gone. They're not storing it, to the best of my knowledge. But every attorney has an obligation when using any technology, especially cloud storage, and there are tons of opinions about this, to make sure the terms of service are very clear, because lawyers have an obligation when using non-lawyer assistants, which are also defined as third-party vendors, that they are also upholding the same obligations you have with respect to confidentiality. How easy is it to breach? How easy is it for me to retrieve it? Who owns it? These are all questions you should be asking when going into this area. So for judges, there's really 3 rules that touch on the same idea about confidentiality. Obviously, in Ohio, judges have to maintain a lot of information in terms of confidence as well as privacy. That could be through exceptions to the Public Records Act, the public access rules under the rules of superintendents, juvenile rules, and expungement and sealing of criminal dockets. That's all the type of information that has to be maintained by judges and probably should not be used or entered into a AI product unless you're absolutely certain that it's not going to share that information with anyone else. Judges also have an obligation not to reveal non-public information. Usually this is information that will eventually be disclosed, but for the time the case is pending cannot be. The rule also is really designed to prevent judges from using that information for their own economic advantage. But it clearly has application here as well. And then lastly, judges can't make statements in pending or impending cases. So while a case is being tried, if you're doing some basic research on a particular area of law that you need more information about, if you're starting to reveal how you may decide a case in that prompt, that could potentially become public information and could be construed as a statement in a pending case. In the time we have allotted, I'm going to advance here very quickly to the idea of, well, let me go back to candor to the tribunal, because I sort of promised this. Of course, lawyers can't knowingly make a false statement of law or fact to a tribunal, and they can't fail to correct it. And so that brings us to the question of using AI and then issuing pleadings or briefs that have case citations that are inaccurate. Citing to non-existent cases, citing to false quotes or false propositions of law is going to give rise to a violation of Rule 3.3A1. We've seen that in a number of other jurisdictions already in the last year. You may also run afoul of making a frivolous statement under Rule 3.3 that you would want to avoid. There are a number of cases that have been issued. These are just a sample of those cases. The Crable case is the only case so far that's resulted in actual discipline of an attorney. This attorney filed a motion to set aside a judgment. He had never written one, so he asked AI to produce it. Just hit enter, boom, spit it out. He didn't review it. He didn't check the case citations, but a couple of those case citations were absolutely inaccurate and completely fictitious. The court, of course, called him on it. He, in a hearing, admitted that those case citations were wrong. He admitted that he knew they were wrong after he'd already filed them, but hoped the court would not notice it. The court did, and he had the audacity to blame his law clerk for the misdeed. I'm sorry, let me find my place in my materials. The Mata versus Albianca case is probably the one that's gotten the most media attention. This is in New York federal court. It was an international law case. These attorneys did the same thing. They needed to file a motion basically in opposition or a memo in opposition. They'd never written one in this particular area of the law, which was international law. They did the same thing, asked AI to print out the motion or the memo in opposition. It did so. It contained a number of cases that had been hallucinated. They filed it. They didn't know that those cases were hallucinated. The court obviously picked these up. And I should point out, usually it's not opposing counsel that picks these up. It's the court and their staff. And so the court asked the attorneys, bring us the cases that are cited here. The attorney said, well, that shouldn't be a problem. I'm going to go back into ChatGPT and type in those cases to get the actual decisions. And AI somehow was able to print out something that looked or resembled a case decision. But as the judge pointed out, any reasonable attorney looking at these cases would know this is completely fiction. It's completely gibberish. It's making no sense at all. It's nonsensical. So the attorneys filed these cases. Still didn't check. But what one of the attorneys did was ask ChatGPT, are these decisions actually real cases that I can find elsewhere? And ChatGPT responded, yes. These are the same types of case decisions you can find in Westlaw and Lexis. So the attorneys were called on the carpet. They received Rule 11 sanctions and $5,000 fines. Yes?
So it might be helpful to understand, because it makes no sense to me whatsoever, how something that's smart enough to write isn't smart enough to know that it's hallucinating.
That it is hallucinating?
Yeah, I mean, if you're, what is it looking for when it says, yes, these exist? What is it finding?
That's a good question.
Maybe it's just lying. Maybe it's not hallucinating, maybe it's lying.
Well,
Maybe it's human enough to lie.
It's capable. It's not 100% accurate, which I should have said as a caveat, and it can make up answers from time to time. Sorry?
I understand that it can make up.
Yeah.
I just don't understand why it would.
I don't know either.
Doesn't know. There are things
I don't know either.
know.
And so the last case, Park v. Kim, the attorney did the same thing, filed a brief with a fictitious citation. The judge asked her to bring in the case. She couldn't because this ChatGPT version would not give her the case. So she admitted there was no case. She was referred ultimately to the disciplinary body of the Second Circuit. So I had a lot more. Obviously, we ran out of time. Is there any quick questions before we wrap up for the day?
I have one question
Sure.
about the paid for version versus the unpaid
Yeah.
version. And I understand the confidentiality aspect that the paid version says we're not, the paid version will say that we will destroy information, or as you said, Westlaw got rid of it right away. I guess the question is, doesn't ChatGPT and the AI programs learn from what is input? And so is there a danger of what's being input into the free version less accurate, but that's what it's learning from and that's what it's pulling from, and even under the paid version, that's what it's giving you? Do you understand where I'm going with that?
I do, and I'm not sure I can explain it well. My understanding is the results you get in the paid version are a lot better. It's faster, and I don't think they're learning from all the prompts that you're writing in the paid version. They're using other sources. What those are, I'm not sure. We have a lot of room for improvement. Let me put it that way.
What if a court were to use the paid services of Lexis or Westlaw for advisory bench memos to, cross-check against what our own drafting attorneys produce? Hey, what about this? You missed this. Are we at the level where we're comfortable? Are we at the level where we're comfortable giving that type of information for paid services?
Question is whether you can have the paid services generate bench memos that could ask, whether or not the staff attorneys have missed anything. I would be cautious about that right now.
I think if the answer about are these real cases and it said yes, it's gonna say yes.
Yeah, right.
Yeah.
You nailed it again. Good job.
Yes.
As a practice pointer, I run a civil practice, and we want to use the paid version of ChatGPT 4.0, I think it is, to summarize extensive medical records.
Yeah.
So as a practice pointer, we haven't done it yet, but it seems like, should we be putting that into our fee agreement, that we're going to utilize a service like ChatGPT to, for example, summarize medical records, deposition transcripts that are not yet in the public or the court record?
We didn't get to the question about whether or not you should communicate that to your client. I think the answer is yes. Whether or not you spell it out in writing or when you have your first sit down with the client, I think it should be communicated that you're using it. Writing, if you prefer it.
Well, have a client sign off.
And sign it, yeah. You may have clients that say, I would prefer you not use it, but you have to be open to and follow their directive. Well, thank you everyone for your attention.
Really,
I think Alan might have come the furthest. He drove in this afternoon from Columbus. So let's give him another round of applause. And that's so you can have a safe trip returning back to Columbus. You know, thank you, everybody. This has been a wonderful audience, very attentive. I think the presentations were fabulous. If there are things or subject matters you want to hear in the future, please let the 8th District Court of Appeals know. And if you want to volunteer, let the 8th District Court of Appeals know, too, that you would like to volunteer and present. With that, I heard the weather's really bad. So we're going to conclude today. We're after 4 o'clock. 6.25 hours of advanced appellate CLEs. Thank you very much.